Good morning and welcome. I'm Wendy Perdue, I'm the Dean here, and it is my great pleasure to welcome you here at the University of Richmond School of Law. A particular welcome to our alums who might be back here for this program. If you haven't been back for a while, you might find yourself a little disoriented in the building, that things are in different locations. This is in the same location, although we've upgraded the interior a lot, but it's wonderful to have you here. I want to extend a special thanks to the PILR, Public Interest Law Review, for putting on this symposium. It's such a timely and important topic, and I'm grateful for the work that they put into putting it together. It's a topic that's full of lots of misinformation, and having a law program that focuses on what the law is and what advocates can do is enormously important, and I'm really, really grateful to the journal for having put it all together. So let me turn things over to our symposium editor, Katie Hall, who will introduce the program.
Good morning, everyone. Thank you, Dean Perdue, and thank all of you for being here today. As stated, my name is Katie Hall, and I am a symposium editor for the Public Interest Law Review here at the School of Law. I have spent the past few months planning this event, and I am so excited to finally see it happen. Before going into my full welcome, I would like to thank a few people. First, I would like to thank Mary Ruth Keys with the Dean's Office for being an amazing resource and for doing so much for this event. Next, I would like to thank Carl Ham, the school's multimedia project manager, without whom we would not have any technology running today. You will see him popping in and out today and pressing a lot of buttons, most of which I do not know what they do. Finally, I would like to thank all the speakers and moderators for their exemplary work in putting together an amazing program. We are on the brink of what will be an exciting day of discourse surrounding pertinent issues of administrative, regulatory, and even constitutional law. This topic is so important not only to me and all of you, but to the American people. For years, the American public has feared the immigration crisis. Just a few days ago, we heard about immigration, asylum, and protective status in the vice presidential debate. Unfortunately, rhetoric surrounding immigration often turns to blaming immigrants for the broken nature of the system that they are in. This system is incredibly complex and incredibly overloaded. By speaking about it today and sharing the knowledge of how to best approach the challenges we and our clients will face, we are moving one step closer to bettering this system. I, for one, am honored to be a part of these discussions. Today, you will hear from experts in their field about their experiences in this constantly changing legal landscape. We will start with a presentation on the basics of immigration and asylum law to provide you with the background necessary for further presentations. Next, the School of Law's very own Professor McConnell, along with Tanishka Cruz and Daniel Bickett, will explain special immigrant juvenile status and the unique challenges immigrant youth face in the United States legal system. After a quick break, we will return to a panel discussion on recent changes in immigration law, where panelists will discuss the impacts of recent regulations, such as the Circumvention of Lawful Pathways Rule and the Family Expedited Removal Management Program. After lunch, you will hear from several practitioners in immigration law and outside of immigration law on how non-native English speakers face numerous barriers to justice in the legal system. Next, we will be honored to host a panel of immigration judges, including Judge Iji, Judge Baez, and Judge De Cardona. Daniel Malo from the Amica Center will then explain how the recent overhaul of Chevron impacts immigration practice. Finally, Sophia Gregg of the ACLU will present on the rights of migrants in detention facilities. These presentations are meant not only to teach you the skills and strategies necessary to better the practice of immigration law, but to encourage tough discussions about the current state of our world. I hope you all have a great day and enjoy this event as much as we enjoy hosting it for you. Now we will move to our first presentation, Immigration and Asylum 101. I'm going to turn it over to Professor Samuel Spiegel to introduce our presenters. Thank you.
Thank you, Katie, and good morning, everybody. I'm so glad you're here. As Katie said, I'm a member of the faculty here in the law school, and I'm really delighted to be able to introduce our first program and panelists this morning. I want to first thank the students of PILR for having assembled such a spectacular program and for the honor of having the opportunity to make this introduction. As Katie said, our first program today is Immigration and Asylum 101, and we're lucky to have with us two guests who will provide a general overview of immigration processes for recently arrived community members, as well as a brief update on asylum law at the border. Joining us today, to my right, are Roma Javed and Emily Lipinski, both of whom are immigration attorneys and advocates at LAJC, the Legal Aid Justice Center. I'd like to introduce Roma first. Her passion for immigrant and social justice is rooted in her life experiences as the daughter and granddaughter of Pakistani immigrants. At LAJC, she's legal director of the Immigrant Justice Program, and her work includes removal defense before the Executive Office of the Immigration Review, as well as federal court litigation related to criminal immigration, asylum law, due process and detention, derivative citizenship, and constitutional violations. Prior to joining LAJC, Roma served as managing attorney of Prisoners Legal Services in New York. She's a graduate of McMaster University in Hamilton, Ontario, and earned her JD from Case Western Reserve in Cleveland, where she worked in the Civil Rights, Human Rights, and Immigration Clinic. Emily Lipinski co-leads LAJC's Immigrant Justice Program's state-level policy initiatives and represents clients before immigration agencies, as well as the Fourth Circuit Court of Appeals. She also supports organizing campaigns such as ICE out of Arlington. Before joining LAJC, Emily clerked at both the Virginia Court of Appeals and the Arlington Circuit Court. And prior to law school, she established a DOJ-recognized immigration legal assistance program at a nonprofit in El Paso, Texas. Emily's a graduate of William & Mary, as well as this law school. And while she was here, she was heavily involved in pro bono casework and immigrants' rights initiatives. And one of the reasons that I'm feeling butterflies in my stomach is that it's a special joy for me to be able to introduce Emily, who's a former student and mentee and now a dear friend of mine. I asked the folks at PILR for the opportunity to be able to say that of all of the people I know on earth, Emily is perhaps the one with the clearest vision of what role she wants to play in the lives of her clients and the communities she serves. She also undoubtedly has one of the most generous and empathetic hearts I've ever known. It's really a pleasure to be able to celebrate her today and to be able to introduce to you both Emily and Roma as my esteemed colleagues. Please join me in thanking them for joining us today.
Thank you, Professor Samuel Siegel. Yes, really, really special to be here. Thank you all. Thank you to Katie and Nick and Emma and the rest of the PILR Symposium crew. We'll just go ahead and jump right in with our presentations. So today we're going to be doing an overview of asylum law. We're going to start with the definition of a refugee, which is very, very similar to the definition of an asylee with one tweak. Then we will give some legal background. So how did we get here as far as refugee law, and also how did we get here as far as immigration enforcement practices? And that will serve as context for when we explain the process for asylum seekers that arrive at the border and then pass their screening and then are released and come in contact with organizations like ours and are seeking asylum. So the end will be very nuts and bolts. What are some practical tips? What are things that asylum seekers need to keep in mind as they go through the immigration court processes? So I'll pass it over to Roma.
Thank you, Emily, and good morning, everyone. It's an absolute pleasure to be here today and talk to you all about the nuts and bolts of asylum law. My name is Roma Javed, and I'm the legal director of the Immigrant Justice Program at the Legal Aid Justice Center. Thank you so much for that kind introduction. I'll start us out with some definitions to frame our topic today. as Emily mentioned. So the definition of a refugee, what is a refugee? A refugee, if we can get to the slide, is someone who has been forced to flee their home country due to war, violence, persecution, and cross an international border to seek safety. Now, in the US, we're at the slide before. In the US, there are 3 legal pathways for refugees. Now, when the process begins abroad, it is called refugee resettlement, and that is an extensive, sort of approximately 2-year vetting process by which a non-citizen living abroad applies to seek residence in the United States, and that application is adjudicated and approved before they arrive here. Now, when the process begins here in the United States, it can happen one of 2 ways. When someone is present here in the United States and they are not charged with removability or in deportation or removal proceedings, they can file an asylum application affirmatively within 1 year of their entry into the United States. That's an affirmative asylum process, and that is a lengthy process that is less adversarial than the other option, which is the defensive asylum process, which occurs in removal proceedings where the government charges someone in the United States with removability, and their asylum claim is litigated through a series of hearings and proceedings called removal proceedings, which we'll talk through in more detail a little bit later in the presentation. So asylum is available to people that meet the definition of a refugee and are already in the United States seeking admission or are entering the United States at a port of entry. So the next slide goes through the definition of a refugee. The 3 most key pieces of this definition are that a refugee is someone who fears persecution in their home country, and persecution has a specific legal definition. That persecution is committed by the government of their home country or by an actor in their home country that their government is unwilling or unable to control, and that persecution is tied to a nexus or a protected ground. And those protected grounds can be race, religion, national origin, political opinion, or membership in a particular social group. These grounds are codified in the Immigration and Nationality Act, which is the Federal Code of Immigration Statutes and Definitions.
Yeah, and I just wanted to add, we're not going to go through each of these prongs, each of these and all the subcategories, and there's bars, and this gets very complicated very fast. We're just providing an overview of the basic definition of an asylee, refugee. Okay, jumping into the legal background, we thought this would be helpful. I'm going to try to multitask and also you do the clicker, or here, we'll let Roma do this. Maybe she can do it better than me. So asylum law is not that old. Refugee law is not that old. It started in the wake of World War II. Of course, people have been facing what we now call persecution, the legal definition of persecution, and have been displaced and needing to migrate, flee from their home country and find safety forever. But this concept, this legal definition of a refugee did not emerge until after World War II. As I think we all know, there was lots of ethnic religious persecution during the Holocaust, and in the wake of that, lots of individuals needed to find safety somewhere else. And so from there, several years after, there was the UN Convention, which started kind of these processes, started to get some countries on the same page about how to provide refuge, how to resettle what we consider refugees. From there, the US did not sign on to the 1951 convention, but later signed on. From there, the US had several basically ad hoc approaches. So groups of hundreds of thousands of refugees would be admitted to the United States. Maybe lots of these folks were from countries that were fleeing maybe political opinion persecution or different types of persecution in countries that were a part of the Soviet Union. That was a big chunks of people were coming for that reason to the United States, and the US was approving those refugees. And then different natural disasters would happen, which doesn't meet our definition of refugee right now, but these ad hoc programs were resettling, admitting those groups of individuals. And then 1965, next slide, please. So this is what is kind of the beginning, and then the next slide shows a couple examples of these ad hoc programs, and then 1965 was the first permanent basis for the admission of refugees. It still wasn't, there was still no process, formal process yet for asylum seekers, but the US made amendments to the Immigration and Nationality Act to create a preference category for refugees. Okay, skipping forward to the Refugee Act of 1980, which is on the next slide. This is when the US created a comprehensive system for asylum seekers, and that's our main focus. The refugee law is completely related and connected, but starting in 1980, there was a statutory, it was in the INA, these processes for allowing asylum seekers to come to the United States. Okay, and then in the 80s at the same time, so that is one arc, the evolution of refugee and asylum law in the United States. The other arc we wanted to provide as context is starting in the 80s, approaches to enforcement, immigration enforcement, also started to evolve and change. For a long time, immigration was seen as being connected to labor, like the Department of Labor and jobs and the need for jobs. Starting in the 80s, this shifted. There was, as many of you have probably heard, of the Reagan amnesty program. So millions of folks who were undocumented, they got a pathway to residency, and then at the same time, increased enforcement measures, increased use of immigration detention and punishment for, or just increased regulation of immigration. So then from there, some additional acts that created these deportable offenses. So this area of crimmigration law is emerging, and some of you might have heard of this. And that started in the 80s and the 90s. And so 1996, Immigration Reform and Immigration Responsibility Act, IRA, is referred to a lot in the practice of immigration law. It increased border patrol and border control measures, toughened procedural requirements, decreased, tweaked a little bit of the discretion that immigration judges could use when they're reviewing asylum applications, and created this expedited removal process, which we will touch on only a little bit today, but it relates to folks who are coming to the US border, the southern border, well, both borders. And then the 1996 Anti-Terrorism and Effective Death Penalty Act also increased immigration detention. So we're seeing these two kind of arcs of the evolution of the legal context in which we find ourselves today. So, of course, we all know 9/11, September 11, 2001, also has had a big shift in the immigration world. And so we see both the evolution of refugee and asylum law and these different approaches, increased enforcement, increased detention, kind of dovetailing and increasing after 9/11. And so the reason we're providing all of this is because it kind of helps make sense of what we see today. So asylum seekers are coming to the border, they're detained, and then they're under ICE surveillance and supervision. They go through immigration court. That court now is, you can draw a lot of similarities between the immigration court processes and the criminal court system. And so this is just as background. I think it's helpful to know where we came from and how we got to this moment today.
Okay, so complicated is an understatement to describe the asylum process for both advocates, let alone the non-citizens that are actually seeking that safety. They face so many barriers. When they come here, a lot of folks have experienced severe trauma. There are language barriers, especially when there are indigenous languages. Oftentimes, it's hard to find interpretation for those languages for advocates. Immigration court is in English. All the documents are in English. People often come here indigent with very limited resources, if any at all. And even beyond that, opportunities and resources for representation are incredibly limited, especially here in Virginia. Affirmative asylum itself can take up to 10 years. So defensive asylum in court, which is a far more adversarial process can sometimes feel a little bit like this picture here, a maze where it is very, very confusing. The law often changes under our feet. Asylum law is also always sort of subject to political whims as well, and so it's changing a lot. It's incredibly complicated as a process.
Okay, this next slide, if I can figure out how to do this a little quicker. We're not going to go through this flow chart, but this is just also to elaborate how complex and also case-specific these processes can be. We're going to do broad strokes. And another note is that border processing policies and practices are also shifting a lot. And so I might interact with someone that arrived 2 years ago and they had a different experience. They might have slightly different documents than someone who I'm coming into contact with in Virginia who saw asylum more recently. So these are shifting, but we're going to do broad strokes. Another kind of elaboration of how many pieces there are to immigration law and how complex it is there's lots of agencies that have a hand in these processes. So for advocates, it's knowing what to file when and where, it's who to communicate with, and also for clients, which we'll get into a little bit more because often they're interacting with multiple immigration agencies at the same time or while they're going through, for example, asylum seekers going through the immigration court processes.
Okay, and this is just a quick note on the affirmative asylum process. This is for people that are not in removal proceedings. And the process differs in that it is an interview process, an application, as opposed to the defensive process, which is more of an adversarial court proceeding where there is a prosecutor and cross-examination and a judge that can question evidence and make a decision by the end of a merits hearing or essentially a trial. Now, people seek asylum or enter the border to seek asylum one of two ways. They can either present at a port of entry. They are then held and screened by an asylum officer to see if they have a credible fear, and then they may receive parole. Alternatively, folks can come in not through a port of entry, and they can also file affirmative asylum within 1 year of their entry into the United States.
So the tip for advocates is knowing, does this person have a pending immigration court case already? If you're going to help them file their 589, which is the form to apply for asylum, you need to know where to file it. If you file it with the wrong agency, they could not start their asylum clock, which we will describe, or there can be other consequences in their immigration court case. So another kind of flag, know where their court case is pending and if it's pending already. Sometimes there's a several-week delay or longer in someone who has come to the border past the credible fear screening. There might still be a delay even though they have an NTA, they'll show you the document, which we'll describe some more. All signs point to they should be in immigration court. They might not yet be in immigration court. So important to know where their case is, and it can really vary based on how that person's case is being processed by the immigration agencies.
Now, asylum seekers in Virginia that are subject to removal proceedings often do have ICE check-ins, which Emily can share a little more about her experience with clients there.
Yep, and this is asylum seekers everywhere, but we're in Virginia, so we're just describing what happens once they arrive to Virginia. They might come to our offices or your offices. So that's why it says Virginia, but these are general processes that all asylum seekers will be going through.
So now let's talk through the basics of removal proceedings and what the immigration court process kind of looks like. Now, removal proceedings or deportation proceedings are initiated by the government through a charging document called a notice to appear, or an NTA. We'll see a sample of an NTA on the next slide. The following slide. Yeah, that is what an NTA looks like. And so that NTA essentially serves as notice to a non-citizen that the government is trying to remove them from the United States. Removal proceedings are conducted in administrative courts where an immigration judge hears the proceedings. And so at the outset of these hearings, the burden is on the government, and the government needs to prove alienage and removability. So they need to prove that the non-citizen is actually not a citizen of the United States, that they are a citizen of another country, that they are deportable to another country under some ground laid out in the INA, or the Immigration and Nationality Act. Now, that is very important because the burden for many things in immigration is often on the non-citizen. That initial burden is very, very important. And so just a little note there that that piece of proceedings is often incredibly complicated and difficult without an attorney. After those initial burdens have been established, only at that point, the burden turns to the non-citizen. And then they have to submit some sort of application or make an argument to establish that they are entitled to relief from deportation or that they're entitled to stay here. So that could be in the form of an asylum application, which is what we're focusing more specifically on in this panel. And so removal proceedings work through a series of master calendar hearings. First, they are scheduled master calendar hearings are essentially scheduling hearings and hearings at which the case and pleadings are discussed. So those initial burdens are discussed. All of those hearings culminate typically in an individual merits hearing, which is sort of a trial, and that is where the judge hears the merits of an application such as asylum. And at the end of the hearing, or sometimes they can reserve decision and make it a little later, they rule on that application and make a decision about whether the person is ordered removed or they are allowed to remain in the United States. So the notice to appear on the next slide, I'll talk through a little bit about what this document is. On the top right-hand side, it's redacted here. You'll see the A number. That is the alien number, which is a bit of a dehumanizing term, so I'll call it the immigration file number. And it is a very important number in immigration because it is it's your file number, so when you are looking up your case on any of the agency websites, that is the number typically that you need to be aware of to get an update on what's going on with your applications or your immigration court case. It will also have your name, date of birth, the non-citizen's name, date of birth, the country that they're being charged with removability to, and it will lay out the statutes under which the Department of Homeland Security believes that the non-citizen is removable. So the reasons for removability should be in this document here. This initiates removal proceedings. At the bottom of the hearing, at the bottom of the notice, it will have a hearing date and a court location, and it will be signed and dated. So next slide. If you see a notice to appear, the first and the best thing to do is to check the EOIR case status website. And if you type in the A number there, you will get confirmation typically of the person's hearing date and court date and what judge their case is assigned to. You can also type in the A number to see if the case exists. Sometimes what happens, and sort of what Emily was alluding to earlier, is we will see someone that brings a notice to appear into our office, and we'll go on the website and type in their A number, and it will say there is no case found. So that just means that while the Department of Homeland Security might intend to file this notice to appear, they haven't done so with the court yet. And so that should be a flag to advocates to sort of stay on top of checking and making sure that you are staying on top of that before that scheduled hearing to make sure it's actually a hearing that the person needs to appear for. We'll talk a little bit later, but immigrants face very harsh consequences for small mistakes, and they can be ordered removed in absentia if they do not appear for a scheduled court hearing. So this is what the case status website looks like. It is available in Spanish and English. On the top right-hand corner, you can change the language. Alternatively, you can dial the EOIR case hotline, and that can give you the same information about court proceedings, and that's available in Spanish as well.
The next part, and this chunk of this like nuts and bolts kind of orientation portion of the PowerPoint is what we give in Spanish to people who have recently arrived as kind of, here are things you need to keep track of that really could derail your cases, and sometimes we're able to help clients, community members with this as well. And two very big things to keep a case on track, aside from filing the 589, which is the asylum application, is the change of address and change of venue. So venue, of course, is where the case is pending. If someone arrives at the border and they don't have an address that is where they're going to be staying, their case might get docketed, for example, in Harlingen, Texas. That means that their hearings will happen in Harlingen, Texas, and it's very hard to get from Virginia to Harlingen in time for a hearing. So that can be fixed, easy peasy. You do a change of venue motion. Someone can do this on their own. I'm skipping ahead, actually. So we'll go ahead a few slides, and we'll come back. Well, I'm not really using this very well today, so we'll just stay here. I will describe in more detail about the change of venue, but basically, this is something that can be fixed. If you see, you pull up in the ECAS, which is the EOIR case status website, which is the immigration court website, and it shows you the address of the court, and it says Harlingen, Texas. Just know there's two things you need to do: change venue, which I'll describe in more detail, and change of address, which also is an easy fix. So change of address, there is a form. Lots of these processes have forms already. So there is a form you can fill out. The person can go to the immigration court. They can ask for the form, and they can fill it out themselves and file it there. This can also be done online. Just a flag for advocate, someone who is helping someone change their address. Make sure that if you do it online, print out a copy and they mail it to opposing counsel, which is the DHS attorney. Side note, there's lots of names for the DHS attorneys: the trial attorney, TA, OPLA, Office of the Principal Legal Advisor, ICE attorneys. That is all referring to one person who is the government attorney that is opposing counsel to the person going through removal proceedings. So you might hear those names used. They can be used interchangeably. Important as in most court proceedings, even in state court, federal court, you got to give a copy to opposing counsel. Okay, change of venue. So this can be done with a motion to change venue. There are samples online. You can do a little Googling. DOJ, the Department of Justice, which houses the immigration courts, they have a sample. Often there are samples at the immigration courts themselves if someone needs to do this and they don't have access to an attorney. The trick, of course, is that all of these forms and these motions need to be done in English. So also, for practitioners, the Immigration Court Practice Manual has a lot of guidance. So there will be guidance on what needs to go in this motion to change venue. Okay, these are the two immigration courts in Virginia. The cases are divided by where the person lives. So based on zip code, it's like the person doesn't need to worry about the zip code. Of course, if you're an attorney, do your research, figure out which court it goes to, where the court needs to be transferred. If you're doing the motion to change venue, if the person's pro se, most important is to get that filed and give the new address, and the court generally will figure it out, the immigration court clerk or the judge. We touched on this already, so A number, really important. It helps someone keep track of their case in immigration court and in the USCIS processes. So it's like a social security number. Someone gets one and it sticks with them. Some cases, someone happens to end up with multiple A numbers, and that is very rare, and it's a little complicated, but it's okay. You just can file things with both A numbers, but generally one A number for one person. All right. Here's other examples of documents you might see if someone comes to your office and they bring you what they got at the border. These, for someone, like when I'm here sitting in Virginia, these are not super important. It's just so you know. These are documents that says they were in ICE custody and now they're not, and that DHS had authority under the statute to detain them in the first place. Okay, now we're gonna switch gears to ICE check-ins. So what I tell people is there's two things you gotta stay on top of: immigration court case and ICE check-ins. So the risk of messing up your immigration court case, not changing your address, not changing venue, not filing your application in time, not appearing, is a deportation order. That's very serious. That's the end of your case. Unless you can appeal, you have something there to get a second shot. The risk of not doing ICE check-ins is detention. So both are very important, and individuals need to stay on top of these processes. So ICE check-ins are different. This can be confusing. So someone will have the master calendar hearings and the individual hearings going on in immigration court. At the same time, they will have regular ICE check-ins. So for example, our Virginia, there is an ICE ERO, so Enforcement and Removal Operations Office, field office for the Washington DC area, and that's in Chantilly. There's one in Richmond, I don't know what the address is, but there are these field offices. You can find the field offices by looking on the ICE website, but again, with keeping track of who you need to be interacting with, you'll be interacting with the DHS, the ICE attorney, and the immigration court. That's the Office of the Principal Legal Advisor. And then these check-ins are also like under the umbrella of ICE, but it's the enforcement and removal operations. And so it will be a different address. Anyway, there are a lot of practice guides, which is great. A lot of just being sure which government website you're looking at is important. But these check-ins will happen. So what we're seeing is sometimes it will be every 6 months, every month. It really depends on the individual's case. We are also now seeing more alternatives to detention. So we're seeing subcontractors. ISAP is what we see in our area. There's another one, I'm forgetting the name, that is I'm seeing more. And so individuals will have their check-in with ICE, for example, at the field office and with this subcontractor. We also are seeing more use of smartphone apps, so daily calls potentially, or house visits. This individuals that are both in their removal proceedings and after they have a deportation order will be interacting with the ICE field office because we're focusing on during immigration court. Generally, the supervision is less than if someone has a deportation order, but very important to make sure you're going to the check-ins. The check-ins can be as simple as showing up at the field office and saying, I'm here still. ICE is so this supervision program is in lieu of immigration detention, as I mentioned, and so the ICE officers are making sure the person still lives at the same address, and ultimately with the point of having the individual show up at their merits hearings and even before that, the master calendar. So there is a new program which you all might have heard about. There's a community-based supervision ICE program that some nonprofits are contracting with ICE to do kind of wraparound case management services on top of the check-ins, on top of keeping track of where the person is living and ensuring that they show up to their hearings. Okay. How to update your address with ICE? I will talk about that in a minute. These two documents on the right, for example, is an alternatives to detention ADT enrollment document. So if someone gets an ankle monitor, they will likely get a piece of paper that says, you got put on a GPS monitoring, here's your contract, or here's something to sign. So on the left is an appointment confirmation. A lot of times, someone will come into the office and they won't really know how to go about checking in with ICE. So someone comes to the border, asks for asylum, they pass their screening, they are released to Virginia, they need to do an ICE check-in. How do they do that? Sometimes they will get an appointment before they arrive to Virginia. Often they won't. These appointments can be scheduled on the ICE, there's an ICE portal. And so someone can help them do it or they can do it themselves. There's an app too. Maybe I'm technology challenged. I have not had a lot of luck getting these appointments scheduled online. And in that case, my advice is for the person to go to the field office. Most important is for them to make the appearance, say I'm here, and to know when the next time to check in is. Okay, so as I mentioned, very important to keep the address updated with ICE. This can be done online. This can also be done over the phone.
Okay, so asylum seekers have a lot to worry about. They pay heavily for kind of not staying on top of every aspect of their case, and as you have gotten a flavor of, there are many agencies and many different pieces of their cases to stay on top of. That is why we were emphasizing the changes of address to make sure that notices and all information is accessible by the non-citizen. As I mentioned earlier, if a court hearing is missed, the there is a possibility of getting a removal order against you in absentia, and it is incredibly, incredibly complicated to correct that in the future. You all know that immigration representation is already limited. Even with an attorney, the grounds on which to reopen a removal order are very, very narrow and very complicated, and they require us to demonstrate a very high burden. Even still, the Immigration Court and the Board of Immigration Appeals, what we've seen in our practice is they're typically stingy with reopening removal cases, and it's never a guarantee. So staying on top of the cases is incredibly, incredibly important. You can see on this slide how sort of small mistakes can lead to very, very big consequences for asylum seekers. Missing forms means missed hearings sometimes, and missed hearings can mean in absentia orders of removal. As Emily just discussed, missed ICE check-ins can mean ICE knocking at your door and detaining you or your family. They face big consequences for their small mistakes. So this next slide discusses parole a little bit. Parole is a bit of a confusing term in immigration because it sort of applies to two different scenarios. The first thing people mean when they discuss parole is often release or permission to stay. So when people enter at the border and they are allowed to remain in the U.S. without being detained, often that is referred to as parole or form of parole. And then there are also separate forms of parole that people can apply for as sort of an immigration benefit or a relief from removal. And those are through formal processes that are for specific populations and groups.
Yeah, you might have heard there was a parole program that was established a couple years ago for Cubans, Haitians, Venezuelans, and Nicaraguans. This is someone is applying for the person on their behalf while the person is still in their home country. That's a different type of parole process. And recently, well, I believe that one is still paused right now, but that many folks were applying for relatives or people that they knew in that country for several years. This went on for several years. There's also a parole in place for relatives of people who are in the military, and more recently, the parole in place for spouses of U.S. citizens and also stepchildren of U.S. citizens. You all might have heard this. This was done 2 months ago by the Biden administration by an executive order. So that's a different type of parole. These are all different forms of parole, and parole, the big overarching definition is permission to be here, permission to enter, that kind of allowance. Parole in place for spouses and stepchildren of U.S. citizens is currently stayed pending litigation in the Fifth Circuit. Is there anything else there? We're not going to get too much into the circumvention of lawful pathways rule. We know that is going to come up, but if someone comes in, I included it in here because if someone comes to your office, you need to make sure, in addition to the other things that we keep in mind, reading the NTA, making sure where they need to file their 589, their asylum application, updating venue, updating addresses. If they entered after May 11th, 2023, there is a presumption with a couple other requirements, but generally come to the border, seek asylum in the normal processes that we've had for several decades. There's a presumption of ineligibility. So I won't get into that too much, but just if someone walks in, they're recently arrived, these are dates to keep in mind.
Okay, so now let's talk about some work permits. Work permits are often one of the top priorities for asylum seekers or new immigrants to the country after their basic needs are met. That's something that we often see a lot at the Legal Aid Justice Center. Folks are eager to get work authorization so that they can make money legally here. So the next slide is a photo of the site that you would spend a lot of time on if you either have filed a work authorization for yourself or you are an immigration advocate that files work authorizations. This is the USCIS website where you can type in the receipt number of any application you have filed, and you can get a live sort of update, status update on it, and it will let you know if the application's been received, if there is any progress on it, if a request for evidence has been sent out, if there's an interview scheduled, if they are waiting on fingerprints. All of that information comes up on this website, so that's really helpful.
Yes, and we don't have a slide, a screenshot of this other website, but the USCIS website also has average processing times, which is very helpful to give clients or community members, whoever you're speaking with, an estimate of how long it will take for this application to be processed. I believe the first work permits, like for asylum seekers, are now being processed in a month or something, which is great. It's super speedy, and that I haven't checked in a little bit, but that changes. But you can look up average processing times, which will help someone make work arrangements, start finding a job, whatever it is. It's helpful to have these estimates.
Okay, so a non-citizen is not able to file a work authorization unless it is based on some sort of application that they have pending, or a visa, and some sort of relief application or a status that they have. So, for example, a pending asylum application allows for work authorization. The categories for work authorization are listed on the USCIS website, and it is important to note that work authorization or employment authorization documents are time-bound. So it is very, very important for advocates and for non-citizens to keep on top of that expiration date and make sure, because of the delays that often come up, to make sure that any renewals of those applications are filed with some leeway. We suggest about 3 months-ish, so that there's no lapse in the validity of their work authorization. And something that's important to note is that often if someone is in removal proceedings, one way to try to get them out of immigration court into a less adversarial process is to ask for prosecutorial discretion so that their immigration proceedings and their removal court case is dismissed, so that you can file the application affirmatively and go through kind of the less onerous and intense process through the affirmative route. It's important to note that if you don't have an active case, that in-between period, you don't have authorization for work during that period because you don't have a pending application. In a situation like that, the person, when their case is dismissed in immigration court, they would immediately no longer be eligible for the work authorization until they were to file affirmatively an application with the USCIS and it had been pending for the required time. So that's some basics about work permits.
Yeah, and there is another kind of like a practice tip. A USCIS also has a very helpful webpage about what happens when your immigration court case gets dismissed and when to file, what that means for your work permit application. So a plug, there's a lot of good resources on the USCIS website and some other government websites, in addition to practice guides that help all of us navigate these different processes. Okay, so some other things for asylum seekers to keep in mind. The person needs to file their asylum application within 1 year of arriving. That applies to everyone who's gonna apply for asylum. If not, there's a bar to receiving asylum. What the bar means is that you can get another form of protection if the person can still establish that they will be persecuted in their country of origin, but that is called withholding of removal. It is not a pathway to residency. So asylum is far and beyond the best option for someone who is applying for immigration relief or immigration protection based on persecution grounds. So it's a big deal. These bars are a really, really big deal. So 1 year. There's exceptions. You can argue to try to get around this bar. But it's there. And something to also keep in mind is it's not just keeping in mind the 1 year filing deadline. If someone is in immigration court proceedings, they need to file their asylum application at one of their masters. It needs to happen so that the immigration judge knows that they have an application for relief pending to schedule the individual hearing and to have a defense against deportation. So the 1 year filing deadline is very, very important. If someone has their master calendars or they've had several master calendar hearings, and it's, at the point that you have 3 master calendar hearings, that's it. Pretty much you're gonna get an individual hearing scheduled, which is the merits, the trial of your case. If that comes before the 1 year filing deadline, the person needs to file the asylum application. That can be amended later, but it's very important to keep both of the purposes of filing. So within the 1 year, it's letting the government know, hey, I'm gonna apply for asylum. The other purpose is to have your defense to deportation. And the third purpose, which is listed Next is to get the asylum clock started. So really important to get those asylum applications pending. Another like tip and trick, there is a translation of the 589, and a nonprofit, an immigration nonprofit did this a couple years ago, so it will be an older version, but the gist, most of the 589 has not changed, and so sometimes if we're not able to take the case, we might print out the version in Spanish and say, okay, go box by box and try to fill out the information as best you can so that you have it pending and so that you can get your asylum clock started. Different advocates will have different approaches. Often we are just trying to help people not get a deportation order and get their case started if they have a valid asylum claim so that they can get their work permit. It's complicated, and there's lots of different, both what the client is trying to achieve and the demands of these different processes with USCIS, which is the work permits, and the immigration court, EOIR. So, but yeah, work permits are super important. Of course, people are often, it's one of the first questions we get. Last thing is changing your address with ICE. It's also very, very important to change your address. I'm like harping on this. It's very important. Okay, so resources, I can change the slide. Oops. We mentioned a bunch of these resources already. They're listed here. So checking the USCIS case status, the forms, another tip, 589 included, which is the asylum application. Always go to the USCIS website and download the most recent version. Versions change, and sometimes USCIS stops accepting a previous, well, they will stop accepting a previous version at a given date. So always don't just get your, go to your files and find one that you had saved. Go to the USCIS website, download it. The instructions are also very important. Read the instructions. This work is very detail-oriented, but it's important, as you can see, because these small details make a big difference. Okay, Immigration Court, which is EOIR, Executive Office for Immigration Review. We mentioned the case status system. If you are representing someone and you file an appearance, there's an ECAS system, which is also a way, an online case system, where you can file things and download what has been filed. The online link, which I shared already, to change your address with Immigration Court, and then ICE to schedule the check-ins and change the address. And sometimes if the technology is not working, call, there's an Immigration Court hotline and ICE hotline. Okay. We now have, we've just talked a lot about the asylum process. We thought it would be helpful to hear from someone who's both gone through the asylum process herself, is now an asylee, which is great, end of a long road, and is a immigrants' rights advocate in Virginia, Beatriz Batres. So we have a video so that we could do simultaneous interpretation. So we will go ahead and see if this will play.
Good evening, and thank you for being here with us. Today we have Beatriz Batres, a community organizer for the immigrant community. Beatriz, gracias por estar con nosotros. ¿Nos podrías decir un poco acerca de ti? I just asked her to tell us something about her.
Sí, gracias por la invitación. Mi nombre es Beatriz, soy salvadoreña. Hago trabajo organizativo desde el 2021.
She just told us she's Salvadorian, and she has done organizing work since 2021.
En el 2014, cuando llegué a Estados Unidos solicitando asilo, fui detenida en el Centro de Inmigración de Artesia en Nuevo México.
In 2014, she entered the United States seeking for asylum, and she was detained at the detention center in Artesia, New Mexico.
Desafortunadamente, en 2018 volvimos a tener otra mala experiencia. Detuvieron a mi esposo y él estuvo detenido en la detención en Farmville, acá en Virginia.
Again, in 2018, she had another encounter with immigration where her husband was unfortunately detained at the Farmville Detention Center.
A raíz de la detención, por mucho tiempo estuve haciendo trabajo voluntario, especialmente con mujeres que solicitaban asilo.
Because of all of those interactions she had with immigration, she started doing community work with the immigrant community, especially with women who were seeking asylum in the United States.
a través de denunciar los abusos que viví y que también viví a través de otras mujeres durante la detención.
And this was because she saw and she experienced all the abuse at the detention center, not only from her personal point of view, but also the other detained women at these detention centers. Beatriz, te voy a hacer unas preguntas acerca de tu caso de asilo y para que la comunidad y los que están viendo este video puedan entender un poquito lo que es el asilo en los Estados Unidos. We're going to ask a couple of questions for Beatriz so you guys can understand what an asylum application is and the process and everything that everybody has to go through to file for these applications. Beatriz, ¿qué le gustaría compartir con los estudiantes de derechos, abogados y otros profesionales en este campo sobre el proceso de asilo desde su experiencia?
Ok, no fue la mejor experiencia. Definitivamente es un proceso que trae mucho violencia, mucho trauma.
Okay. I asked Beatriz to share with the law students and attorney and any other organization what was her asylum experience. And her answer was that it was a very traumatic and very hard experience for her. ¿Cuál fue uno de los aspectos más difíciles de su viaje de asilo a los Estados Unidos?
Una de las cosas más difíciles fue que en México también fuimos secuestrados por un cártel y después puestas en una detención.
One of the most traumatic experiences she went through while in the process of getting herself to the United States and applying for asylum was being in Mexico and being kidnapped by a cartel. Not only after going through that, she was able to enter the United States and then get detained while she entered here. ¿Cómo fue como organizadora en el espacio de los derechos de los inmigrantes en Virginia? ¿Cuáles son algunos de los desafíos comunes que enfrentan los solicitantes de asilo y otras personas que viven en Virginia que atraviesan procesos de inmigración?
Una de las cosas que me he encontrado es que mucha de nuestra comunidad no comprende el proceso y confunden todos los pasos con provocar su deportación.
I asked her as an organizer, what are the challenges that she sees among people that live in Virginia and the people that are applying for asylum? And she said one of the biggest challenges she sees is that the lack of information from the community of all the steps they need to follow and from the steps that they don't follow that end up being in a deportation for themselves.
Porque mucha de nuestra gente también tiene miedo de hablar de su experiencia. No sé, les han metido ese miedo de que si denuncian, su caso se va a perjudicar. Y también la forma en la que criminalizan al utilizar dispositivos en los pies.
Another challenge that she mentioned that our community is having is the fact that people have fear to share their own experiences because either they fear that they're going to get detained, that they're going to get that ankle bracelet, and that also is also something that our community is uncomfortable having or sharing their experiences to avoid that and being able to be open to share their stories. Beatriz, ¿qué papel pueden desempeñar los abogados en el movimiento por los derechos de los inmigrantes en Virginia?
Creo que es importante que este conocimiento también se comparta con la comunidad. Hay muchos aspectos legales que también alguien que no es abogado puede tener para poder apoyar.
I asked her what will be the role of the attorneys with the immigrant community in Virginia in terms of sharing the information for asylum applicants. And she mentioned that maybe just exposing the information to our community, being clear about the information, not only for attorneys, but other community organizers or organizations that can have this information available for the community. Beatriz, ¿qué papel desempeñan los abogados en la creación de un sistema de inmigración más humano?
Creo que a través de proponer que el proceso mismo deje de ser tan violento al exponerse al trauma una y otra vez para convencer a alguien de algo que ya viviste.
One of the things that I asked her was how can attorneys create a more humane system for asylum applicants? And she said that making the process less stressful, I guess, less hurtful, and without having that human touch towards the applicant so they can freely express themselves through this the turmoil that they face and also share their experiences comfortably.
Creo que también algo importante es el cómo se muestran los abogados, que es demostrar esa sensibilidad y no verlo solo como un caso más.
One of the things that she shares or she wants to share is that how attorneys project the applicant. How is the attorney being more sensitive towards the applicant and not only seeing this person as just one more client, but instead of just one more client, it will be as another human being seeking assistance or seeking help from this country. Gracias, Beatriz, por compartir tu experiencia y esperemos que esta lucha contra nuestro sistema y la lucha contra los derechos de los inmigrantes siga siendo perfeccionada.
Gracias a ustedes por crear estos espacios y hacer que se escuchen las voces de más personas.
We thank Beatriz for sharing her story, and she says that this spaces and opportunities to share her story opens up, clarity about the asylum process.
Alrighty. So, we're very grateful to Beatriz for sharing her experience and also her insight and all of the wisdom she has. She works really hard too, both as a community organizer and in lifting up her experience, both in immigration detention as an asylum seeker and going through the process herself. So, okay, now we're getting to the end, but we want to share some final takeaways for someone who is maybe a new practitioner or new to immigration law, some final tips and tricks.
Yeah, I think a big takeaway here is that access to accurate information in this space is absolutely critical. This was just an asylum nuts and bolts 101, and there were so many complexities here that we weren't able to even address or acknowledge. These are very, very complicated proceedings, and the law on this is even more complicated. It's also scary and high risk for the non-citizens that come here. It's often the single most important experience that they'll have or thing that they'll go through. And there are lots of barriers and lack of access to representation, especially here in Virginia. I was a practicing attorney in New York, and I think that was one of the most jarring things for me when I came here to kind of see the lack and how great the need is across Virginia. There's no universal right to an immigration attorney. In criminal proceedings, you have the right to an attorney or the government will provide one to you. There's absolutely no such right in immigration court. You often don't even have the right to ask for enough time to seek an attorney. So immigrants are up against a lot, not to mention the anti-immigrant rhetoric that is always out there, especially in an election year on both sides. The laws change so much, language is often a barrier, and it's an intimidating process, even for the advocates. The court is often hostile, so immigration attorneys are often, there are barriers to them even taking on complicated defensive asylum removal proceedings. Also, these cases take a very, very long time. As we mentioned, if someone is not detained, an immigration case, an asylum case can take many, many years. An affirmative case can regularly take up to 10 years, and a defensive case can absolutely take 5 or 6 years. We often deal with while there are some kind and reasonable judges, some are unreasonable, some are hostile. Same goes for prosecutors and attorneys in the space. So it's a challenging arena to navigate. Access to this information is limited, and it's very, very critical. We are one of the nonprofits in Northern Virginia that does take direct rep cases for asylum seekers, although we are limited because there are only 3 attorneys that we have, and we're all based in Northern Virginia. There are a number of nonprofits in Northern Virginia, but most of them are not open to intake for asylum seekers on a regular basis at all. So that's a little bit challenging. And so we are brainstorming and always thinking through ways on how to share this information more widely. We do Know Your Rights presentations in community spaces in English and Spanish to try to get folks to easily access accurate information. And we provide consults as well too, which, although that's nowhere near the benefit of full representation for an asylum proceeding, we have seen that it provides a lot of value in providing information and orienting people to know what they need to even be keeping track of.
Yeah. I think we've underscored this, I think, throughout the presentation, but diligence as to the details and keeping up with the changes. And making sure that both the information and any kind of legal assistance we give is gonna help the person and not hurt their case. We have a case right now pending at the Fourth Circuit because of immigration fraud and scams and poor performance, ineffective assistance of counsel. And so this is widespread. I know you guys have probably heard of notario fraud, but this happens by lawyers and non-lawyers. And so helping individuals also protect themselves against immigration scams and equipping individuals with the accurate legal advice helps them protect themselves against these things. So that, yes, staying up to date. And then I think as hopefully hearing from Beatriz helps just for practitioners, advocates, community organizers, all of us to stay grounded in the humanness of this issue. These are people who are going through the legal process. Everyone who has been released from the border has passed a screening enough to show that they have a valid claim for protection based on persecution that they're afraid will happen to them if they receive or has happened to them in the past. And so keeping in mind that these asylum processes have their roots in refugee law. These folks are refugees. And so keeping that in mind, they're going through legal processes that is outlined for them in the statutes and the regulations, and keeping that, this issue, and I think all legal work, keeping the humans at the center. Okay, I think we're basically out of time. Thank you all.
Okay, we're going to set up our next presentation. Feel free to step outside and grab some of the continental breakfast that is now set up. We're going to start in the next 5 minutes.
And manage cases for children who are aging out of the Juvenile and Domestic Relations Court. The panelists will also discuss language interpretation resources and how to work most effectively with interpreters in these cases. The presenters are Julie McConnell, Daniel Bickett, and Tanisha Cruz. Daniel Bickett serves as the program coordinator and DOJ accredited representative at Sacred Heart Center's Immigration Legal Services Program, where he represents indigent non-citizen youth, survivors, and asylum seekers before the Department of Homeland Security and the immigration courts. Since 2022, Daniel has collaborated with the University of Richmond School of Law's Children's Defense Clinic through his role at the Sacred Heart Center, co-counseling disadvantaged immigrant youth and pursuing special immigrant juvenile status and other immigration relief. Tanisha Cruz Esquire was raised in the Dominican Republic until her parents immigrated to the United States. She earned her bachelor's degree in journalism, public relations, and advertising from Temple University in 2004. She then earned her Juris Doctorate from Drexel University, Thomas R. Klein School of Law in 2012. In 2015, she joined Legal Aid Justice Center as a staff attorney under the Immigrant Advocacy Program. She also co-supervised students in the University of Virginia School of Law's Immigration Law Clinic, and she is the founder and managing attorney at Cruz Law, PLLC, a small law firm in Charlottesville, which was established in 2017, focused on immigration and family law matters. Julie McConnell is professor of law, legal practice, and director of the University of Richmond Children's Defense Clinic. She has worked in youth justice for more than 25 years and specializes in holistic trauma-informed representation and client-centered practice. McConnell and her students have assisted dozens of children with obtaining special immigrant juvenile services, predicate orders in the Juvenile Domestic Relations Court. I present to you the panel.
Thank you so much for the lovely introduction. My name is Tanishka Cruz, and as was noted, I am the managing attorney and owner of Cruz Law, a small firm in Charlottesville, Virginia. And, you know, years ago, I had the privilege of attending a conference where Justice Sotomayor spoke. And one of the things that still ring true today that she said was that the legal profession is an honorable and noble profession. And nothing rings truer in my mind than the work that we do here with children and advocating for children really bring those words home for me on a regular basis. So it's been one of my joys and greatest privileges to work with immigrant youth in Virginia.
Yes, hello. It's very nice to be here. I was very grateful for the invitation to participate on the panel. So my name is Daniel Bickett, and I'm as was mentioned, I'm the program coordinator at the Sacred Heart Center. We have an immigration legal services program that principally practices humanitarian immigration law. We are actually a DOJ recognized organization. Emily Lipinski, it was mentioned, formed one such organization in El Paso, and so kind of a niche non-attorney practitioner of immigration law. We've been working hand in hand with the Children's Defense Clinic here at U of R since fall of 2022, co-counseling disadvantaged immigrant youth, and I couldn't be happier to be doing this work. And so thank you again.
Thanks, Daniel. Good morning, everyone. I'm Julie McConnell, and about, I think it was 10 or 12 years ago, I had the fabulous experience of going to a CLE that Tanishka taught, and she was teaching lawyers who wanted to do public interest pro bono work how to do these cases. And she demystified them, and she made it possible for us to take those cases on. I was so intimidated by all of the immigration aspects of the cases, but Tanishka brought it home for me that this is something students could do. So we've been handling these cases now for about 10 or 12 years, and they're wonderful cases. They're so rewarding. These kids are phenomenal. They're working so hard to assimilate and thrive here. And it's just a joy to be able to help them. These kids would have no counsel without pro bono lawyers, and occasionally people can retain lawyers. And so it's just such an honor to be able to introduce this type of pro bono work to my students. So I look forward to sharing more about that as we go along.
Right, so what we're gonna cover today, just to go over the agenda, is an overview of special immigrant juvenile status, the role of the J&DR court, some common SIJ issues, some SIJ practice pointers, and then we'll talk about what happens after family court. Okay, so I think it's useful to sometimes cover some of the basic language that's used in immigration practice, because it can get confusing. I think a lot of folks believe that people just become citizens, and you don't just become a citizen. There's usually a step in between for non-citizens. So you first obtain your lawful permanent residence, you hold that for a certain number of years, and then you naturalize. So there are certain steps for folks if you weren't born in the United States, or if you don't have a parent that is a US citizen. There is a difference between non-immigrants and immigrants. So a non-immigrant would be someone who is coming on a visitor's visa on a temporary basis. They don't have the intention to come and reside in the United States, whereas an immigrant is going to want to come to reside. The panel before us already covered the refugee versus asylees. So I'll just move on to undocumented individuals, or those who are here without lawful status. And then you have people who are lawfully present in the United States. And that could mean that you have lawful permanent residence, or you are seeking asylum, or you have temporary protected status, or you have deferred action. There are a number of different lawful presence statuses. And as was covered in the earlier panel, you have the affirmative versus the defensive processes and unaccompanied minors. For this panel, the unaccompanied minors is very relevant, and that's a very specific term. You have to be designated an unaccompanied, well, under the immigration statute, it's called an unaccompanied alien minor. So those children are those who are detained at the US border who have arrived without a parent. They're deemed an unaccompanied minor, and there are certain processes and procedures by law that they are afforded. So it is a specific designation, and it means a lot because there are protections that follow when you have that designation. Is it true? Sorry, everybody. I think it's relevant to talk about the treatment of children in immigration court. It was alluded to in the prior panel, but to me, because I serve as a guardian ad litem throughout Virginia, I think it's really important to hone in on this, because I think we have a tendency to think, well, they're children, so there's going to be a GAL that at least will be there to speak for them, correct? I'll tell you that not too long ago, I think it was about 2 months ago, I had a client appear at a master calendar hearing with myself, and a lot of times these are being done virtually now, but the client is 8 months old. So they are in their little baby carrier, and the judge was shocked, quite frankly, and stated on the record that the respondent was nonverbal, and what does DHS want to do with this case? And DHS, is the prosecution in immigration court proceedings. And they were sort of like, we don't know. But the point is that we at times are literally holding our clients in court, because it doesn't matter whether you're 8 months old or 17 years old, you can be deported. So it becomes really critical for lawyers to become involved in these cases. And I'm really passionate about SIJ because it's a life-altering status for children, and it really can be life-changing. So an overview of special immigrant juvenile status. I think it's important to note that it's a federal law, but it's unique in the sense that it utilizes a state court system. And the state court system is a prerequisite to the child's ability to apply for this status. And that's unusual in the federal court system or in the federal immigration system. And the reason that that's so goes back to the creation of special immigrant juvenile status by Congress in 1990. And it was created because you had children who were essentially ending up in foster care and then aging out of foster care as undocumented adults. And for that reason, Congress sought to protect vulnerable young people who were being abused, neglected, or abandoned by their parents. And that's the framework for where SIJ came from. In 2008, the law was amended, and now you don't have to be a child that is essentially, that the prerequisite is that the child has to be in foster care. Now you can have single parents that are applying for SIJ status on behalf of their child, but that is the thought process. It's because the federal court or the federal immigration system is recognizing that they aren't the experts in what's in the best interest of a child, right? They're not the ones who get to decide whether a child needs to reside with one parent, the other parent, whether that child has been abused, neglected, abandoned. That pertains specifically to the juvenile courts. So the thought process is that these cases arise organically from some kind of state court process. And I just want to flag, especially for those who are GALs who are attending today, that this isn't just for custody proceedings. It's important to flag these cases when you're dealing with children in need of services, CHINS petitions. If you're representing minors that are in delinquency proceedings, they can be eligible for SIJ. or foster care as well. So anyone who's a minor who's in the JDR court system can and may be eligible for SIJ, and it should be part of your screening to see if that is something that needs to be dealt with for the child. So how do you become eligible for SIJ? The eligibility factors are that the child must be unmarried and under 21. In Virginia, you have to be under 18 in order to access the juvenile court system. And we're going to talk about some of the variations that come into play there. But the federal law defines a child as someone who is unmarried and under the age of 21. So there's a little bit of a disparity between some state court systems and the federal system, because there are some states where, you know, a juvenile might be defined as a child that's under 21. The court has to have jurisdiction under state law to make determination about the care and custody of children. So here in the Virginia system, it would be the Virginia JNDR courts or the circuit courts by appeal. And I have found that we have had to appeal less and less over the past couple of years, but it still happens. So it's important to know that those two courts can issue the predicate orders. And the child has to be dependent on the juvenile court or legally committed to or placed under the custody of a state agency, department, individual, or entity appointed by the state or juvenile court. So that means that, you know, the child is placed in the custody of a parent, an uncle, a grandma, a brother, a sister, or the child could be placed in the custody of the Department of Social Services, or the child could be placed in the Department of Juvenile Justice. Reunification, you have to have a finding also that reunification with one or both of the child's parents is not viable because of abuse, neglect, or abandonment. And I just want to flag or similar basis under state law. And when we get into the nitty-gritty of each of these points, I'll circle back to this similar basis under state law. And it must be also found in the order that it's not in the child's best interest to return to his or her country. So you want to run through all of the Virginia best interest factors, the needs of the child, the relationships with each parent, the willingness and inclination of the parents to provide and address the child's needs. So all of the factors that you would go through in any other case become applicable here. Okay, and then the major players. So for SIJ, the major players that are involved are the state courts, and that's where you have to obtain what is commonly called the predicate order, because it's a prerequisite to apply for the special immigrant status under USCIS. So the first step in all of these cases is to obtain the predicate order from the state court with the necessary factual findings. Typically, depending on the child's situation, and that's another thing, you have to kind of sometimes evaluate every case because some children are in removal proceedings, some are not. So if the child is in removal proceedings or deportation proceedings, then you have to at some point deal with the immigration court. And currently, and this is administrative, or it depends on which administration is in power, how this goes for the child. So under the Trump administration, it was very difficult to get the child out of removal proceedings because there's a significant backlog for SIJ status children to become lawful permanent residents, meaning that it could be a very long wait for them to become green card holders. So the courts were not in a position to adjudicate those cases right away. So Oftentimes, we had to file asylum applications and jump through various different hoops to try to get the kids to a point where they could apply for their green card and get out of the removal proceedings. During this administration, now, as long as the child has an approved SIJ petition, and we can provide fingerprints for the child, showing that they don't have a criminal record, then the Department of Homeland Security is usually inclined to dismiss the case or terminate the case so that they no longer have removal proceedings pending. And then you deal with USCIS. That's the other agency that you're going to be dealing with, and that's where you apply for SIJS. And that triggers a priority date, which is what I tell kids is that this is you going up to the deli counter and pulling a ticket, and it has a number, and we're waiting for the number to get called. It's their place in line, and and every month, our practice at my firm is to check all of our priority dates against the visa bulletin to see who is eligible to adjust status and get kids down that path as soon as possible. And then, it's the same agency where you would apply for adjustment of status once that priority date is current. I think when it comes to SIJ in Virginia, I want to flag and bring up Canales v. Torres. I haven't had this case come up in a very long time. But I think it's important because in the context that it has come up for me recently is when I've had to appeal a case to circuit court, because I think they're not being appealed as often anymore. So the judges may believe that this is still, the controlling law in Virginia. So essentially, Canales v. Torres was a case that went up to the Virginia Court of Appeals, where what was being sought was clarification on whether or not the JNDR court had jurisdiction to make JNDR court findings. In my opinion, this opinion is quite muddled. And what it did was if you were, inclined to make SIJ findings as a JNDR judge, you continued to make SIJS findings and move forward. And if you weren't inclined to do it, then you can sort of read this case to say that I can't do it, Canales v. Torres. Now, in 2019, the Virginia General Assembly decided or sought out to correct that confusion that was being caused by Canales v. Torres. And it was made very clear in the state statute that the Virginia JNDR courts do in fact have jurisdiction and may make these findings when a child needs to apply for a state or federal benefit. And that's found in 16.1-241A1. Now, it doesn't require that the judge, that a JNDR court do this, but it just states that the court does in fact have jurisdiction. Then there was a further change in 2021, and this is an important one, because there were many children pre-2019, when the legislative change was made, that were not able to get SIJS findings because, for whatever reason, the judge cited Canales. Well, what this legislative change allows folks to do is to ask for modifications of orders to include these SIJS findings, particularly for children who have now aged out. So if you're between 18 to 21, you can petition the court to get SIJS findings made if the court at some point prior to your 18th birthday had jurisdiction of your case. So for GALs that are out there, this is similar to fostering futures, right, where the court retains jurisdiction and continues it up until 21. It also happens in the juvenile justice area as well. So the court already has been doing this in other contexts and now is applying it here.
Okay, thank you. All right, so I thought it might be helpful to, see if I can get this to change. There we go. to talk about exactly what we're filing in juvenile court when we do these petitions. And along with your custody petition, which is where it most often comes up for my clinic in any case, so that's what I'm going to focus on. When you're filing a custody petition, you have to also file all the relevant forms that you would have to file in any custody petition. You know, you have to certify that no one who has the right to have custody of this child is in the military. You have to show that you've tried to give notice, or if you can't give notice because you don't know the address, then you ask that it be noted on the courthouse door for 60 days. So there is a built-in 60-day delay in cases where you have no way to contact the other parent, or maybe even both parents, if it's a non-parent seeking custody, and show that you have, made your best efforts. You don't have to publish it in a newspaper. You can just post it on the courthouse door in these cases, because in my case anyway, all of our clients are indigent. And then you have to look at the Virginia Code definitions of abuse, abandonment, and neglect, because that's what's required to be shown in these cases, that there is either abuse, abandonment, or neglect, or in some cases all three, and that therefore the court can make a best interest finding related to custody as well as SIJS. And so you look at those definitions under Virginia Code section 16.1-228.3. The basic definition is the Virginia Code defines an abused or neglected child as one whose parents create or inflict, threaten to create or inflict, or allow to be created or inflicted upon the child. We do see that a lot in these cases, that the family just is not able to protect the child from abuse or neglect, so that comes in very often in these cases. And then you use those best interest factors, as Tanishka said. You just go right down the statute and show the court all the ways in which it would be in the best interest of this child to stay here. Then you add that extra element of that it would not be in their best interest to go back to their home country. You file a detailed proposed order along with that includes both SIJS, a request for that the judge is making SIJS findings, as well as custody. We used to do those orders separately, but right now the common practice is to combine them. And we have included in our materials a supplemental practice advisory that really goes through this in detail and gives you great examples of exactly how you should create these forms and petitions. All right, looks like I skipped one. All right, so the issue of reunification not being viable, this is required for an SIJS finding. So you don't have to show that the rights of the parents have been terminated, but you do have to show that they cannot properly take care of the child. They can't meet their needs. If the parent has some contact with the child, that's fine. That doesn't negate this process. But what you do have to show is that they're not supporting them, they're not regularly in contact, they've shown no interest in actually being the custodian. And so these are very fact specific. All right, the definition of abuse: physical or sexual abuse of the child, verbal and emotional abuse could be, but that's a little harder to prove unless it's very severe. Rejection of the child because of some inherent characteristic, sexual orientation, gender. Failure to intervene or protect the child if there is an abusive situation in the home, or if there's another family member who might abuse the child and you're not actively protecting them from that. And neglect. So if a parent fails to protect the child from domestic violence, for example, which unfortunately we see in a number of these cases, by not leaving the relationship. We see that, of course, in custody cases every day that aren't related to immigration. Parents don't provide adequate food, don't take the child to medical appointments, don't allow them to go to school, require them to work instead. Failure to follow through on a child support order, failing to provide visitation, all of those kinds of things. All right, sorry, this is finicky. Abandonment. So what is abandonment? This one can be very challenging to show, but typically the facts are there if you do a little digging. If the child was abandoned by the parent, they did not provide support, they didn't stay involved in the child's life, that's obviously a little easier to show. But sometimes it's a little more complicated than that. Or if the father abandons the mother while she's pregnant and never even has contact with the child. If they leave and fail to maintain contact, come here, for example, to work and fail to maintain contact or provide support, or they send a child alone to the US. And most of the time, these parents are doing this out of desperation, not because they don't love or want to protect their children, but we do have to sometimes make that argument that they did put the child in harm's way by sending them alone. That is abandonment, obviously. These can be very challenging to talk to our clients about because this is very personal and very emotional, but so meaningful. So when you're looking at whether it would be in the child's best interest to return to the home country, the arguments that you're going to be looking for are that there's no one there that can take care of them. There are medical conditions that require treatment that won't be available for that child in home country. They would be forced to go back to working or be in an abusive or neglectful situation. There have been past threats by gang members or injuries by gang members. Unfortunately, some of these kids have been very seriously injured by gang members, and that's part of why they left their home country, and we do have to sometimes put on that evidence. How do you put on the evidence? Through testimony, affidavits, police reports, court records, foreign medical records, home studies from home country, country reports about the violence that show that this is, that our clients are not making up these horrific stories, that it really is happening. These are all the sorts of things that you might have to put on. Sometimes you put it on directly through testimony, and sometimes you put it on through proffer. Most of the time these days, in my experience with these cases, probably just because we've done so many of them in front of the same judges, they rarely ask for testimony. They typically have read our pleadings beforehand and rule on those. And actually, I'm happy to say the clinic has been successful in all of our cases so far. These cases are winnable. I really encourage you to give them a chance because we've never had, we've only had to appeal once or twice and then succeeded in circuit court. All right, let's see. So that first return, typically in my cases, we go ahead and do the hearing that day because we've filed such thorough pleadings. And again, there are great examples in that best practices advisory that usually the judges go ahead and rule that day. But if you have a situation where they're not quite ready to, maybe it's a substitute judge who isn't comfortable with these cases, hasn't had one since they retired, they may want to only do a temporary custody order. They may want to do a permanent custody order, but please ask them to make it temporary so that you can come back and ask for SIJS findings, because you do have to have another reason to be in the Juvenile and Domestic Relations Court. So you want to keep that open so that you can make those arguments about best interest. If you miss that opportunity, it's much more complicated to get back in and do it. You have to have a reason to amend the petition, and that's not always there. So do try to do that. As a GAL, if you're a GAL in one of these custody cases, really look at whether it's possible to consider SIJS findings as well. A lot of times they will just do all of it in one hearing, and I actually haven't had a judge even want to amend our order in any way in years. We've just, I think, gotten to the point where everybody understands how important this is, at least in this area in Central Virginia. So when they sign that order, you want to make sure the guardian ad litem signs it as well, and you want to make sure that it does include all of the elements of the SIJS, all 5 elements, and particularly that the judge makes a finding that it would not be in the child's best interest to go back to their home country. All right, so some common issues that come up. These kids often don't know that they have a right to special immigrant juvenile status. Their families aren't aware. And they've gone through so much just to get here and start to learn English. And the last thing they're thinking about is going back to, some sort of legal process. So they don't realize it oftentimes until they're a little bit older. So sometimes we have a 16 or a 17-year-old in this situation. And so it used to be that the court would lose jurisdiction at 18, no matter what, even if there were pending matters in the juvenile court or a custody petition that had been decided in the juvenile court. But now, as long as we have gotten, the court has taken jurisdiction in the case before the child turns 18, you can go back and ask for SIJS findings up until 21. This has been a very helpful addition to our toolbox. But you do want to motion the court for an emergency hearing if the child is 17. You want to get into court as soon as possible because sometimes judges will say, why are you asking for a custody order when the child's turning 18 so soon? So you want to be prepared to argue, as is accurate, that these kids still very much need the intervention of a guardian. They're often behind in school, they have medical conditions that need to be addressed, they wouldn't have, the ability to work, so they're not able to support themselves. So there are a lot of reasons that they still need a guardian involved in their lives. So I've not had a judge reject that argument in these cases, and hopefully you'll have the same success. But as long as you get before the judge, before they turn 18, you can go back and resolve some of these other issues if the judge is not quite ready to do it. You can use the emergency temporary jurisdiction statute, section 20-14615. All right. So some common issues. I wanted to touch on the issue of a parent who has passed away. I had a case recently where both parents had died. And it's not technically abandonment under the statute just to die and not be able to support or take care of your child. But if you abandon the child before your death, you have then abandoned them under the statute. And we had that situation where both parents were deceased, but the father had abandoned the children several years earlier and had had no contact with them before he died, and they didn't even realize that right away that he had passed. That, under the court, they did find that to be abandonment, and you do need to make that specific argument and put that specific language in the order that the abandonment occurred before death. And so that's something to really look at very carefully. All right, I'll go back to Mr.
And there's a good case out of California called Eddie E. versus Superior Court that deals specifically with the death of a parent. And essentially, one of the findings is that death made abandonment permanent, like the abandonment permanent. So as Julie stated, if you can find before the death that there was abuse, neglect, or abandonment, then I think you can get where you need to go with the court. So some other common issues and complications in Virginia are the publication and the publication issue, right? Even though this is a little bit of a different kind of case, it still gets treated like any other custody proceeding before the JNDR court. So you have to achieve publication. And, I, in my practice, don't really use the parental consent and waiver of service as often as I do seek personal service wherever possible on the parent. Whether the other parent is in the United States or abroad, we do whatever we can to try and serve that person personally. I think that that's best practice anytime that you can do that. If the parent is inclined to sign a waiver of future service and notifications, then that's also very useful, because then you don't have to keep serving in case, as Julie noted, you sometimes can wrap everything up in the first hearing, but sometimes you have service issues, right? You need an order of publication because you can't locate the abandoning parent. Right, so then by statute, what is it, like 50 some days that need to run? So that the publication can meet the statutory requirement. So it's really important to make sure that service is achieved, and that's probably one of the more nuanced and complicated parts of these cases, but it's totally manageable and achievable. I have lots of tips and tricks. If anybody ever wants to take on any of these cases, don't let this dissuade you. Just reach out to me, and I'm always happy to share whatever I've learned about achieving, service in Guatemala, El Salvador, Honduras, Venezuela, all over the place. Okay, some helpful hints and tips. Some things you have to be prepared for in certain jurisdictions is that this isn't being sought solely for the purpose of immigration benefits. So if it's a custody case, be prepared to discuss all the other reasons why this order benefits this child. So it could be for the parent to obtain passports for the child, or for the third-party petitioner, which we often are dealing with in these cases. We have children being sent by the federal government to live with other relatives like grandparents, brothers, sisters, aunts, uncles, and these individuals do not have the ability to just register these children in school. They can't just consent to medical treatment. They can't get their passport for them. So having an order that gives that person or enables that person to do all these things for this child can be very beneficial. I also always recommend, and I still do from time to time, call the jurisdiction that I'm about to file my pleadings with and find out exactly what that jurisdiction requires. What I'm finding is more and more JNDR courts want separate DC 511s for each custody visitation and SIJ factors. And that's very court specific. You can also find that what the judges individually want is different, and sometimes it's different within the same court. You have some judges within the same court that might want testimony. You might have some that will accept a proffer. I always say prepare for both. Be ready to do either or. It's important to know that I had a recent situation where a judge denied the SIJ findings because the child was having significant mental health issues, had dropped out of school, was just having a very hard time. And the JNDR court judge denied the findings because she said that he hadn't shown her that he was going to be a good citizen. So that to me is not really the call of the JNDR court judge. The call of the JNDR court judge is to say, are these factors in this child's best interest? And then the question of whether they get SIJS status, lawful permanent residence, citizenship, is the call of USCIS or the federal government. And it's sometimes important, it's not necessarily fair, but these young people, once they become US citizens, if they do become US citizens, they are precluded from being able to petition for either parent. I believe that stems back from the fact that you had to be eligible for long-term foster care when the law was established, and then it changed, but that limitation never changed.
Right, so it's obviously a tremendously interdisciplinary field of practice. That's one of the reasons it's so interesting, so exciting. The custody order that Julie and Tanishka have been so eloquently describing, it has multiple readers, it has multiple audiences, it has multiple functions in different legal contexts. And I just want to underscore that one of our purposes here is to demystify this practice for the audience. If there are practitioners in the audience who are interested in getting involved in immigration law or getting involved in removal defense or just SIJS practice, we want to stress that you can do this. You don't have to be a star-studded litigator to get involved. Indeed, I'm sitting here before you as a non-attorney who's obtained relief from removal and in immigration court. And so, I obtained partial accreditation. When we say DOJ accredited rep, it used to be known as the BIA accredited rep, but it was in 2022 that I became fully accredited and was able to practice in immigration court. And in my program, we knew that we wanted to build up removal defense practice in our office, and it was by design through SIJS practice that we learned those skills. And I think it's really great that there was a contrast from Asylum to here, because it couldn't be more of a contrast, where immigration law is said to be famously complex, and that's true, but the learning curve for SIJS is so much more forgiving, and you can totally do this. It's imminently practicable, and so that's one of our goals here. Right, so just wanted to quickly give an overview of sort of the major milestones, and then touch on the key form that lays the groundwork for all of the rest of the immigration law process, and then finally discuss some of the practice pointers. And so, Tanishka already mentioned the difference between an unaccompanied minor and a minor who may have crossed with their family unit. And so one thing that's not mentioned on this slide is if you're working with an unaccompanied minor, you most likely want to start by doing a FOIA request with the Department of Health and Human Services. in order to, at least have as much information as the government has, to, obtain interesting interview notes from their border encounter, from their shelter encounters when they were under the custody of the Office of Refugee Resettlement. But once you have that, of course, the next step with the predicate or custody order in hand is to file the I-360, and that's a petition with the U.S. Citizenship and Immigration Services, which is the primary adjudicating body under the Department of Homeland Security. And your main piece of evidence is that court order with the family court findings. Also not listed here, and something that a new development from 2022 under the Biden administration is the concept of deferred action. So, on a case-by-case basis, once your petition for special immigrant juvenile classification has been approved, then there's an automatic case-by-case discretionary determination of an offer of deferred action to the minor. And so that's essentially a 4-year promise from the Department of Homeland Security that they won't prosecute the removal proceedings if they're not already initiated. And that comes with work authorization. So before you weren't eligible to work until you eventually obtained your green card status, but now with that deferred action designation, you can apply for work authorization and then obtain also your Social Security number. And so then once your I-360 is approved, maybe that's 4 months, maybe it's 6 months, the adjudication times obviously vary. At that time, under the current framework, you can then seek dismissal of your removal proceedings if you're in removal proceedings. And this is something that our previous panelists touched on, but whether or not removal proceedings have been initiated is always sort of an analysis you have to make. And so it's a question of whether or not the Department of Homeland Security has filed that charging document with the immigration court. If they haven't, then the immigration court doesn't even know who your client is. But if they have, if the department has filed that charging document with the immigration court, then you will see pending proceedings show up. And there's really no rhyme or reason to the pattern, or there's no consistency. So we might have folks who are about to turn 20, and for whatever reason, the department still hasn't initiated removal proceedings. On the other hand, and so maybe the file got lost, or maybe there's some delay with the relevant office. On the other hand, I have plenty of clients who are like 10 or 12, and the government saw fit to force them into removal proceedings for whatever reason. And so if they're in removal proceedings under the current prosecutorial discretion framework, and we can talk about what the election may or may not, what impact that may or may not have, but then you're able to seek dismissal. On the other hand, if they're not yet in removal proceedings and they obtain deferred action, then in theory, the Department of Homeland Security is not going to initiate removal proceedings against your client. And then once you have that deli ticket that Tanishka mentioned, then it's a question of, on a monthly basis, checking the Department of State's visa bulletin. And so, the priority date is the overly complex term for the date you filed the I-360 petition. And it's your turn to file for permanent residency when the priority date falls prior to precedes the date that you filed the petition. So, the October bulletin shows that those who filed their petition prior to February 1st, 2021 are now eligible to adjust status. Okay, let me see if I can make this work. Great, awesome. So, this is sort of the procedural groundwork. It's the I-360. It's relatively simple, but you obviously start by filing the G-28, and that's whether or not you're an attorney or an accredited representative or a student attorney. That establishes your relationship between your client and you. And then there's the I-360 itself. So it's a long, winding form that's used for numerous forms of relief, including Violence Against Women Act petitions and religious workers. The actual special immigrant and juvenile status section is relatively brief. Most of the form is blank. Let's see. You attach the custody order. It doesn't actually need to be original anymore. USCIS is increasingly moving towards just asking for copies. It doesn't even need to be the original certified copy. It can be a photocopy of the certified copy. They don't really want the originals in this case. Let's see. And then, of course, if your client was an unaccompanied minor, you'll want to attach the ORR verification of release, and that's just the document that shows that the custody changed from the Department of Health and Human Services to the sponsor. And of course, you'll want to attach proof of the age of the client and their identity. So that could be a birth certificate with a certified translation. It could be a foreign passport. This was loosened up quite a bit in 2022. It could be a foreign consular ID, but you will need to show additional proof of the age of the client and their identity. Let's see. Important notes, you always want to screen for criminal justice contact before filing a petition with USCIS. So, if your client's not currently in removal proceedings, then filing a petition with USCIS, that invites government scrutiny. They could end up in removal proceedings. So whenever you're filing with USCIS, that's just, no matter what, that's an important point. And always you want to make sure to download the latest edition of the form. It changes on a regular basis. It's possible to subscribe to a form update notification, but as a matter of course, it's most helpful to simply download the form fresh every time. Let's see. Okay. And maybe the adjudication takes 4 to 6 months for that. I-360, it seems to change all the time, just the same as the visa bulletin. So this is sort of some of the more additional procedural highlights. Obviously, once you've obtained the predicate order and you have and you've filed your I-360, if the department believes that evidence is missing, or that you haven't complied with one or more requirements, they may issue a request for evidence, or RFE, or they may issue a notice of intent to deny, or NOID. They have one key thing in common, which is that the department is going to ask for additional evidence to satisfy either something that's missing or something that seems to, in their opinion, contradict the rules. And so you have a short period of time to respond to that. I'll be fully transparent, which is I had the luxury of beginning my practice after the Trump administration, and so anecdotally, most of my colleagues are saying that they're not receiving these days in general. Typically, those that do receive RFEs, it's gonna relate to those findings on the custody order, right? Perhaps the factual basis of the abuse, abandonment, or neglect finding wasn't supported in the custody order by the facts that were considered. So maybe those aren't in evidence yet. And it's simply a question, it could be, I'm told by my colleagues, a question of asking the GAL for a letter speaking to what facts were considered during the custody proceedings, or potentially the representative in JDR signing a sworn affidavit attesting to those proceedings. Let's see. And yeah, I know we're running out of time, so I'll touch on something which, well, I guess I mentioned it already, the deferred action. That's a critical component of advocacy while there's a visa backlog. And so, those who are eligible for adjustment today have been waiting since February of 2021. And so, it's important, yeah, that's an additional area for intervention. You can obtain work authorization for your clients. That's a tremendous life-changing moment for your client, and then they'll also obtain a a Social Security card. Let's see. And yeah, once you obtain residence, you can also apply for U.S. citizenship in 5 years. And of course, you want to advise your clients of the importance of staying out of trouble, maintaining their eligibility. Notably, under immigration law, a child, the definition of a child is anyone who's under 21 and unmarried. One of the changes that the Biden administration made in 2022 is that you only have to remain unmarried through the approval of your SIJS status. It's no longer necessary to remain unmarried through to obtaining residency.
I still tell them to wait.
But yeah, and it's important to naturalize as soon as you can, and that's because depending on the type of offense, a single felony or 2 misdemeanors is all it takes to end up back in removal proceedings. So a green card's permanent, but it's not, right? It's permanent residency, but it's not. It's actually not permanent, and it's just tremendously important to naturalize as soon as you can.
Do we have a couple minutes for questions? Yeah? Okay. So do we have any questions from the audience? Yes.
Determination where the JDR judge said, I don't think this person is a good citizen. Did you appeal that?
I sure did. And we were able at circuit court to get the predicate order. So that had a happy ending. So that's the thing. You can appeal, and you can go in and, the other option would be to motion the judge for reconsideration at the JNDR court if you think that maybe there was an argument that you didn't make in the moment that you want to try and make, or you can just appeal up to the circuit court. And we did in that case.
Yes.
Abandonment based on death. So I know you guys said if you can establish abandonment prior to death, then that's a good argument. But what if that's not able to be done? Is that kind of dead in the water?
So, I think you can still make the argument based on that Eddie E versus Superior Court that the death is a permanent form of abandonment. Something that I've been kind of considering and thinking about a little bit is that other similar basis under state law. So if a judge is not inclined to make the finding under abuse, neglect, or abandonment, potentially making it under that other similar basis, citing to the best interest standard. So that reunification isn't viable because it's not in the child's best interest. And that's something rooted in state law, and then you don't have to make the metaphysical, isn't death the greatest abandonment kind of thing.
Okay. Right. Any other questions? Yes.
One thing we've been running into is having issues with certain judges and arguing neglect for the non-custodial parent that lives in the home country because they've been stating that they don't feel comfortable making that argument when it's not the parent's fault because they're experiencing poverty. Have you had a workaround on that? Because sometimes that's really the only driving factor on why a parent is sending them to be with a older sibling or a parent in the US in the first place, is that they just want them to come work. Do you have any ideas on that?
So I would say that asking questions about whether or not that parent is providing any kind of economic support to the child. Under Virginia law 20-81, there's a presumption of abandonment when there hasn't been any financial support provided to the child, or the child is left in a destitute situation for over 30 days. So I think if you can show that the child hasn't received any economic support, then that should be sufficient for the judge to make an abandonment finding.
Any other questions? Before we go, I have to shout out how incredibly proud I am of Emily Lipinski, your first presenter, who learned how to do SIJS cases in my clinic and created incredible guidance for future students that we still use today. So thank you, Emily. You had one other
Yeah.
announcement.
And I want to, thank Julie McConnell and the Children's Defense Clinic for, the 5th semester working together, and selfishly plug that my organization here in Richmond, the Sacred Heart Center, we just opened a legal assistant, a bilingual legal assistant position. I brought flyers. And so if you know anyone who's interested in doing specifically this kind of advocacy, joining our team, I'd love to hand you some flyers. Thank you.
We have one question from the Zoom audience.
Oh, okay, thank you, Carl.
The question is, has anyone had success in getting a child who is older than 18 but under 21 to establish the predicate custody order for SIJS in another state? And if yes, did they have to move there to establish a home state?
Yes. So Maryland is the closest state where the juvenile court in Maryland does have jurisdiction up until 21. Now, the child does need to reside in that state. There does need to be jurisdiction, but I oftentimes will have the family do a consultation with an attorney in that state in order to fully evaluate whether or not it is a viable path for the child. But if you Google SIJ age out, you should find a map that provides all of the states by color coding to where it's up to 18, where it's 21, and where it's kind of like in the middle, like Virginia. So I think that's a useful resource, because sometimes there are other relatives in California, New York, Massachusetts, Maryland, New Jersey, where the child can potentially go, and where it's in their best interest to go so that they can achieve this benefit.
Including DC now, right? Isn't that right?
Mm-hmm. Yeah.
Thank you, everyone.
Thank you.
Thank you so much. We're now going to take a 10-minute break before our next panel at 11. The restrooms the locations are in the program, but they're to the right, and then there's also some to the left. So whichever direction you go, you'll find a restroom. Thank you.
Hello, everyone, and welcome to our session here at 11 o'clock on recent changes to immigration and asylum law. I am Tom Donnelly. I'm an assistant professor of law here at the University of Richmond, so thank you, everyone, for being here. First, I'm going to introduce our distinguished panel before we dig into this really important set of topics. So first, we have Jillian Blake. She's an immigration attorney with a private firm located in Alexandria, Virginia. She has more than 10 years practice experience specializing in removal defense, asylum, and family-based petitions. Jillian also teaches immigration law as an adjunct professor of law at George Mason University. Jillian earned her law degree at the University of Michigan Law School and master's and bachelor's degrees in international relations from Johns Hopkins University. Next, we have Jessica Wright, who joined Hyder Immigration Law as an associate attorney in 2017 after earning a JD here at the University of Richmond School of Law. So welcome back. During law school, Jessica participated in the Pro Bono Immigration Clinic and the Education Rights Clinic. She was honored with the Public Interest Law Association's Pro Bono Award upon graduation. Prior to law school, Jessica earned her BA in political science and philosophy at Christopher Newport University. And finally, we have at the end there, Layla Ayub, who is an Afghan-American lawyer and co-founder of Project ANAR. She has over 5 years of experience as an immigration defense lawyer, primarily working alongside detained asylum seekers and leading collaborative immigration advocacy efforts. She is the 2024 recipient of the American Immigration Lawyers Association Young Lawyer Award. She has presented and written for dozens of immigration, public interest, Muslim, and progressive platforms, and her work focuses on organization, administration, external relations, technical assistance, removal defense, advocacy, and communication. So please welcome our distinguished panelists as we dig into this conversation. So, just to tee up our conversation here, I'd love it if each of you could maybe just take a little bit of time and just talk about your own specialties and just some what you take to be some of the most important recent developments that you're finding on the ground. Maybe beginning with you, Jillian, and then we could go down the line here.
Okay, hello. Thank you all for having me. It's really exciting for me to be able to speak to all of you today.
I've practiced asylum for more than 10 years now, asylum law, and so I've seen, the Obama administration to the Trump administration and then to the Biden administration. So I've kind of seen 3 administrations. And definitely the most difficult time was during the Trump administration. There were constantly, new rules restricting asylum. And I think unfortunately, because of the political situation now, the same thing is happening with the circumvention of lawful pathways regulation, which we'll talk about during this panel. It's a Biden administration rule, but it's very similar to bans that were instituted during the Trump administration. Overall, though, I would say it is a lot better practicing asylum immigration law now, and a lot of that has to do with enforcement priorities. During the Trump administration, everyone was an enforcement priority. Now, and the government attorneys were, pushing for deportation in every case. Now, I think they're a lot more reasonable, and, it's better for the system overall. So I would say prosecutorial discretion and asylum bans and the BIA case law regarding who's eligible for asylum are the 3 biggest things that I think make a difference in practicing asylum law from one administration to the next one.
Excellent. Thanks, Julian.
Hi, good afternoon. I'm Jessie Wright. I've been practicing for 7 years, and that's been primarily removal defense, which is primarily asylum. Most of my clients are from Central and South America, but since 2020, we've seen kind of a shift in demographic of who is immigrating to the US, specifically to Central Virginia. So I'll talk more about that later on this panel as well. I entered the practice right at the beginning of Trump, so that very much shaped my form of advocacy. I have seen the drastic changes between administration, and we are preparing for another administration change, whatever that may be. I can mimic what Jillian has said, that who the president is a huge determinant factor of how your case is going to fare in immigration court. There's not really any bigger factor, but as well as there being, under this current Biden administration, prosecutorial discretion, which I'll talk about in detail later, they're more positive BIA precedent. We're also quite blessed to live in the Fourth Circuit, because the Fourth Circuit has a really positive immigration precedent, and that's not true of the rest of the circuits. Yeah, I'll talk later about the geopolitical issues of how that affects your case in immigration court, how it affects who's in immigration court, and other ongoing global conflicts, El Salvador, Afghanistan, Congo, Ghana, and all of those later.
Thank you, Jessie.
Yeah, so I can share a little bit how I got to where I am now, focusing on Afghan asylum seekers, and then I know we'll talk some more throughout about specific policy changes throughout the last few years. So for myself, prior to August 2021, I was working with recently arrived asylum seekers from various countries, primarily Central American and Haitian asylum seekers who are ending up in immigration detention as a result of trying to access asylum at the border. And that's definitely something that we're still seeing now. And what we've seen in the last few years is various humanitarian responses to humanitarian immigration, so-called crises, that really reflect just sort of a lack of preparation, and we see a lot of disparities in those responses, and that happens across administrations. Definitely the response itself, the policies itself, and the way that they're enacted are very different, but we still see a lot of those same trends of the disparities, of a lot of the underlying threads of kind of diminishing access to asylum, even though they might be enacted in different ways. What we've seen in the last few years with Afghans has included a lot of sort of incremental positive changes, but then we see other responses to different crises that show a response from the government that they really can create more efficient pathways And we're just not seeing that across the board. So there's definitely still many things that impact the way that access to asylum is rolled out to everyone. Yeah, I think we'll all be talking about that a little bit more, what those changes have been recently and how they're impacting different populations.
Excellent. Thanks so much for setting the table. It gives us a lot to dig into here. And maybe starting with something that you mentioned, Jillian, which was the circumvention of lawful pathways rule. I can throw it to all of you, but maybe beginning with you, Jillian. Just talk a little bit about what that is and sort of how has that affected the communities that you work with?
Okay, so this is basically the Biden administration's asylum ban. And the final rule was published in May of last year. And it establishes basically a rebuttable presumption, that's what it's called, but it's effectively a ban for asylum for anyone who enters the United States without inspection between May 11th, 2023 to May 11th, 2025. So unless the person enters with parole, a visa, or an appointment on a phone app, a CBP-1 phone app, they will not be eligible for asylum. So this is a really big deal. A lot of people who are fleeing persecution and violence do enter the country without inspection and apply for asylum and have been able, it's not a factor in granting asylum, but under this rule, many people will be denied asylum protection because of the manner in which they entered the country. Now, in my practice, and I don't know about anyone else, it hasn't come up in removal defense yet in my cases because the rule started May 11th, 2023. The system takes so long to get someone in removal proceedings, get the final hearing. So the first case I have where this is going to come up is in February of next year. So this is going to be something that really, is going to really affect practitioners in removal defense, starting now and, in the future. So it could apply the affirmative asylum process, which we went over the 101. The CFI process is when someone gets an expedited removal, meaning they cross the border, they're automatically put in removal. Whether they even get the chance to apply for asylum is going to be a question, or in removal proceedings when someone's applying as a defense. There are a few exceptions: unaccompanied minors, Mexican nationals, parolees, and there's a CHNV parole program, which is Cuba, Nicaragua, Haiti, and Venezuela. And those people will be able to apply for asylum, the people who benefit from that program. It was paused, it's back on again. Entry with this CBP-1 app, so it's an app that you use to get an appointment at the border, but of course many people can't access that app. And also the wait times, a lot of people, are experiencing harm and they need to enter. Those who have asylum denied in another country will still be able to apply, and those with exceptionally compelling circumstances, which have been defined as a medical emergency, an imminent and extreme threat, or a victim of severe trafficking. So that's just the basic idea of what the law says. It's really important to note that the asylum statute and the convention that was brought up earlier in the Asylum 101 clearly states that no matter how you enter the country, you can apply for asylum. In my view, I don't see how the government's making the argument that this is legal, but they obviously are, and we'll talk more about the cases, the legal challenges to this.
And I mean, do you have a sense, I know you're saying you haven't dealt with it a lot in your work so far, but a sense of how much that escape hatch matters, of sort of like the exceptional circumstances, and how that would differ from a normal asylum application? Like, how much more of a burden are we probably talking about on the ground there?
I think it's going to be a large burden. I think those exceptions are meant to be extremely narrow. So for the medical emergency, like you're about to die, or the imminent threat, someone's about to kill you, severe trafficking victims. So I think those exceptions are going to be very narrow, and it's basically going to be a ban for people applying for asylum.
Okay. Thank you, Julian. I don't know, Jesse and Layla, whether you want to hop in on anything else on this front, but I'll sort of leave it to you, or we can move on.
I will just note, in terms of how narrow the circumventing legal pathways will be applied, it is, I can't read the future, but the actual text of the regulation is written much more narrow than previous asylum bans. So I do agree with Jillian that I think it will be very difficult to overcome the presumption in cases where this applies.
Yeah, I can share a little bit that, I work with many detained asylum seekers who have recently arrived, and some of them are subject to this rule. Most of our cases that have reached the stage of asylum adjudications in detention, they still don't quite apply. But I'll just share a little bit first about how we're seeing the CBP One app playing out. So again, I work primarily with Afghans, and the CBP One app is, it's a phone app. It's been referred to as the Ticketmaster of the asylum world because that's how dysfunctional it is. And it's only available in a few languages. So for many asylum seekers from different parts of the world, that doesn't work for them. And it's also assuming that someone is literate even in their language. So it's available in Spanish, Haitian Creole, I don't know if I'm missing.
I think it's just Spanish, English, Haitian Creole.
Spanish, English, Haitian Creole. So that doesn't cover a lot of the world. And what we're seeing, which I know we'll talk about this and throughout the presentation, but we're seeing many people from various parts of the world needing to reach the southern border to seek asylum because of the various limits to humanitarian pathways. So that's one thing. And then you have to have technology. You have to be within a certain number of miles from the border. So that really impacts how people can access this. And we see that many people wait. They try to access that pathway, and then something happens, and they might have a medical issue that's not considered an emergency, but they have to make that decision to just cross the border. So they abandon that application, or they might wait, and then what we have seen recently is that some people go to that appointment and then they are denied parole, which is what would happen. They would get a parole at that appointment and then be paroled into the US, which would allow them to have temporary permission to stay here. So just to kind of illustrate how it's meant to be the pathway that people are supposed to take, but it's not really accessible. And then what we're seeing in court then is for folks who are familiar with firm resettlement, I don't know if that was covered in an earlier panel, but what we have seen at least is that this seems to be getting conflated with firm resettlement, the circumventing lawful pathways rule. Just the arguments that the government is presenting in court kind of go beyond the norm of like this person spent time in a third country. It's really stretching that further than what we've seen in the past that, for example, for Afghans, many come to the US through a humanitarian visa in Brazil, and that's a temporary thing. They spend maybe a few days there. Some people spend longer, but for many of the people that we work with, they spend a few days in transit. That's the only third country they have meaningful access to. And that visa usually is expired by the time they reach here, but we're seeing these conflated arguments of circumventing lawful pathways and firm resettlement, using the fact that that person didn't seek asylum in that country to argue that they shouldn't be eligible for asylum here.
Thanks so much for that, Leila. And I mean, so we've talked here about the circumvention of lawful pathways rule. You know, the Biden administration also took additional action earlier this year. Can you talk a little bit about how that altered the status quo even further? I'll just open it to the panel if someone maybe wants to talk about that.
I can talk generally about what changes President Biden has made in immigration court. First and foremost is the prosecutorial discretion memo. Prosecutorial discretion is exactly what it sounds like, empowering prosecutors in immigration court, those are ICE attorneys, to exercise discretion. That's a concept that's kind of baked into our criminal justice system. You know, we're familiar with plea deals and counsel striking deals with the prosecutor.
That does not exist in immigration court without a presidential administration issuing a memo. Honestly, the best thing that Biden has done for immigration under the last 4 years is the PD memo. His memo creates 3 categories of enforcement priorities. So people that have certain criminal history, so not even just criminal history generally, but particularly bad criminal history. People with prior immigration violations, so prior deportations or fraud allegations or whatnot. The third enforcement priority, I can't say I'm a huge fan of, but it is people that entered after November 2020. So I assume that that made its way into the memo to appease some people on the right to not have an open border, as they like to say. So it's saying we're not encouraging people to come to the US because you won't benefit from this memo if you come, because you'd have to enter before November 2020 to benefit. However, if you are not one of those 3 categories, which many people in immigration court are, you can benefit from having your case administratively closed or dismissed. And those are pretty much your only options for preventing a deportation order if you have an asylum case that is not very strong. And I could talk about this for hours, but I'll just briefly say that it's not that many people don't have valid fear or will not be in danger if they're returned to their country, but our current asylum framework is very narrow, which makes most of these very legitimate fear cases not win in court. So having the ability to get your case dismissed or administratively closed is a huge benefit. The only difference between those 2 terms, dismissal and administratively closed, is whether or not you can keep renewing your work permit, which is very important to many people. So while that memo is truly a godsend for many families and people in immigration court, the way that it's written is very broad. It gives prosecutors a lot of power, but unfortunately it's individualized discretion, so you are at the mercy of your ICE attorney in your case, and just by selection bias of who decides to become an ICE attorney, you're not always gonna wanna exercise discretion. So great policy, glad it exists. It's not 100% foolproof. So 1 point for Biden, I guess.
That is, yeah, so that is a very good thing. And then another positive thing I was gonna say about that is that a lot of the system is really based on luck and circumstances. Who's your DHS attorney, who's your immigration judge. So sometimes you think, wow, this is actually a really great case, but I know this judge is not gonna grant it for whatever reason. And it's, I think it's very unfair, but sometimes when these cases are terminated, then you can file them with the asylum office and you can have a different person looking at it.
Yes, or if you're eligible for a different kind of relief, such as U visa, or as the previous panel was talking about, SIJS, you can get out of immigration court and then be able to pursue that relief without having to worry about deportation. So it's a really, truly great benefit. It will be the biggest impact to my day-to-day practice if we have another 4 years of Trump, because that will disappear. Another big thing that's happened in Virginia under the Biden administration is the Biden administration has pumped a lot of money into the Department of Justice. So they've expanded the courts and hired a lot more judges to reduce the case backlog. I know there's judges speaking later today, so I'm just slowly scanning the audience so I don't say anything offensive. That we have gone in Virginia from having 1 court with about maybe 7 to 8 judges to having 2 courts with 60 plus. And it has definitely reduced the backlog. Our cases are moving much faster. And there's pros and cons to that as well, but logistically speaking, it means your case is moving faster. It means you need to get evidence faster from your country, from your relatives who don't have access to internet or don't have a way to get to a notary to sign an affidavit. It means a lot of people struggle to pay for their cases because they have less time to do so. It also means that there's kind of a bottleneck effect where all of our old cases were scheduled, you'd have 2 to 3 years to prepare for that final hearing. And then now we have, a trial every week as opposed to every month. So it also means that all of the attorneys are absolutely burnt out. It's scheduling an immigration court these days is insane, and I'm going to leave it at that. But it creates more challenges for clients as we adjust to this new timeline. Since we have more judges, things are moving faster. And also, as I mentioned previously, the Fourth Circuit then this has happened under Biden's presidency, but isn't necessarily credited to him. It's credited to the Fourth Circuit. They've issued several really, really great cases affecting asylum law that have given us as practitioners the tools to make arguments to get around a lot of the really draconian asylum laws.
Thanks, Jesse. And one other thing that you mentioned at the opening, Jesse, was sort of the the geopolitical issues that affect asylum seekers and a lot of these immigration issues. I can maybe begin with you, but also open it up to the rest of the panel if others want to talk about some of those issues, some of those challenges, some of those developments, and the effect that they've had in recent years.
Sure. One of the many weird things about this job is you would never think that a presidential election in El Salvador would affect your day-to-day life, and yet here I am about to tell you about the president of El Salvador. Currently, well, first of all, why this is relevant is that there is a huge Salvadoran immigrant population here in Virginia. So if you practice in immigration court in Virginia, you are going to have clients from El Salvador. Most of those cases, not all, but most of them involve people fleeing from gang violence, as El Salvador has been plagued by gang violence for the last couple decades. They have a new president, who I encourage you all to Google later if you're bored. It's very interesting, who has decided to, he's implementing essentially martial law. It's called the state of exception, and he's doing that to try to crack down on gangs and put everyone affiliated with gangs in jail. To do that, he's had to suspend civil rights. Why that matters to immigration court is that part of winning asylum is that you have to show that you will be harmed on a protected ground if returned to El Salvador. So say you leave El Salvador and you had a very harrowing experience with gang members extorting you, forced recruitment, sexual violence, you name it, all types of violence from gangs in El Salvador. Say you have that, a very credible claim. But then you go before the judge here, and the judge is inundated with research about the state of exception that the ICE attorneys are showing as that El Salvador is now paradise, and we can all live in peace in paradise, and there's no more gangs, like they've disappeared overnight. Judges are denying cases, but they're saying, well, you're not in danger anymore. And part of the problem of why judges think that is because in El Salvador, the president he's truly closer to a dictator at this point, but he's controlling the media. So all of the reports of what's happening in state of exception are, glaring reports of all crime is down, every gang member ever is in jail. But really what's happening is that, say your neighbor was a gang member, well, now you're in jail too, because, you've been caught talking to him. So while people are still very much in danger if they return, sometimes it's for a different reason. Sometimes it's because they'll be in danger of being imprisoned, and within these prisons in El Salvador are massive human rights violations, tortures, indefinite detention, no due process, the whole gamut. So that is really putting more people at risk of deportation to end up in a incarcerated situation where there's human rights violations. But because it's a different fear than they had when they left, it weakens their case.
Yeah, and I found that that's on a judge-by-judge basis.
Yes.
So certain judges are like, state of exception, everything's fine now, the gangs are under control in El Salvador, you can go back and you'll be fine. And other judges are more open to hearing, differing reports from human rights organizations or, different perspectives on that, and, believing that people are still at risk. So I think, as a practitioner, you have to, know what your judge's perspective is sometimes. And whatever it is, you have to bolster the record with your evidence. If you don't win, then, there's an appeals process, so potentially you could do that.
And Jillian, I don't know, or Layla too, if there are other geopolitical issues you want to place on the table that are, important developments for us to be aware of that are shaping asylum and immigration.
Sure. So I can talk a little bit about the situation the last few years with Afghans. And I think this is also U.S. foreign policy, right? It's and I think that's just important context that the policy decisions, the immigration policy decisions the U.S. is making are within this context of people being impacted by all these political changes in their own countries that are directly tied also to U.S. foreign policy. So for Afghans in 2021, when with the US military withdrawal, as well as a couple weeks later, or kind of with that, right, was also the closure of the US embassy in Afghanistan, and large-scale military evacuation. So there's historical precedent for wartime evacuations, and the evacuation of Afghans happened similarly to historically what's happened with other populations. But there have definitely been a different set of policies recently just because of all the recent administrations and changes to humanitarian pathways within the last few decades. So the 80 or so thousand people who reached the US through evacuations in 2021 came here with humanitarian parole, which is a temporary permission to be in the US. And it's not really any sort of actual legal status. And it's more so a discretionary authority that can be used by DHS. So that was used large scale for Afghans in 2021. It has since been used for different populations, like we've mentioned, with CBP-1 southern border arrivals. They get a form of parole. With the CHNV program, that is parole for Ukrainians. There was also a parole program enacted. When people reach here, then they have to do something else and they're impacted then by all these asylum policy changes that we've been talking about. So typically, they have to apply for asylum affirmatively, and they're able to do that because they have that humanitarian parole status. The situation then has been that a lot of people applying for asylum at the same time, and it's been pretty unique for Afghans because there has been some congressional action too, and I'll just note that the congressional action has been different from what has happened for other populations. So there's been a push for an adjustment act through Congress, and that has not passed. For other populations in the past, though there have been adjustment acts that have been enacted, which then gives that population a opportunity to just apply for permanent status in the US because there's this recognition that everyone was fleeing the same situation. They arrived here under the same circumstances, rather than straining the system and also forcing people to go through that process of individually proving very similar asylum claims because they fled under similar circumstances. So that has the congressional action that has been taken, though, has been that there were some legal services authorized. There was also a mandate for the Asylum Office for USCIS to adjudicate applications within 150 days of filing for this population. And what we saw was that wasn't actually happening. And so there has since been litigation to force the government to keep up with that timeline. So yeah, that's just that very case-specific situation, but it's definitely something that we've been seeing impacting a lot of different populations. And the last thing I'll say on that is that parole is really this one of the few things that can be used quickly and large scale for in response to a geopolitical situation that is forcing a lot of people to be displaced and to flee their homes. And what we see is that it's often politically challenged then because of that too. So there's lawsuits. I feel like there's always lawsuits against the use of parole, and it's happening right now. There's several states that have sued the Biden administration for their use of parole.
Excellent. Thank you so much for that, Layla. Thinking about other, policies, we could talk about policy changes. We have the Family Expedited Removal Management Program, which, if anyone wants to chime in about that. And then we also have the Presidential Proclamation 10773. So I just want to place those two on the table and see if anyone wants to talk about those developments as well.
I can talk about 10773 if we can confirm that that's parole in place. I don't usually refer to it by its number. Is that, can we?
That's the
confirm?
border, it's the border.
Oh, okay, I will not talk about
I can talk about that briefly. It really works hand in hand with the circumventional lawful pathways. Once a number of border crossings is reached, then people aren't going to be paroled into the country. More people are going to be subject to the asylum ban. There's also a provision whereby officers don't have to ask people if they're afraid. They have to affirmatively, say they're afraid. And that's really troubling, I think, because people are, they come across the border, they don't know what they're supposed to do, what they're supposed to say. They could be very afraid of returning, but they don't know that they're, the time or place where they're supposed to say that. So I think, definitely asking someone that question is really important. So I think there'll just be the increased use of expedited removal and further restricting an asylum. And I think it really is, just very political with the political climate now, wanting to restrict people applying for asylum at the southern border.
And I will just add, to bring everyone's attention to the historical context for asylum. I think when we talk about it, or if you're only familiar with asylum from the political context of hearing about it in debates or just generally political developments, we tend to lose sight of the fact that asylum is not something that America came up with. It's international law, and it's something that we are supposed to abide by. So when there's asylum bans like this, where the rules turn on and off based on how many people have illegally crossed the border in a week, it's by week, I don't see any way that our government can argue that that is legal. So I hope to see that one is vacated, but I will remain cautiously optimistic about that.
Yeah, and there also are some provisions of the circumvention of lawful pathways that are interesting to note. One of them, it's very strange. There's a family unity provision where one is that if one family member meets the exceptions, all other family members will meet that exception. Another one that's really interesting, that so people who are in removal proceedings, they don't qualify for asylum, they're subject to this ban. Okay, there's something called withholding of removal, which is similar to asylum, but it comes with much fewer rights. It's harder to prove, and then you're never eligible to become a green card holder or citizen, and you can't petition for other family members to come. But there are international obligations where we can't send people back to countries where we know they will be persecuted or tortured, which obviously that makes sense. I feel like that's the bare minimum. So if one family member meets the higher standard, then the rule can change where all of the family members can be granted asylum. So it's very strange, and a lot of immigration practitioners, but you also have to show that those family members wouldn't independently qualify for withholding of removal. So on their own, they wouldn't have their own cases. So the only way they can stay here with this person is to be granted asylum. So this is something that a lot of practitioners are talking about as, you basically have to argue against some of your clients saying, they don't qualify for relief so that they can actually get asylum. So it's something that's very strange. I think it's also another reason why it's illegal is because it's requiring this higher withholding standard for people who are eligible for asylum. And there's clear case law that says, there's a standard for withholding of removal, there's a standard for asylum, and it's saying that to get asylum, you need to meet this other standard, which is not the correct standard. So I think that family unity provision is something that a lot of practitioners are going to be dealing with in and how to move forward, because it's really ethical. It's an ethical problem for lawyers and what to do in those situations. So that's something people are talking about now.
I can just add a little bit also that again, what we're seeing now is more and more people being pushed into more opaque processes that have less access to legal support. So many of the components of some of the recent executive actions are kind of similar to things that were enacted under the Trump administration, although at that time they were enacted very chaotically and quickly, and and just the impact was complete chaos a lot of the time. But now they're being enacted kind of through the slower process, and they're rolling out, and it's a lot harder to know how some of the components will actually play out. So just one example of that is in the most recent action, I believe it included like a faster paced expedited removal process where people get a credible fear interview very quickly, and that credible fear interview is what someone has to pass in order to get access to the full asylum proceeding. So under that was something that was expanded under the Obama administration, and then under Trump it became fast-paced. And for example, we saw executive action that led to interviews happening within a few days, and those policies got overturned through lawsuits that were targeting the unlawful appointment of the heads of those agencies at that time. At least like some of them were. And so one in particular, the one that led to fast-paced credible fear interviews, it was overturned that way. And so what we're seeing now is some of those policies that really limited access to asylum are being enacted in a way that really allows them to stay and to have like a longer term impact. And then some of the other components are just more vague, and we're gonna have to see how they actually impact people. But part of it is like the new standards that are being created in the credible fear process.
Yeah, that's a good point, because during the Trump administration, there was an entry ban and a transit ban, which is very similar. And those were overturned partially because they conflicted clearly with the Immigration Nationality Act, and then partially because of the rules and the comments, the APA rules of how regulations are issued weren't done correctly. So yeah, with the Biden administration, in some ways, it's even more dangerous because they're gonna issue the rule in accordance with the APA, and it's going to be harder. And there's currently, a lawsuit against the administration for these rules. Right now, and I don't know if anyone knows more about this, but as far as I know right now, the government and the nonprofit organization and those lawyers who are bringing that lawsuit are in a settlement negotiation. I think they would clearly, it's in the Ninth Circuit, I think they would clearly win at the Ninth Circuit because the Ninth Circuit already held that the previous bans are unlawful, and it's really the same thing again. However, I think the issue is them not wanting to go to the Supreme Court and create a really bad precedent.
And is that East Bay Sanctuary Covenant versus Biden? That's that case?
Yes, that is the case.
And I don't know if Layla and Jesse, if you want to say anything more about that legal challenge or about any other challenges, important ones that are percolating in the lower courts that for those of us that care about these issues that we should keep our eyes on.
I'll just note that you may be very surprised at how much of the Administrative Procedure Act that we have to be familiar with in immigration because of all of these lawsuits. Because Congress never touches immigration and we haven't had any meaningful immigration reform in decades at this point, all of the changes that you've heard us talk about are coming through executive actions or the regulatory process, which means that they all end up in lawsuits, and you have to know which circuit is better for that. Like if East Bay being in ninth, we're like, okay, that's good. If it had been the fifth, we'd be like, that's not good. Yeah, it's not something I expected getting into immigration, that I was going to need to know all of this stuff, and I've learned a lot. But yeah, it's important to follow the lawsuits to know what the current law is in immigration because it changes every day.
And there's a panel later on Chevron, which I think is really interesting. So it's really going to matter now a lot more, what circuit you're in. If you're deferring more to the courts and less to the administration, it's really good for us here in the Fourth Circuit, but practitioners in Virginia, but in the Fifth Circuit, that's really bad for them. So that'll be really interesting to hear about as well.
And I mean, you've already mentioned it in passing a few different times in this discussion, but maybe just to put it squarely on the table, how would you describe the stakes of the upcoming election for a lot of these issues? In part, one of them being, if it's a President Kamala Harris, to what degree can we expect continuity with the Biden administration, and what might we see, what might be different, and then obviously the difference between a President Harris and a President Trump?
I can answer, but it's not a fun answer. As you've heard us talk about all these asylum bans that were pretty much identical to Biden's asylum ban being regurgitated text from Trump's asylum bans, I don't think any of us are optimistic that if we do get Kamala as president, that things are going to be any different than they have been under Biden, which how I describe the difference between practicing under Trump and Biden is that Trump every day things got worse, and under Biden things stopped getting worse, but they didn't get better either. So that's what I would anticipate from a Kamala Harris administration, is that things hopefully wouldn't get worse, but I don't have hope that they're going to get better, that we're going to undo any of these really draconian asylum laws and regulations. That said, I will probably vote for her because I don't want things to get worse. So.
Yeah, I think it would definitely, for an asylum seeker, definitely Harris will be better. I think that she would continue probably these asylum bans, but there is, the use of parole, the prosecutorial discretion that are very positive, and for those reasons, I think it would be, for asylum seekers, people fleeing persecution, would be a lot better.
Yeah, I mean, I definitely agree with what's been said. I think, yeah, we have many examples of how the different administrations really, regardless of the party, they're building on each other in many ways. And I see that continuing if there's a Harris administration. I'll just share something else that I think we haven't necessarily touched on is that kind of shows this is under Trump, right, the COVID pandemic started, and we saw that authority, this emergency health authority, was used to essentially close access to asylum at the southern border. And that didn't change until very recently, and the circumventing lawful pathways rule was part of this policy that overturned that Title 42 policy that was really eliminating access to asylum at the border. And what we've seen, though, has been that the things that were happening under that emergency authority, under that really unlawful use of this executive power, have just been come through in other ways that maybe it feels a little bit, again, less chaotic, but it's still inaccessible. So the reality is definitely different for people who are seeking asylum under different administrations, but many of the outcomes for a lot of people end up being the same. I mean, again, the numbers show differently, right? But we still have people who are in detention, who are experiencing a lot of challenges with their asylum cases. And I'll just say one last point on that is there were some things that were positive happening that have kind of been taken away too under the Biden administration. And one of those was the lower, the detention caps because of the pandemic, right? Those were things that we wanted to see stay, and we haven't seen them stay. But there have been some small positive changes that would be very impactful to continue, and that just need to be scaled. And some of those include increased access to humanitarian pathways for people outside of the U.S. So there have been new programs like the Welcome Corps, which are building on models used in other countries that increase access to the refugee program. And so I think that's one thing that you would immediately see is if there's a Trump administration, the refugee numbers will will turn to 0, and they were the highest they've been in years this year. So there's definitely a lot of ways that we see the policies like building on each other, but there's big ways that things would be a lot harder for people if there's a Trump administration.
Well, one other thing, it's not asylum, but it's very related, is TPS. So I think temporary protected status, and so there's a number of countries that if you're a national from that country and you're in the United States, you can get this protection, you can get a work permit, you won't be removed. And that would be a major change. You know, during the Trump administration, they were trying to get rid of TPS for almost every country. And that's what a lot of people rely on. So that would be another big change, which would be a lot more positive during a Harris administration. She would keep, I assume she would keep TPS for most of the countries that have it now and possibly expand it.
Excellent. Well, you've done a great job framing a lot of what's going on today, and I'd love to ask you questions for countless minutes more, but I'd like to open the floor to the Q&A from the audience. So if anyone has any questions they'd like to ask the panelists, please raise your hands, and we have microphones that will come over, and so we have someone right here in the front. Maybe just say your name and then ask your question. Thank you.
Hi, Tanishka Cruz. So because you just ended on the TPS discussion, just wondering if you all have seen any uptick in RFEs for TPS, citing smuggling as being an issue for families that are coming with children, and how you're responding or dealing with that issue.
That they were smuggling their own children or someone else's?
Their own children.
I've never seen that. I know that was an issue when previously during the Trump administration, when people would be applying for asylum, then they'd apply for adjustment. There's a big discussion among attorneys: should we, concede that they smuggled their child, meaning they fled with their children, here. I haven't personally seen it as an RFE for TPS. I don't know if you have.
I haven't personally seen it either, but I have heard other attorneys talking about how there's an uptick in that happening.
Thank you. Any other questions from the crowd? Maybe in the back there?
Yes, this is from Zoom. How long can withholding of removal remain in effect if someone cannot become a green card holder or a citizen?
They could have it their whole life. So you can have withholding or removal, you'll get a work permit, you could potentially stay here your whole life. Technically, you're supposed to, every few years, they could ask you to look for other countries that would accept you. Or they could say potentially that the circumstances changed in your country where you can return now. Maybe the administration, the government changed and now it's safe for you. So potentially you could be your whole life here with the work permit, withholding of removal. Potentially, although I've never seen it happen, I don't know if anyone's seen it happen, you could be removed if it was safe for you or you found another country that would take you.
Thank you. Other questions from the audience? Oh, yeah, right here.
Hi, I'm Lucas Henderson. I was wondering if you all have had any experience with pitfalls related to the asylum clock in gaining work authorization.
Yes,
Yeah.
routinely. Yeah, routinely, it's just kind of an administrative nightmare to deal with that with the immigration court. For those of you who aren't familiar, the asylum clock is after you've applied for asylum, you have to wait 150 days or 180 days to be eligible to have work authorization. That count of days is initiated by the court or by USCIS, depending where you filed your application. And there's often just administrative errors from the court or USCIS about entering the correct number of days, and leaves people without the ability to work. So big consequence.
Yeah, I'll also add that many people are pro se. They don't have an attorney because it's not easy to find one often. There's many people who might file their asylum application on their own, and it's one thing that stops the asylum clock is if you're asking for a continuance. So if you ask for more time to find an attorney, for example, that can pause your clock. Or if you get an attorney and they ask for more time because they need to prepare your case. That can stop the clock. So we see that impact people, again, especially those who are in like a fast-paced proceeding. And a lot of people aren't aware of that consequence. So we've definitely we have people reach out to us, for example, who are like, why is my clock on this number? We see also like that in terms of just the administrative issues with the errors in it. We see like families where the children's clocks are running. Everyone's in the same case. They have the same judge, the same court proceeding. The children's clocks are running and then the dad's is frozen. And so he's the one who really needs to apply for his work permit and he can't get it. And there's a lot of challenges that come with that.
Thank you. Hi, this is Phil Story. So I know it might not directly impact your work with your clients, but to the extent that the asylum bans or asylum restrictions have gotten pretty severe, how does that, in your experience or from what you've heard, how does that affect sort of the human rights situation on either side of the border, whether it's the way people are treated by border patrol or the conditions they're subject to on the south of the border?
I can start. So again, I work a lot with people who are like on both sides of the border actually, and recently have been to Tijuana and San Diego, and also met with asylum seekers in Mexico City who are waiting, trying to access asylum. And that includes many people who were eligible for lawful immigration pathways to the US and they're stuck in processing delays. And we definitely see that, especially with like this CBP1 app situation that is pushing all these people into waiting for an appointment, that many people are in areas where there's a lot of asylum seekers who are waiting. And that's something that happened under the Trump administration. There were, with NPP, there were proceedings happening at the border. And so what we saw is many people have to take a bus back and forth to the border. And a lot of those areas are dangerous and people are targeted because they're asylum seekers, and not just that, but they're subject to like policing. So we hear from people who are like, tell us that they've been bused to another part of the country. They might miss an appointment because of something that happened, or they just like miss their bus or something, someone gets sick. There's many challenges with that. People often like lose their documents, or they might get stolen, and that impacts their access to asylum then. And then what we see is increasingly people are, well, at least what I have seen, and again, I work primarily with Afghans. It's interesting because it's across the board. People who worked alongside the US in Afghanistan, the US has their biometrics because of that. And so you would presume that they're eligible often for a pathway here. They're eligible for a visa, and from like a policy standpoint, the US should want to help those people. They have policies in place that are for that purpose, but we see that if they come to the border and they have a CBP1 appointment, because of that biometrics being in the system, it triggers additional screening, so then they end up in detention, and then they have to go through all these other delays. And what we find is that once someone is in that border situation and they're in detention, it's huge discretion to put a label on someone of national security risk, things like that, that are just so broad and really hard to push back on because there's no distinct thing to pin it on. And that definitely applies to people from other communities as well. So yeah, that is kind of the way that I'm seeing it play out. And then also, we just see really that people have such little access to counsel. There's certainly benefits in theory to someone not having a super delayed process, but how we really see that act out. Like, so we had talked about the executive actions that rolled out this faster credible fear interview process, and part of that is CBP asking questions. And so that's taking it away from USCIS, which are like the trained adjudicators, and still even in those interviews we see a lot of issues with access to counsel, or just like someone facing many challenges in the process. But when it's CBP, it's even harder, and so that it actually has raised a lot of questions for many practitioners if they even want to take part in that process, which yeah, it's a very complicated thing.
And I'll just add what may be a not so obvious point, but it doesn't matter how many asylum bans that our presidents enact, people are still fleeing their country. So people are still coming to the border, and not because they want to, because it's their only option. So during the height of COVID, when President Trump used the emergency health provisions to close the border under Title 42, what happened is along those border towns created refugee camps. People from all over the world didn't have anywhere else to go, so they started organizing there. And when you are organized along the southern border, you are at the mercy of the cartels and many other criminal organizations. So you hear from a lot of people, if they were there for any length of time, they had to deal with kidnapping, extortion, rape, all sorts of terrible things. So certainly the human rights issues on the other side of the border, when we have asylum bans enacted, it's only giving more power to cartels and criminal groups to exploit these vulnerable groups of migrants.
Yeah, and I've heard a lot more stories about people being kidnapped by cartels, and like every year it's more and more, I feel like. So, and I think that is because people are having to wait, like sitting ducks, in that area, and it's very dangerous.
Thank you. And sadly, we're at the end of our time, so thank you for the excellent questions from the audience. And please give a warm applause to our wonderful panelists.
That we're going to have lunch served in the Law Commons. So that's if you go down this hallway here, keep going straight, you'll see it right there. It's before the entrance to the library there. I did want to mention that a recent alum, Marley Benyares, is going to be set up near the lunch area. She works with the VCU Medical Legal Partnership, and they're currently looking for help, pro bono help, working with immigrants in the medical system with access to care. And I know we'd be grateful for anyone who would be interested in putting in some pro bono hours with them. We'll be able to provide more info over there for anyone who's interested. But thank you all for being here, and enjoy some lunch.
Here we have one panelist who's been delayed, but we expect she'll join us soon, and we'll bring her into the conversation then. The purpose of this panel is to answer questions regarding barriers to language access that immigrants face in the immigration system, as well as the US legal system more broadly. And I'd like to begin by introducing our 5 panelists, and then we'll get into some questions. Seated immediately to my right is Danita King. Ms. King, after a 24-year career as corporate in-house and general counsel in Fortune 100 companies, became a founding partner of CMG Collaborative Law Offices, which is now Danita King Law Offices. Her work now focuses on mediation services for multicultural, multi-ethnic, and multilingual clients, with a focus on serving Spanish-speaking clients throughout the greater Richmond region. She's certified as a mediator by the Supreme Court of Virginia, as well as an approved ADR trainer and mentor. In addition, she is an approved collaborative law trainer and FINRA authorized arbitrator and mediator. Is FINRA the right way to say that, Danielle?
FINRA's right.
Thank you. She also serves here at the University of Richmond School of Law as an adjunct professor teaching mediation. Danita previously served on the Virginia Bar Association Joint ADR Council and served as chair of that council in 2015, as well as on the Governor's Interagency Dispute Resolution Council. She currently serves as a board member of the Virginia State Bar Disciplinary Board by appointment of the Virginia Supreme Court, and is active with the Hispanic Chamber of Commerce, as well as Hispanic Women in Business. Let's see, I'd like to introduce next Amber Banks, who's to Danita's right. Amber joined the Legal Aid Justice Center's Youth Justice Program as an attorney in 2023. She previously was a staff attorney at Texas Rio Grande Legal Aid, where she primarily worked on education, civil rights, and LGBTQ+ cases in the border communities of the Rio Grande Valley. Amber is a graduate of Vanderbilt Law School, where she was the Garrison Social Justice Scholar for the class of 2020, and she holds a BA from the University of Virginia. To Amber's right is Chelsea Delgado, and Chelsea joined the Legal Aid Justice Center as the Youth Justice Program organizer in Northern Virginia in 2021. Chelsea is originally from Lima, Peru, and has called the Northern Virginia area home since 2000. She has previously done outreach and community engagement internationally and statewide in Virginia, working with the LGBTQ+ community, immigrant communities, and youth populations. She holds a degree from William & Mary in public policy with a concentration in educational policy and equity. And next, I'd like to introduce Hank Bostwick. Hank is a former public school teacher who now serves LAJC as a senior supervising attorney for the Youth Justice Program, where he tackles barriers impacting local access to general and special education services and fosters statewide advocacy to improve the quality of education for all of Virginia's K-12 students. His work in Virginia dates back to 2008, where after serving as court-appointed juvenile defense attorney, in Alabama, Hank joined the Virginia Legal Services community as an education law fellow at the Legal Aid Society of the Roanoke Valley, where he successfully litigated and secured private school reimbursement and other services in the matter DB et al. Against Bedford County School Board, a leading special education case in the Commonwealth, which is routinely cited as enduring precedent. In Texas, where Hank is also licensed, he was the education and special education law team manager for Texas Rio Grande Legal Aid. Finally, I'd like to introduce, in anticipation of her arrival, Flor Lopez Trejo. She is the coordinator and community organizer with the Virginia Language Justice Collective, which she joined 2 years ago. Prior to this role, Flor worked as a language justice community interpreter for 8 years and has been an immigrant community advocate and organizer for 15 years. She also has worked at the Legal Aid Justice Center and with the Free Them All Virginia Coalition. As a queer immigrant, Flor's identities and lived experiences have shaped her values and intersectional approach to social justice. She was born in Chihuahua, Mexico, and migrated to the US after graduating college with a Bachelor's of Arts in Elementary Education. In 2019, Flor was the recipient of the Diversity Richmond Hispanic Heritage Award Viva RVA for her outstanding contributions to the Latinx and LGBTQ+ communities. Please join me in welcoming all of our panelists this afternoon. We have, Flor, welcome. Perfect timing. We just finished introductions. Thank you so much for joining us.
Of course. Thank you, everyone. Thank you. Hi, good to see you.
We have a number of questions planned, likely many more than we'll be able to cover in an hour. And in light of the enormous experience and wisdom of the panel, I'm sure we'll only be wanting more. But let's start with sort of a general question. And perhaps I'll pose this to any member of the panel who'd like to kind of get us started. And that question is, what challenges and difficulties do non-native English speakers face, specifically in the immigration system? Somebody like to get started with that one? Flor would be great, thank you.
And hi, everyone. My name is Flor Lopez. I use she, her pronouns. I am part of the Virginia Language Justice Collective, and I'm the Language Justice Community Organizer and Coordinator for the team. Okay, so I'm gonna start by sharing, just like a story, experience that I had. The worst experience ever that I have had in a space witnessing what someone would call interpretation, right, or language access. I attended an immigration court hearing to support a family member of a friend that was going to be potentially deported. And I just remember like the length of the session was probably like, I don't know, an hour or something like that. And the only moments that interpretation was happening was when the judge was referring to the person in detention to ask them a question or say good morning to them or give the result at the end of the hearing, right? Everything else, the conversation that was happening between the judge and the attorney, a lot of back and forth, right? That was about this person's life, about the history of their case, about what's going to happen to them, if they're going to be offered asylum or not, or deported. Like the person had no idea what was happening because none of that was being provided with interpretation. So I think like the barriers can be us, ourselves, when we are part of those systems and we don't demand that we do better, right? That's not interpretation. That's not even language access. I don't know if I can even call that language access, right? It's very unfair and like just the trauma, right? That involves all that. When a person cannot hear what's happening and it's being said, it's about their life, their past, it's about their future, it's about what's going to happen to them, and it's a matter of death or life many times, right? So I think the systems put the barriers. When we are part of the systems and we let that happen or we don't stand against that, we also are complicit of those barriers. Thank you.
Thank you. The other thing that I find very important is that Americans tend to dismiss those who may be able to speak English fairly well. But what Americans don't realize is that when people are under stress, they revert to their first language. And try, as an American, being upset and being in another place, even if you speak another language, how well do you do? And being able to speak for yourself, you cannot. And that I find it's very unfair. And the circumstances that you put these people, then the other thing, these people being people who are not from the US, think about yourselves. We said, well, you know, they kind of sort of understand English. Think about yourselves from wherever you are in the country. Northeasterners speak quite differently from Southerners, who speak quite differently from those in California. And there are times when you may have people from each section of this country get in a room and not understand what each other is saying, and then put them under stress. So Americans who are working with people whose first language is not English, you need to make sure that they are included, as she says, that they are made as comfortable as possible. That means when you speak more slowly, not disparagingly so, you know, but at least take your time so that they can take a while and process. It's a small thing, but it's a very important thing, because the other signal we send out, and remember, most of our communication is actually nonverbal. The other thing we send out is, yeah, you're not really important. To the other one, we're important and we understand what's going on. And in the meantime, whether you see it physically or not, that person is going to shrink and pull back. We need to remember that if you're representing or advocating for someone, or if, as a mediator, you are trying to help communications.
I really appreciate both the bringing into the conversation people who need translation and sort of in every moment of an interaction, as well as people who can benefit, who might not need translation, but can benefit from other awareness of the speakers around them. Are there other examples of particular challenges or barriers that any of the others of you have witnessed, either in the immigration setting or in other legal settings?
Well, we hope to talk about the impact
of the lack of language assistance services, particularly for the parents of limited English proficient or English language learners in the K-12 context. And so we're going to talk about some of that data and try to give an overview. But certainly, I mean, if they're having problems in the immigration court context, in the general family court context, or just accessing justice in general, you can imagine the difficulties that these parents face in the K-12 system.
Also, one thing that we have seen and that I've heard of in other contexts is people who are from South or Central America who are assumed to be Spanish speakers and are given Spanish interpretation, but are not given interpretation in their indigenous language. And so there's an assumption that they are being given language access, but it's still not going to be their first language or possibly something that they are able to fully understand in. And so I think we have to also address that it's not just Spanish interpretation that is needed, and it can be really hard with some of these languages to find an interpreter who can speak these languages. And I know that one of my colleagues at LAJCU was telling me earlier about an immigration case. They got pushed back multiple years over and over because they could not find an interpreter who spoke the person's indigenous language. And so that's another barrier that I think comes up, that we have a lot of assumptions about what language interpretation should be in.
Thank you. I appreciate the chance to sort of lay the groundwork. The next question that we've planned is a question that asks about the experience of the representative, so the lawyer or other advocate. So I'm curious if you might share a little bit about what are the unique aspects of representing a client who requires language access. I think Danita has already begun encouraging us to think about that. Are there things that the panel would like to add on that subject at the moment?
I can just add that I'm not telling you guys what to do, but when I get a new client, and I was speaking to someone today, it's easy for me. We're a bilingual office, Spanish speaking, and we're familiar with Hispanics from different areas. And we know that the language is different from, the vocabulary is different. And we very quickly catch on that, okay, this is Peruvian, this person's from Ecuador, this person's from El Salvador, and they're gonna have some differences. It really is important, and I know this is something that lawyers don't like to do. It's like, we're facts and you really need to find out a little bit of something about the culture. In representing parents, I'll give you a perfect example. You may think you are explaining to your client, and if you're gonna advocate or represent your client, you really need to understand your client and where they're coming from. And I had a case, there was a guardian ad litem, and the guardian ad litem said, I did a check in that house and, for the child and for custody, and there was nothing in the pantry, and I didn't even see milk in the refrigerator or whatever, and how's this father supposed to feed these children? And now, mind you, the children had been well cared for. And early on, when I didn't know to ask this in advance, and I spoke with my client, and he said, I would never give Americans feed their children that stuff in the can and in the pantry and stuff. I go to market every day. I feed my children fresh vegetables and whatnot, right? But the guardian ad litem didn't know that. And frankly, until he told me, I didn't realize that as well. And I had to talk to him. Actually, he was from Ethiopia, I think. And when I was able to convey that, then the guardian ad litem realized they needed to look into and ask other questions. So that's when I learned early, you're the first contact, you're the front lines level of support. How are you going to advocate for your clients if you don't understand more about your client's background than just the language?
So I also want to add, can you guys hear me well? I'm not sure if this mic is working. I really appreciate that you mentioned that, Anita, because within the Youth Justice Program, we provide a slew of different services, one of which is defending parents that are accused of neglect. So combating the typical notion that because you're low income or because you run your family in a different way, you're necessarily a neglectful parent. And so I think having that cultural understanding is really important in those senses. And I'm not an attorney, but within our team, we do convey a lot of information, both legal and non-legal, to families. And I think when you're talking about how you communicate to, you need to take into account the cultural background of the folks that you're working with, where they feel safe, where they feel comfortable, how you're conveying that information, where you're conveying it. Within legal aid, in the last couple of years that I've worked here, we've had moments where families have actually thought that we were, while we were trying to provide them services, actually thought that we were on the side of police or the county. And we had to communicate that very firmly, that like we were not representing another entity that could potentially hurt them. But when you have families of mixed statuses, that can be like a genuine concern. When we recently did some town halls in the community. We were very intentional not only to provide those town halls in places that people were familiar to, that were walkable and accessible to families during a time that they could be there as well, but also to provide a space where they felt like they could have those conversations by being really intentional about who we brought into that. So if we were asking families, what barriers were you facing in accessing education services, we wanted to prioritize inviting those families over, ironically inviting school officials that may have benefited from hearing that, but could have changed that space significantly in a way that would have inhibited those families from sharing their stories.
Thank you, Chelsea. I want to continue with sort of laying the groundwork by asking a question about translation services, the availability of them, and what, if any, translation services are required, in particular in the immigration context. Amber, is that something that you might speak to?
I can speak generally about the language access that's required under Title VI. I have not worked specifically in immigration, although some of my clients are immigrants working on different legal issues. But Title VI of the Civil Rights Act of 1964 is something that guarantees language access, or at least some language access to folks who are accessing a program or service that's funded by the government. This is considered national origin discrimination, not to have any sort of way for people to understand or participate in a program. And so that could be something like interactions with police, interactions with court officials, in medical settings, with schools, and also like immigration courts. But there are a lot of factors that it's kind of like a sliding scale, how much access, language access, someone is entitled to. So part of that is based on what number or proportion of the people accessing that service need language access, and how often they come into contact with it, how essential the service is, and then the resources that whoever's providing the service has. So something like in a criminal court where you might be sentenced to jail, you have a much higher language access right than you might have in something smaller like in a school. Like we think that schools, you should have as much language access rights as you need, but the kind of factors that are used to look at this are based on, I guess, considering how serious or important the service is and what the impact might be on people. So that's just a small one, and then in a lot of different areas there are additional laws, and so I'm not super familiar with ones that are only focused on immigration, but that is one that applies to recipients of federal money.
Thanks, Amber. Flora, is this something that you might address in the immigration proceeding context? What translation services tend to be available?
Yeah, I think that whatever we have available, like I said, is not even really meeting the bar of language access, right? So I think that, yeah, I'm even thinking, I guess, something that I would like to share is one of the prior questions was like, what are the barriers when we work with people that speak other languages? And I also just want to invite us all to even think about just the framework, right? Take a step back and think about the framework. I think that the barriers to me, right? Like there's no barriers, for example, when we are working with like, I don't know, Spanish speaking members, because I speak Spanish, right? I'm a native Spanish speaker, and to them, to one another in their own communities, like the system is the barrier, right? It's not that they're the barriers, it's the system that's creating the barriers. And I think that we might be able to improve the availability of the translation services in immigration and everywhere if we were really trying to work within those contexts and fields with more equity and representation of the beautiful diversity, like racial, ethnic, language that we have, and that it can be representative. So yes, there's like a lot of lack of availability of services from my experience and what I have witnessed. And the services that they do exist do not even really meet the bar because they are designed to favor the person or the system that needs the translation services. And I think many times it is perceived as the judge needs to hear, right, what the person is saying, or like the attorney needs to understand this declaration in Spanish or things like that. So I think that many times it is about highlighting that things need to be in English, right? And when they're not in English, that is the problem. And I want us to even like question that framework, right? Like, why do we even think like that, right? Like, that's, I don't know, that's not how the world is. And again, I'm approaching these conversations from a very like organizer lenses, not necessarily an attorney, right? But to me, it's like even challenging ourselves and questioning and reflecting about why do we even think that it's like they need to be on the service of us, things need to be translated, interpreted into English, right? How does it look like to start to create like those legal settings, like immigration courts, but everyone else that have that diversity? How does it look like to at some point get to a court hearing and maybe it's not happening in English, right? Like, I think like there's a lot of ways that things could look like in the future. And I know a lot of you, this might seem like very out of the box, right? But I think that like the current legal system and the law doesn't equate to justice. And I think that we can also figure out like ways that we start to transition to systems of accountability that could look a little different than what nowadays we consider like the law and the legal settings. From my perspective, right? I respect that not everyone might have the same perspective.
Something to add for all of you to know is you really have to be careful with translators. Certified translators will do just that. They will translate the words that you use, okay? And that is it. They don't offer explanations. And the poor person that's hearing the translation, they still may not understand what is being said. It may be in their language, but what do they know? The court once, I had a translator say to me one time, what's imputation? Because I said, well, the court can impute income. But the translator asked me, what is that? So that I could interpret accurately. But that was in mediation. In court, they can't do that. All they can do is use the word. The other thing is, when we're having a private setting, whether you have somebody translating for you before you get to court or not, screen your translators. See if you can get somebody that is capable of communicating something so that you can be sure the other person understands. And do what you always do, body language, right? Tone, look to see if the other person actually comprehends. Because without that, when I used to, and the only other language I speak is Spanish, but I have, multilingual cases, but when I used to get, for the firm I worked with, people who were looking to translate for us, Spanish and speaking interpretations. I remember at one time the organization had 5, and they said they put each one of them with me so that I could evaluate them. And there was one who was very good at picking up on the nuances, the words, the understanding, and I would have rated them highly, except that when it was over, oh my goodness, they're so emotional, and just how can you do this when they're so emotional, whatever. And I'm thinking, lady, if you're having trouble working with Hispanics who are emotional, you're not the one that we need to have, okay? I didn't say that to her, but she went down in the translation. If we were in court, that would be one thing, but I need somebody that can understand a little bit more about the culture and help me to communicate, whether it's Spanish or something else. So all I'm saying is do not rely 100% on the interpreters. The other thing I will tell you is when you have conflicting sides, they may not as well. I did a Korean divorce and business mediation, 12 people in a room, lawyers. Each side had 2 Korean interpreters, and they didn't trust the other side. Okay, and this is serious, right? So yeah, that slowed down the process a lot, but there were times when one side, the wife's lawyer, interpreters would say, he just said such and such, and that is not the same things, because we take that to mean, well, if you can't get that straightened out in the language, how in the blazes are you going to get it straightened out in the concepts or the issues you're supposed to resolve? All I'm saying is, please be very careful when you work with interpreters. Get some references, try them out, and don't necessarily rely on the fact that they have a certification or not.
Thank you. I want us to shift into the focus on the educational setting. I know that some of you are particularly focused there. So Hank, maybe we can start with you and ask you to talk about the trends historically in Virginia regarding educational outcomes and language access services, such as English language instruction for non-native speakers, and maybe teach us a little bit about the current state of educational outcomes in maybe some county settings as well.
Excellent, thank you. I was feeling a little lost in the immigration law discussion. I am a special education attorney. I am not bilingual, but I do have a very deep interest in ensuring language access services, particularly for Latinx students in our K-12 public schools. So to that end, our entire team is very interested in that project, and we are focusing in the Youth Justice Program this year at the Legal Aid Justice Center on just that. So we have started collecting data over the summer as it pertains to the receipt of English language services for students in the K-12 context. And so for the purposes of today's discussion, I think the best way to gauge how the Commonwealth is doing is to look at educational outcomes. So we're going to look specifically at graduation rates and dropout rates. Carl, would you hit it? Thank you, sir. Okay, so many of you may know that the Virginia Department of Education is required by a number of regulations to publish and promulgate data that it gathers from divisions across the Commonwealth. They are good at that some ways, in some ways they fall short. They often have to rely on the receipt of data from school divisions themselves. So the reliability of the data is in question. Our retrieval of the data from, and you can see the website here that's noted, and if you have ever visited this portal, you could go on there and there's a significant amount of data that you can access, and you can put yourself together charts across a whole series of topics. But what we did particularly is we looked at English language learners. Specifically, we're going to talk about Latinx English language learners. And in Virginia, we prefer on our team the use of the term Latinx. Maybe you've already had that discussion this morning, but the way the VDOE collects the data is under the term Hispanic. Carl, can you do the next slide? All right. So we decided to do a 10-year sort of snapshot for you all today, and our IT guru, Chris Flores at the Legal Aid Justice Center, has helped me put together this data, so we know it is reliably and accurately taken from VDOE. My interpretation of it, of course, is subjective. But beginning in 2014, these are the number of divisions in the Commonwealth that served Hispanic EL students or Latin EL students. That's it, right? So among those, we've broken those down into female students and male students. So in 2014, the graduation rate for female Hispanic L students was roughly 61%. For male students, it was 62%. Carl, please, next slide. Okay. No, sir. All right, the next 5-year period, we look at female Hispanic EL students versus male Hispanic EL students, and that you could see that the number of divisions offering EL services has increased over those period of 5 years. The graduation rate for female students has ticked up a bit to 72.42%. The male graduation rate actually went down, right? And if we go over to 2024, still trying, Carl, but I'm gonna have to lean on you, brother. Oh, that's all right. And so now we're looking at the most recent data that we were able to pull as of October 2nd, this week. And so the graduation rate on average amongst all the counties in the Commonwealth that are providing L services, right? For women, it's gone up, or female students rather, it's gone up to just over 81%. For male students, it's gone up just about, well, from that period of time, just about 8 or 9%, maybe less. Now, let's look at some more granular data. Next slide, please, Carl. All right, so between the years of 2021 and 2024, those 4 counties served the most number of L students in the Commonwealth: Chesterfield, Fairfax, Loudoun, and Prince William County. Now, I got to get over here a point. So if you've broken it down between the graduation rate, and these are the racial identification categories in the Commonwealth, all right, from American Indian to white, not a Hispanic border. And we took a special look at Hispanic student body, right? And for those Hispanic students in our schools who are not EL students, the graduation is roughly commensurate with all of the racial groups, 93.1%. But when we look at if they are, and this is in the female side, if we look at if they are English language learners, the graduation rate goes down significantly. For male students, we're talking about almost 90% graduation rate, but if they're L, 53.53%. So just almost 54%. And the dropout rate goes up, right? And let's look at 2024 in Chesterfield County, which is right here around the Richmond area. Next slide, please, Carl. In Chesterfield County in 2024, all right, we'll notice though, right, that the number of students has gone up almost. You'll go to the next slide too, Carl, just want to toggle back and forth. The number of Hispanic students, both male and female, in Chesterfield County over the last 10 years has gone up 743%, right? Can you go backwards, Carl? Okay. All right, now for males, it's the rate of graduation, the graduation rate has gone up almost 19%, and for female students, it's gone almost 4%. All right, now we could tick down to Fairfax County. One more slide. All right, now we're looking at Fairfax County, right? And so back in 2021, out of the number of, if you'll notice the number of the students in this cohort, non-English learner Hispanic students graduated at a rate of almost 98%. And for females, almost 76% if they're L, right? But for male L students, 63%
Yeah, 63.11%. Next slide, please, Carl. So when we get to 2024, we notice that the graduation rate for female L students in Fairfax County has gone down just over 3%. For males, L students, it's gone up just over 3%. Next slide, please, Carl, and I'm almost done. But the difference between what happened in Chesterfield and what happened in Fairfax is in 2014, there were 870. Now there are 1566, and it's only an increase of 180%. So what is Chesterfield doing that Fairfax isn't doing right, or vice versa? What can we learn in this data? And what we see primarily, and it seems to be most resonant with our community members that we've talked to, and Chelsea will talk about this a little bit later, is that there is this huge disparity in graduation rates, not just among, not among the Latinx population generally, but specific to students who are English language learners. Is good?
That's great.
Yeah.
Thank you.
You're welcome.
Great is probably not the right word, but a lot to chew on.
Yeah.
Thank you. Now, Amber, I know a question I asked earlier sort of jumped ahead a little bit to something that you wanted to talk about, which are thinking about the bearing that Title VI has on the rights of the students that Hank was just speaking about. Is there anything that you'd like to elaborate on, or should we continue on to ask Chelsea some questions?
I can just briefly talk about what the L students are entitled to, so, and parents, under Title VI, and also some education laws, that Equal Educational Opportunities Act. The schools have to give language access right to children and students. That means they need to identify students who need language assistance because they're English language learners. They need to assess them annually, and they need to give them basically education to help them catch up both in language and also stay on track for graduation. So that's kind of the general goal, is they are supposed to be able to graduate on time with their peers. Virginia does have a law that says that students who start school in Virginia after the age of 12 and are identified as English learners can actually stay in school until the age of 22 if the school board provides for it, which most school districts do. Recognizing that for students who are starting to learn English a lot later, it might take longer, but for, in general, they're supposed to be kept on track for graduation rates. So based on some of this data, it seems like that's not happening. And then there's also some extra specific rights for students who are special education students to make sure that their rights under disability law are being met and their rights to language, and that they're not being assumed to be in need of special education services just because they're not fluent in English, or vice versa, not having their special education needs met because it's assumed that their only issue is that they don't speak English.
Yeah, and some recent data from Education Week in 2003 suggests that amongst L students in Virginia, 99.2% of them are receiving services. So we're somehow doing a good job of getting services to Ls. The services that they're getting are just not doing the job, apparently, looking at the objective data that we all just reviewed. So our sense is that there may be a correlation between the lack of robust enforcement of Title VI and its vital documents requirements, that those be translated, and lack of robust enforcement through in school divisions, as well as the Department of Education, for rights under the Individuals with Disabilities Education Act that students are entitled to, specifically LEP parents of students with disabilities who have the right to have interpreters in IEP meetings or have certain parts of the IEP meetings, as Amber was, or IEPs, as Amber was discussing, translated. One other thing that I wanted to bring up, and I don't want to be controversial, but I certainly do believe that it could have something to do with the tone, as if you will, in the Commonwealth as it pertains to the provision of L students, particularly to immigrant Latinx families. And one of those is that the Code of Virginia in section 22.1-212.1, and it's titled Obligations of School Boards, and it says, pursuant to the code section that makes English the official language of the Commonwealth, school boards have no obligation to teach the standard curriculum except courses in foreign language in a language other than English. So, I mean, there could be times where this is setting up a situation where there's a systemic bias in the law as it pertains to the provision of EL services in the Commonwealth. So I just kind of wanted to throw that out there too. And we're trying to determine the potential constitutionality of that provision, particularly under Title VI.
I mean, I think Flora got us started on this, but the weaving into this conversation of structural questions seems essential, and I really appreciate that. I want to transition to asking Chelsea to join in the conversation, but I want to let the audience know that we have about 15 minutes left in our hour. I know we have some questions from folks who are watching online, and if any of you has a question, I'd like to turn to that in just a couple of minutes. So first, though, let me pose to Chelsea a couple of questions. Could you tell us about your experiences and challenges in your work organizing with immigrant and Latinx communities on education matters? And maybe in particular, you could tell us about the Youth Justice Program's Latinx K-12 Language Access Town Hall project.
It's a mouthful. So, I think one of the challenges in working with communities is particularly those that are immigrant, is that oftentimes a lot of the immigrant folks that we work with are in survival mode. They have so many things to worry about with immigrating and like understanding a completely new system that, this is not any comment on like their dedication to their children, but that's just an issue that ends up falling on the sidelines. Not because of a lack of care, but because on top of everything that they're dealing with, it's not the first issue that comes to mind. So oftentimes when I'm working with community members in Northern Virginia in particular, I start to tell them, I introduce myself, I'm like, I'm an organizer, I work for the Legal Aid Justice Center. And their first questions are, can you help with my housing? And can you help with my immigration case? And obviously we provide some services in those fields within our organization, so I do transfer them there. But it's like we can't really have that conversation until their needs, their primary needs are met. I think within the Youth Justice Program, which primarily focuses on education and family cases, so thinking again about like family separation and then juvenile justice as well, what we found, and what actually was an impetus for us to start the town hall series that we ended up doing, was that as parents were calling us, and usually folks as a legal aid, they call us as their last line, right? They were calling us because they had a case in school discipline, or their child wasn't getting their special education services, or they didn't know how to navigate it. Oftentimes we were uncovering that the underbelly of that was that they did not know their rights, and they did not get services interpreted and translated so that they could be informed participants in their child's education system, which is a huge problem, right? Like, I know many of us that like are parents or work closely with families. That's a crazy idea that you do not even know what's happening with your child. So that's where this really came from on the legal sense. But in terms of community, Northern Virginia, and really like, if you look at the entirety of the state of Virginia, we're browning in the sense that immigrants are moving all around the state and the country. And so something that was coming up with community partners was that oftentimes new immigrants did not know their rights when coming into this country, and were coming from a completely different background also in their understanding of education. So they didn't know, for example, if you were coming and you were precariously housed, you didn't know that you had the right, your child had the right to go to school. Or if you were enrolling your child, sometimes you would be ping-ponged amongst many different service providers until you found the right district that your child belonged to, which is really easy in an area as populated as Northern Virginia as well. So we identified that this was a barrier that was happening, and we also identified that amongst our community partners, it was happening primarily, or specifically with the Latinx population in a disproportionate rate. And so that's how we started this series of town halls. And we recognize that immigration is much bigger than just the Latinx community, right? There are so many different demographic groups. So this is just a starting point. But it really was an effort to like start honing in on like informing folks about their basic rights and letting them know that they were entitled to them and that we were a service, to then continue the conversation. And one thing that we found through our town halls as we were talking to community members is that they were not aware that they were entitled to interpretation and translation services. Oftentimes, children were utilized in place of actually having a professional interpreter. And two, as we start, we talked a little bit about the cultural nuance also when you're communicating with other groups. Oftentimes these families also didn't know, like when we were thinking about like special education, for example, what a disability looked like, and how to communicate that in a way that they understood and could support their child. So really just like providing information and then building that trust to have more conversation, I think has been really important for us as a team.
Thank you so much, Selshi. Let's turn, I'm sorry, Hank, did you want to?
Well, I was going to just mention two small anecdotes from the town hall that I was able to participate in. And just think about if you're someone who doesn't speak, that your native language is not English, and your child is put through a general education disciplinary hearing. Well, those things move fairly quickly, right? 3 days. And so we don't routinely see at LAJC amongst the cases that we intake, in fact, in the parents that we polled through the town halls, where those types of documents are being translated into Spanish. And so you can imagine the consequence of a parent or a child missing something like a disciplinary hearing. And in terms of one of the things that I found really interesting that parents brought up is that, students, L students will get stuff in Spanish about being on the football team or being on the soccer team, but when it comes to the academic club or the chess club or the debate club or things like that, the same notices are not being translated. And one of the things that federal guidance in relation to Title IX, or interpreting Title VI rather, requires is that parents of L students have the same access as other parents generally, even to information about extracurriculars and clubs and sort of things like that. So whereas we do notice from time to time that parents will have interpreters at IEP meetings or the requisite documents, the bare minimum standards will be met under IDEA. There's a whole host of things. I could just go on the board docs of your local school division and click on the board policy manual. You will not see it translated in Spanish. And so parents will have to rely on something like DeepL or Google Translate or something like that. And one of the important things, and Amber, it didn't really even occur to me until you mentioned it this morning, but it's been something I've been thinking about too. I mean, that's almost like, we're talking about discrimination based on differences in nuance of the Spanish language, or and that sort of thing, or fluency discrimination too. So anyway, I just wanted to add that before we ended it.
Thanks, Hank. So I know we have people attending virtually, and I'd like to see if we can take a question for the panelists from among that group.
The first question we have from the Zoom is, how can we incorporate a trauma-informed approach with interpreters when the interpreter may not have awareness of the trauma?
Can you, I didn't hear all of it.
Could you repeat the question?
How can we incorporate a trauma-informed approach with interpreters when the interpreter may not have awareness of the specific trauma?
Well, were you going to say something? No, please, yes.
Yeah, I think that it's all about setting up the space and taking time to prepare for anything that we are going to request interpretation for, right? And Yes, everything, some of the things that my colleagues have shared, right? Like I agree so much, I want to echo, like it's not just about the translation, it's about the cultural nuances, right? It's not about just word by word. Google Translate is not going to do the same. Let's not even get into the conversation that some people might not even read in their native language, right? Like, so all those layers exist. So it's always thinking about how to prepare with advance and anticipation. And that needs to happen both in the setting with interpreters, right? Like part of these like certifications, courses, like need to be always inclusive of recognizing vicarious trauma and training interpreters about like coping skills on how to navigate that so that they already have the skills up in their sleeves for whenever like those type of assignments come up, right? So it's incorporating that into the training of all the interpreters, but also on the side of the events, moments, situations that will need us to have a bilingual, multilingual space. How do we actually start to think about it in advance? Many times it's an afterthought and it's like, oh yeah, we also need interpretation. And then we're rushing at the very last moment to find the interpreters, things like that. Like some of the practices that I have with my team of interpreters is we like to ask for materials with as much notice as people can give us. We need to know the context of the event, if people can share like, the script, the program, the agenda, whatever materials, slides that are going to be shared, that's a way for interpreters to prepare ahead of time. And then they might have the opportunity to then choose also if there's something that they're not a good fit for and they want to opt out and have someone else come, right? So it's like training everyone on how to work with interpreters and how to best support them. And then also providing interpretations, the training to know how to develop like coping skills to navigate with vicarious trauma.
Yeah, and if I could dovetail into something, Flor,
I want to try to get a couple more questions.
Yeah.
Should we try, Hank? Yeah, thank you. Sorry to interrupt you. Let's have another question from the Zoom attendees.
Our next question is, are there any thoughts on whether we should spend energy arguing for team interpretation in immigration court where two interpreters swap off during long hearings like they do in federal court?
Yes.
Next question. How about questions from folks in the room? Anybody have a question? Ashlyn has a mic.
Walking around with the mic, so whoever has a question can just raise their hands and I'll run over to you.
This may be our last question of the day.
This is Raya Karimi. Thank you. We have faced some issues with our clients, like whenever they're going to the USCIS for their interview, for example, for when they're having pending cases for their green cards. But their interview is being canceled because of not having interpreter there, as well as we are telling to our clients that whenever they are scheduled for an interview, they have to have an interpreter with themselves. But for some reason, sometimes the USCIS is not accepting the interpreter that the client is taking with themselves. And as far as they are not offering or they don't have any interpreter at that time. So this, I think this makes a big issue, and the client needs to wait more than 3 months after that to being rescheduled for interview, and if there is any solution for this. Thank you.
Thank you so much for the question. Are there thoughts from the panel? It might not be something that any of you has particular experience with.
I do not have experience with that, but my question to the UCA, I already forgot the acronym, but would be one, if they have standards for what interpreters they'll accept, and two, if you can get them approved in advance, so find out who your interpreter you want to bring is and get them approved. I do think that it sounds like there's a larger systemic issue because the person should not have to be bringing their own interpreter, but fighting that might not be what they want to do because they probably want, what they really want is their green card first, and so I would think about that as kind of maybe a larger systemic issue to address outside of the particular client's case, unless the client is down for, delaying their own case to fight and say, no, you're the ones who need to be providing an interpreter for me.
Thank you. I'm sensitive to the fact that we only have about a minute left, but could I ask maybe each of the panelists to give us your sort of 15-second little tidbit, the last few words you'd like to have in the room on this subject?
Sure, I am a very practical person. I think I have like 7 tips for working with non-English speaking people. I think I have materials that you can get on the website. So on this stream, I think all my materials in there, I'm assuming. In which case, there's a lot of very practical stuff because that's how I approach things. And you might find some of that helpful.
Thank you.
Just going off my last answer, I would say the hardest thing for me as someone who cares about language access rights, but also is trying to represent my clients' issues, is figuring out when to just do what is necessary to help them right now and when to be looking at the systemic issues we face. And so I think that's always a balance you have to have if you are doing this kind of work, but it's something to be sensitive to and consider asking your clients, like later, would you be interested in helping me write a complaint or being a witness or something and being involved if I want to challenge this policy?
So I think my last words for this would be that, coming into the project that we ended up working on, I thought as a native Spanish speaker and someone that went through the education system in Virginia as an ELL myself, that I would understand it like the back of my hand. I was actually a product of the same school system that some of the folks were coming in from. And to my surprise, there were changes and there were things that I also needed to adapt to. So this is all to say that, when we talk about making the law accessible to folks, we talk a lot about making things accessible to the lay person. Keep that in mind that that's also true to language. When you're translating something, when you're interpreting it, it needs to be accessible not just as legal Spanish or another legal language, but also in ways that are understandably culturally and easily understandable by the folks that are listening to it. That's something that we had to work on intentionally, and it was multiple revisions of the same presentation to ensure that folks would understand it. And even when we were I think a couple of hours before the actual presentation, we got more feedback and it was like, nobody understands that, you need to change that language. But that makes all the difference, right? And folks understanding their rights and knowing that they can ask for additional services, and a child being able to get an advanced diploma versus a standard diploma, being able to go to college versus not being able to, all of these things. So to us, it might seem like an extra little burden, but to the folks that we're working with, it's all the difference.
Yeah, and I think I would just like to add to the question about the trauma-informed care that we got over via Zoom. And I just wanted to say that it's a good instance to bring up the fact that under both IDEA and at present Title VI, there are no standard requirements for interpreters. There may be in a certified court interpreter context, but there certainly are in the K-12 context. So if we want to do some practical change, that might be an area of instant legislation or suggestion or policy change would be to require some standards, including some training in trauma-informed care for interpreters. So thanks for the question.
Yeah, thank you, everyone. The framework that I do work with is language justice more than language access, which is a bar even higher than language access, right? Language access is that, and it stays that, but they're providing access to people. Language justice is about everything that I have been sharing, right? It's about challenging the way that we think about all of these, recognizing that we live in a world, in a society that's multi-ethnic, multiracial, multilingual, and recognizing language is personal and can be so intimate, right? Because it's about how we share our thoughts, our emotions, our feelings, communicate our ideas, our experiences of pain and trauma, but also our most beautiful experiences. All that happens through words, through language. And there's some words that only exist in one language and they won't exist in another one, right? It's deeply cultural also, we were talking. So recognizing all that beautiful diversity that exists in language, and how do we support multilingual, bilingual spaces spaces in a way that we do not expect that one language is going to be the dominant language in the space, right? How do we switch some of those dynamics of power? And language justice is used as a tool to also connect it with like racial justice in decolonize as well, and trying to switch the dominant like culture and dominant language. And if anyone is interested into that, I invite you to research a little bit about that. I send some materials as well. And I'm gonna stick around a little while. I have like business cards if anyone is interested in those things. Thank you.
Thank you all so much.
Versus Natural Resources Defense Council and ended the Chevron deference doctrine, which required courts to defer to an agency's interpretation of an ambiguous or unclear statute that Congress delegated to the agency to administer. The presenter is Daniel Melo. Daniel joined the Amiga Center for Immigrants' Rights in 2023 as senior staff attorney, where he litigates impact issues on behalf of the detained non-citizen community, including petitions for review from agency decisions, habeas relief challenging immigration detention, and FOIA litigation. He is admitted into the 3rd, 4th, and 11th circuits and several United States district courts. His book, Borderlines, explores the political economy of US capitalism and migration from the nation's inception to the present. Enjoy the panel.
Hey everybody, I feel kind of like Jon Stewart up here with all of this space to myself. I'm like news desk, I need some papers to whack on the desk. Anyway, I am going to try to keep you all awake for the 3 o'clock here on Chevron. Oh, my screen's over this way, sorry. And talk a little bit about what this case means or what we think it might mean for immigration cases going forward. And I will put this big qualifier out up front, is that obviously this is a brand new piece of precedent, and a lot of this is speculating at this point because most circuits haven't weighed in on any substantive immigration issues since the Supreme Court overruled Chevron. Next slide, will give you a chance. So just quickly again, I am with the Amiga Center for Immigrants' Rights in the Immigration Impact Lab. We are formerly the Capital Area excuse me, I've already forgotten our old name, Capital Area Immigrants' Rights Coalition. And in the Impact Lab, we try to take up the cases of detained adults and children, and through working with our detained adult and detained children program, develop cases from the IJ level, district court, all the way up through the BIA Courts of Appeal in the hopes of making better precedent for everyone in the detention system and trying to access humanitarian relief more broadly. And so just briefly, just gonna put a quick plug in, we do monthly litigation roundtables, so feel free to sign up and follow us if you'd like to follow more information that we put out on a monthly basis around pertinent impact issues in immigration law. And so here, just very briefly, this is sort of our general approach. I won't walk you through all of it, but just for folks who aren't really familiar with the immigration system, again, we start at the agency level with the IJ, working with cases, working with individuals to develop their cases. And as we work our way through the BIA and up to the circuit courts, hopefully develop impact law for detained clients trying to access relief. So again, briefly, we're going to talk about Chevron today and what happened in Loper Bright and what it might mean. Going to walk through some of the things that we've been thinking about that might be ripe for litigation in the near future. Talk a little bit about, specifically about crimes involving moral turpitude, also called CIMTs, as sort of a particular drill down case study of what this might look like. And then look at a couple of cases. There actually have been a couple of circuits that have weighed in since Loper Bright was decided. And then obviously, if there's questions and we have time at the end, I would love to engage with you all a little bit more. And do feel free to interrupt me. Next slide, please. All right. So as we sort of talked about at the beginning, Chevron was the 1984 sort of watershed decision that said, hey, when the agency looks at an ambiguous statute, we're going to defer to the agency. Even if there's a better interpretation out there, if the agency's interpretation is reasonable, we're going to stick with it. And so that applied obviously not just to immigration, but everything from clean air to financial regulation, FDA, et cetera, et cetera. And of course, subsequent to that, there was the Brand X case that extended Chevron deference arguably even further and said that agencies at times can pick up circuit court cases and overrule them. And so, next slide, please. So along comes this Loper-Bright case, which is a pair of consolidated cases before the Supreme Court this year. And writing for the court in a 6-3 decision, Justice Roberts said, Chevron's done. We are no longer going to defer to agency interpretations under the APA for ambiguous statutes. And while stare decisis still applies and aren't necessarily calling into question every single case that has come before on Chevron grounds, such that it's not going to be a special justification in and of itself to upend a case, nevertheless, we're not going to necessarily defer to what the agency has said this term means, doesn't mean what this statute should or shouldn't, how it should or shouldn't apply. And so whereas before, again, say in the immigration context, we were looking at the BIA's decision around what is a crime involving moral turpitude, right? And we'll get to this a little bit later, but I would invite you while you're listening to me to think exactly, if you're not familiar with this term before, what is morally turpitudinous, and whether that is something that is fixed, flexible, or subject to the whims and mores of your personal morals, societal morals, and just have that kicking around for a little bit for when we get to that part later. But at any rate, arguably Skidmore deference to apply. So the courts are going to still look to the agency's rationale for what it's saying about its decision, but it's not going to simply defer to it without further statutory analysis. Next slide, please. All right, so in starting to think a little bit about what this means for us in the immigration context, we definitely think that there's opportunity here for us to start mounting challenges to BIA precedent without necessarily really needing to overcome any level of deference. This is going to be the easiest, oddly enough, in places unlike the Fourth Circuit, who hasn't weighed in to as many issues from the BIA, right? Because where the Fourth Circuit, again, going back to what Robert said about stare decisis, here in the Fourth, we have all these decisions around humanitarian relief, CIMTs, right? If we want to try to tackle those again, we're not looking at them for the first time because the court has already weighed in on those issues prior. So we think that in some instances, in some instances it is going to be easier to mount challenges in circuits where these issues have never been before the court before and they are looking at the BIA's decision-making, for example, for the first time. Similarly, to the extent that there are decisions, for example, in the Fourth Circuit, that have looked and applied some level of Chevron deference to a past BIA decision, we think that there's still room, especially to the extent that there is extra evidence, extra things that we can point to that would demonstrate that society has moved away, for example, from considering a particular crime vile and depraved. And so anything that falls kind of into that Brand X level of deference might be subject to challenge as well. And there are, of course, plenty of circuit court decisions that did apply some level of Chevron deference to BIA precedent. And again, while there's probably some wiggle room to advance the needle in favor of non-citizens in those particular areas of the law, that is what we've already started to see in terms of looking at some of the cases that we might try to challenge things with, is that it is going to be an uphill battle to get some of the, at least the circuit court precedent overturned on some of these prior ambiguous statutes. And so I guess before I go any further sort of into looking at some of the other particulars, I will say that just as a general comment about the Supreme Court's decision in Loper-Bright, we in the immigration bar, I think, at a little bit of a weird spot relative to the rest of the bar, like writ large, in that we see this as an opportunity, right, to really potentially at least advance the law in favor of non-citizens for the first time in a long time. With that being said, right, many commentators, including those within the immigration bar, and I think they're right about this, recognize this as the upending of a very important piece of precedent that is going to have massive consequences for our democracy outside of immigration, and many of them, I suspect, not good. So at any rate, all that to say is that while we are looking at this, obviously, in the context of immigration, I would be loath to not point out, right, that this impacts far, far more than the clients that I serve every day, and it will impact their lives in ways, unforeseen ways, that have nothing to do with their immigration status down the road. Next slide, please. All right, so I've thrown up, you've had so much alphabet soup today, but I'm gonna throw a few more at you. So the INA is rife, the Immigration Nationality Act is rife with different statutory definitions for things that are grounds of inadmissibility, bars to relief, or even the actual forms of relief are rife with terms that aren't very clear. So for example, we have what I just mentioned, the crimes involving moral turpitude, CIMTs. We have particularly serious crimes, aggravated felonies, abuse of a minor, sexual offenses. All of these definitions, again, to some degree of application across the different circuits, have had to go through some form of Chevron analysis because nobody knows, they're not defined in the INA, and we don't really know what they mean outside of, again, what Judge Eggy was talking about in the earlier panel, some level of line drawing, right? And so as IJs, BIA, and the Attorney General have tried to craft language around this through regulation, through decisions, we've gone up to the circuit courts and back and forth again until we've sort of landed on these definitions, which now arguably are all up in the air again. So again, I've just thrown out here some possible ones. I won't get into the nitty-gritty on all of those, but needless to say is that, again, there's so many, even just within the deportability statute alone, that I think there's a lot of room to talk about what these mean after Chevron. Next slide, please. And I've also just thrown up here some other areas where I think there's some room for discussion and litigation and back and forth with the agency about what these things mean going forward. And that includes things like for fear-based asylum, fear-based relief under asylum law, for example, we have what does a particular social group mean, right? Again, the BIA has historically defined that one way. Do we have an opportunity right now to change what that means, right? Again, a lot of courts have already weighed in on this, so the answer is maybe a little bit, probably not a lot, right? But nevertheless, right, there is this space now that's opened up for at least some new creative lawyering around what this might mean and how much do we have to actually listen to the BIA on this. Similarly, again, there's things like nexus. What does the extreme and unusual hardship mean? That has also been before the Supreme Court recently, and the court has said that that is a mixed question of law and fact, so we have judicial review of that as well available to us now. And again, just sort of as other asides, we've got everything from what ICE and USCIS and CBP think 1226A versus 1226B detention means, and whether someone is eligible or not eligible for bond. All of these interpretations now are, again, arguably under Loper, are no longer subject to any deference to the agency. There was briefly sort of a line of argument, and what I've seen and heard from some folks is that the DOJ has started to move away from this. But there was a line of argument that under section 1103A that there was already sort of an express, almost Chevron-esque delegation of authority and deference given to the executive in this area, to the Attorney General, so that they didn't need Chevron anyway, right? And I suspect that while, again, they may be backing away from this in terms of expressly making this argument before courts, one of the things that we're starting to talk about and are concerned about is that even if we are able to gain some traction on some of these arguments, there's still a degree to which immigration is a sovereign prerogative. And so there is already some level of indication from SCOTUS down that we're only going to be able to walk this so far before they say that it ultimately is up to Congress and the executive to do these things that may not be constitutional or sound if applied to citizens, but nevertheless, we are perfectly okay with doing to non-citizens. Next slide, please. All right, so we're gonna take a little bit deeper dive now into crimes involving moral turpitude, sort of as just like one area that I think is ripe for litigation and one that particularly interests us at Amica because we represent so many folks in detention who enter the deportation pipeline through the criminal justice process. So CIMTs, again, have historically been defined as conduct that is so vile and depraved that it shocks the conscience, right? But taking a step back a little bit further, and this will become important in a moment when we talk about how this gets used in deportation, they've historically been a way of just getting rid of people that we didn't like in society, right? And so the phrase from its inception was ambiguous because it didn't need to mean anything super specific beyond the people that we didn't like. And so, you know, that included over time everything from folks who had premarital cohabitation, obscenity, homosexuality, have largely been grounded in gendered honor cultural norms throughout our history as a nation, some of them predating our actual history itself as a nation. Regardless, even though the phrase itself is at least as old as 1891, it's never been defined in the Act. So we've literally been making it up this whole time. Next slide, please. So again, it's on that basis we think that while we've tried to advance, for example, frameworks that say that this statute is unconstitutionally vague, because again, what is this word, what does this phrase even mean? Haven't had a lot of success. We do think that Loper is at least an invitation, right, to start having those arguments again about how can we utilize this term in a way that if it isn't constitutionally, just completely unconstitutional for vagueness, has some kind of boxed in meaning that people can know what it means when we say it. And again, I've talked about it enough in enough places that I have yet to have anyone come up with a coherent definition that survives much questioning. But at any rate, we're going to take a shot at it here today together. All right, so next slide, please. Before we talk, though, about the specifics, to sort of pull back this point about it means whatever we want, that matters because the consequences attached to just this, right, crimes involving moral turpitude, are incredibly dire. There's a fairly famous quote that is floating around there on the internet of an immigration judge who said that most of these cases are like trying death penalty cases in traffic court. And so in this particular instance, right, for CIMTs, we're talking about, again, folks getting convicted of conduct like petty larceny that are being faced with the possibility of death in their home countries for that conviction, right, because that is considered a crime involving moral turpitude. So again, we can and have deported people for homosexuality. And it was actually only very recently, in some cases, that we have upended some of those laws as CIMTs on constitutional grounds. So anyway, I've just laid out here some of the rather draconian consequences for having a CIMT. Even if you're a permanent resident, you can be removed if on certain grounds for CIMT-related conduct. There are all kinds of other penalties that attach as well. There's beyond just removal proceedings, you stop the clock in terms of accruing enough time to be able to apply for certain forms of relief. It is a bar for good moral character, so you're not able to move from that legal permanent residence, which is anything but permanent, move from beyond that to naturalization, and can result in mandatory detention while you're going through the removal process. Next slide, please. So again, right now, as it stands, the CIMT definition is generally refers to conduct that is so inherently base, vile, or depraved and contrary to the accepted rules of morality and duties owed between persons and society in general. And it basically boils down to reprehensible conduct and culpable mental state. I'll just note that courts sometimes even get this wrong and sort of consolidate those into one. But we note here that are some circuit-specific differences in terms of how this breaks down. But this has been the definition, right? And so we've had to cabin all of our arguments of late, up until very recently, into that. Can we say that X, Y, or Z conviction is either not inherently depraved because it lacks reprehensible conduct, or because it lacks a certain culpable mental state? Next slide, please. But now, let me finish talking about it. So pre-Loper, right, again, we have, you'll notice in the Third Circuit, right, this conviction for sodomy is a 2017 decision, finally saying, hey, it's not constitutional to remove people because they're gay. And here again in the 11th, finally acknowledging that, well, society has changed its view, right, on the legalization, decriminalization efforts around marijuana. So we're not going to say that these particular Arizona trafficking offenses are CIMTs. But these are outliers by and large. Again, CIMTs have been used very successfully to prosecute mostly poor folks with miscellaneous substance problems. Next slide, please. So here in Ortega-Cordova v. Garland, we have actually here in the fourth was Ben Winograd's case. Folks might be familiar with him. If you do litigate in immigration at all, you will see his name at some point here in the fourth. But took up to the fourth after Loper. We've got this case challenging whether Virginia's solicitation of prostitution offense is a CIMT. And there were some novel arguments that Ben brought that we hadn't really seen quite like this for the first time in a while, around social thinking. So rather than trying to make a strict elements to offense kind of argument under the categorical approach, which is what we use for analyzing crimes involving moral turpitude, he brought some novel arguments forward and said, well, sex for hire, paid sex, society has changed its view on that, and in some places in the country it is perfectly legal to do so. And so therefore, it's arguably falls outside of that window now of what we could say is so vile and depraved that it shocks the conscience. And introduced polling data on prostitution and decriminalization efforts, and sort of, again, that inquiry is focused on what is the least culpable of the acts in terms of meeting the CIMT definition. And so a consensual act where money was exchanged, sure, but a consensual act between two adults arguably just does not rise to that level of reprehensibility. And so again, sort of pushing a new line, if you will, in the sand around what we would hold out as morally turpitudinous. Next slide, please. Sadly, a deeply conservative panel denied the petition for review and ultimately found that there is a social consensus. I disagree with them, but there is a social consensus that prostitution and conduct facilitating it violate a moral rule. And so despite the fact, again, that we have some of these novel arguments and that there was no need at this point to defer to the BIA's interpretation around this, We nevertheless ultimately had the court essentially doing exactly that, despite, I think, some fairly strong social science to the contrary. And we still think that that approach, that model, if you will, is really viable in other contexts. While ultimately it's not going to win the day every time, I think this is exactly the kind of creative thinking that Loper sort of invites all of us to do, right? Is to, okay, if I were to throw out the BIA's idea about this entirely and start from scratch, what would I come up with, right? If I were to write, because if I'm stuck with this statute, right, and we are, at least for now, if I were to write the definition of this in the most non-citizen friendly way, how would I do that? And then from there, how are we going to back that to the court when we get there? Next slide, please. And so I've got one other case for you this afternoon around CIMTs from the Ninth Circuit, also very recent post-Loper. And again, sadly, challenging the BIA's decision in Diaz-Lizarraga, which held that, again, that this form of petit larceny actually is a CIMT because it's enough of a permanent taking, basically. And so, again, here in the Ninth, we came and tried to push back on this version of the definition and say this municipal petit larceny statute clearly is not so vile and depraved that it shocks everyone's conscience when they hear about it. Nevertheless, the Ninth said, well, yes, Loper, but we're still going to apply a Skidmore level of deference to this, and we don't see any issue here, right? Sure, the taking only has to be under, I think it's $1,200, but it's enough. It's enough money, it's enough reasoning from the BIA, and ultimately, theft just seems bad enough that we're going to follow the BIA on this one. So while they are seeking rehearing, so far we, at least as a movement, have not made any immediate gains on Loper. But that said, to take a sort of a broad step back, again, to talk about some of the creativity that we've already seen exhibited going into these cases, which I think is going to be the difference between gaining ground and not. But the other thing too is that the court, I think, in Loper, in taking that power grab, also invited litigators to put new feet forward and start thinking about the law, not just as sort of, well, we're stuck with these frameworks that the agencies have done and we might be able to get some wiggle room here and there, but to go back to Judge Eggy's description of things being going from, what was it, like a 50-piece to a 3,000-piece puzzle. I think it's completely upended the table because now we're not just talking about all of those pieces, right? But I think Loper has invited everyone to say that we get to question where each of those pieces go. That where the agency says this is a corner piece, we get to say, is it though? Where the agency has, pulled together some stuff here and said, this is what the picture is. I think we get the opportunity at least to push back and say, you don't get to start from there, right? That's not an accurate picture. And so what I've been trying to do in our own practice and thinking about this going forward, and what, to the extent that you all are thinking about practicing in this area, is to really take up and start reading the statute again for the first time from scratch. I was guilty of this as a practitioner starting out, is that I simply started with the cases and might flip back to the statute, and because you're taught, right, that you have to pick up where the agency picks up its interpretation. But if anything, is going to be successful, I think, in looking at some of the other cases that have gone up to the court recently in immigration, very nuanced, very esoteric bits of the INA that have gone up on decisions. And I don't think that's going away, because I don't think that Congress is going to act anytime soon. And I think that's the other half of what ultimately the upending of Chevron really means for immigration, right? Is that the judiciary has firmly placed its foot now in this. Whereas they had long said it was the purview of Congress, of the executive to decide who's in, who's out. Having seen that that mess has just gone around in circles, I mean, again, the last meaningful piece of legislation that we've had around this was IRA 1996, right? So then that honestly was dealing with a problem which was then already 20 years old. So we're so far behind trying to address all of the push factors that are bringing people here. And the court has said, well, I guess we're going to get in on this too, right? And try to help sort this out. You can decide for yourselves whether or not that's good or bad, but nevertheless, I think we are entering sort of a new era, if you will, of litigation around immigration, around what these terms mean, because I really do think that we, for the foreseeable future, until it reaches a breaking point, at least are going to be stuck with the INA as it stands. And so, again, not just along the Fourth Circuit court level litigating things, but we're also starting to try to think about what does it look like to bring novel challenges in district court, right, to agency regulations. For example, there is an agency regulation that bars folks who have been designated as arriving non-citizens at the border from any bond hearing at all, period. This designation is entirely up to DHS. There is no challenging it. So if someone arrives at the border and is designated as an arriving non-alien, the regulations say that they don't get a bond hearing during the pendency of their removal proceedings, during the expedited process. That's not in the INA. It's just not. So that, which many of us had just taken for granted, now I think are now starting to go back and look and say, okay, we have let the agency do its thing for a long time, and now we've been invited to try to do things differently. None of that is to say that I think that there is going to be some profound, revolutionary change that is going to come out of Chevron, the death of Chevron in terms of what we get for non-citizens. But again, I do think that at a bare minimum, there is ground to be gained in removing people from the deportation pipeline. I think there is ground to be gained in ensuring that at least a few more folks make it through the hurdles of asylum, SIJS, and all of the other miscellaneous forms of relief that are available to them. But ultimately, I think that it is an opportunity for folks to have new and different ways of telling their story and making sure that that story gets heard, which is really the only thing that I am able to promise my clients walking into any given scenario, right, is that we're going to hopefully get the chance to fully tell your story to the court. Next slide. I don't think I have much more. Okay, so I'll just briefly, in some of the time I have left, sort of talk about some of the other resources if this kind of has got you interested in what might be out there and what else you could read on, follow up on, if you are interested in sort of especially the crimmigration side of immigration. Up top, of course, we have our criminal immigration resources that we publish specific to Virginia. We've got primers, practice advisories, all kinds of good stuff there if you are in the practice of immigration law, especially if you work with detained folks or folks with convictions. The other thing, though, that I didn't think I would have enough time to get to, and I'll just kind of chat briefly about, but if you don't read anything else and you don't listen to anything else I've said today, go read Professor Morowitz's Strict Construction of Deportation Statutes after Loper. Professor Morowitz takes the time to walk way back into SCOTUS's history and talk about all of the ways that the court has actually signaled in the past, at least, that when faced with ambiguity in the statute, it should always be construed in favor of the non-citizen, right? So where these deportation statutes are unclear, the tie should always go to the non-citizen. And so she makes, I think, a very interesting and compelling case for starting to also think about how we can be pushing that line of thinking into those ambiguous moments in the statute. And yeah, the rest mostly is about, specifically about defending and looking at crimes involving moral turpitude. That in and of itself is honestly a whole practice area that you can get super in the weeds on. But again, there's very much a need right now. So to the extent that you are thinking about entering the practice area as well, I would encourage folks to have a look at the intersection of criminal justice and immigration. Because it is far and away one of the hardest things for folks to find services in as well. That's all I had. I've thrown a lot at you today. I really do welcome your questions, your thoughts. If folks want to spitball about what they think the end of Chevron might mean for immigration cases, whether on the relief side, I'm happy to have that discussion with you.
If you have questions, if you want to raise your hand, I have a mic we'll bring around.
Because I haven't looked at it in like at least 10 years. But so is my understanding, and maybe I could be wrong about this, but of course the law hasn't actually, the INA hasn't actually changed, but that the INA gives the Attorney General or whoever authority to issue a detainer if a non-citizen has been arrested for a controlled substance crime, for violating controlled substance crime. And in the actual detainers that ICE issues, it doesn't bother citing to that. It cites to some sort of catch-all provision that says that the Attorney General shall have authority to take other actions that are necessary to carry this stuff out. Detainers are such an integral part of the whole pipeline that I would imagine any court would be pretty reluctant to knock that out. But is that the kind of thing that might merit this sort of post-Chevron?
Yeah, I mean, I think so. And I think you're right to say, right, that courts might be reticent, right? And the couple of cases that have gone up to SCOTUS recently where like the in absentia orders were at issue and the government was basically saying like, if you guys upend this, like we're talking about hundreds of thousands of cases that might have to be reopened, right? So I do think that might be a concern, in terms of getting relief for folks en masse. But I do think if our habeas work is any indication, though, I do think that winning those fights, even on a small scale, 1-to-1 scale, is meaningful because folks are able to take that and apply that then in other scenarios, right? So even if we weren't able to get something that said that every detainer that's ever been issued on that basis is thrown out, if you can consistently, because again, like to go back to the NTA example, right? Like we are able to get NTAs tossed right now. We are able to get cases terminated in some instances, even if that wasn't a mass wave of relief. That is exactly, I think, right, the kind of thing, right, that it's like, we're not going to get 400,000 detainers thrown out. I do think that if you saw a pattern of that with your local office, you could get a bunch, potentially tossed.
I think we do have one Zoom question. Do you see Loper-Bright affecting unpublished BIA cases in a situation where you, as the practitioner, want the immigration judge to take a similar stance as that unpublished case?
I am very curious, and I've candidly put in a FOIA to EOIR to find out what they're telling their people about Loper Bright. But I suspect that not much will change at that tier, because the BIA is simply, if anything, is going to have to tighten up its analysis, knowing that it's going to be subject to a higher level of scrutiny now going forward. But all that to say is that I think in the context of like unpublished decisions, ultimately I think that an IJ, the BIA, or a circuit court looking at that, unless they are already compelled by the reasoning, are going to have a really easy out if they don't like it, to just say, well, it's unpublished, and chuck it. So I think to the extent that anything unpublished sort of invites a level of novelty, right, into the analysis that you think you can make hay out of, yeah. But to the extent that it's going to allow for some kind of new side shot into getting better decisions out of your IJs, probably not, would be my guess.
Okay, so from my understanding, Loper Bright says that decisions that were awarded Chevron deference in the past still have stare decisis precedential power. For the cases that you were talking about today and the matters that you were talking about, how would you go about challenging them under the Loper Bright standard, even if they used Chevron deference in the past for like new facts?
I mean, I think that is one of the harder parts in all of this, is that if you go to the court and say, I don't like the CIMT definition, it's like, okay, but what do we replace it with, right? And I think that's where the bulk of the work is going to have to come for us as a movement, is that if we are going to bring these challenges to the court, we've got to have something better, something, again, more non-citizen friendly, right? And because otherwise, right, if we're just saying it's not good enough, the court's going to do exactly what it did in the 9th and the 4th recently, which is to say it's like, yeah, it is. So all that to say is that I think that coming forward on challenges, number one, on grounds that again, I think the court is going to be willing to have a second look at, and you could say, well, maybe if there was a dissent in the opinion, right, then that might be enough to take a second crack at it. But all that to say is, like, if we've seen anything already, is that absent a very compelling case and absent a very sound substitution for what is already in place, courts are not going to do the work for us of trying to make things better for non-citizens, unfortunately. Oh, yeah, sorry. And then shameless plug for some of my team here, but shameless plug for our upcoming roundtable on November 7th. We've got our mental health training on PSGs, and then our December 5th due process and record issues. And then next year, hopefully I'm not speaking out of turn, but I'm sure that we'll be kicking this back up again, since it was such a huge success for us this year. So anyway, hope to see some of your faces on there. Fill 5 more minutes of time, y'all, so bear with me. I guess one of the things oh, there was a question back there, yeah.
That you work with, the AMICA.
Oh, yes, of course, I'm happy to talk a little bit more about it. AMICA is based in Washington, D.C. We have a Baltimore office as well. It's comprised of 3 teams primarily. So we've got our detained adult program, our team that works with detained youth, and then us, the Impact Lab. But far and away, the largest of that crew is the Detained Adult Program, and we represent folks across the 3rd, 4th, and 11th circuits primarily, and are continuing to push further into the South. Some of the name change actually came about because the CARE name and logo which we're talking about, the capital area, were really no longer reflective of our sort of much more broad scope in terms of our work. So all that to say is that in the lab, we represent folks before the Board of Immigration Appeals on appeal of those cases to the 3rd, 4th, 11th circuits. We write amicus briefs, we develop materials. We have also been doing a lot of work together with other partners here, ACLU, NIP, NLG, around habeas, and getting folks released from Farmville and Caroline, as well as work in Moshannon up in Pennsylvania. We are currently working with folks down in Florida and Georgia and starting to look at addressing detention issues and habeas relief in Florida, in Georgia. So all that to say is that we sort of have our hands at this point throughout a lot of the Southeast, again, trying to make life at least a little bit better for non-citizens in the removal process, in detention, working to get folks out where we can, and again, advance the law in some small ways for everyone if we can.
Can you briefly speak to some of the volunteer opportunities that your group offers, like the hotline?
Yes. So one of the other things, you don't need to be a lawyer if you'd like to volunteer with our organization. We have an amazing group, core group of volunteers who man our hotline, who take calls from detainees. Again, that could be everything from what's going on in the detention center right now, trying to get legal help, to they've been assaulted. Again, all kinds of help opportunities. We have translation requests that come in on a routine basis for cases. So again, please check us out, amigacenter.org. If you'd like to get involved with us, we have internship opportunities as well.
Do you have any cases that you're working on now or a specific area as a result of Looper Bright that you can speak about generally?
I don't think we have anything that I could bring forward right this second. But that being said, I do feel this is top of mind all the time for us, and so we are hoping to find some inroads on this very soon.
Question from the Zoom. What areas do you think will experience the most likelihood of inconsistency?
Inconsistency? I guess I would interpret that sort of like as between the circuits. I think that CIMTs are going to probably still continue to sort of break down along because it is such a sort of societal norms, values question. Is going to continue to sort of break down along geographical divisions on that front. I think that there's probably also going to be a lot of inconsistencies in terms of some of the threshold questions of relief. Again, as we saw, like here in the Fourth Circuit, death threats are a form of past persecution, whereas in other circuits they are not, right? So I think, if anything, Loper Bright is, again, going to probably escalate the level of contradiction across the circuits because everybody's going to get their own interpretation of this for the first time. Thank you all so much. It was great talking to you.
Have a brief break before our next panel at 4 on habeas. Thank you.
There's an extra, your extra Thursday.
Is it? Yeah.
Awesome. Hello, everyone. I realized when I announced lunch earlier, I did not introduce myself, but my name is Nick Kay. I'm editor-in-chief of the Public Interest Law Review, so thank you all for being here today. I'll do a very brief closing remarks after this presentation, but right now I'm very excited to introduce Sophia Gregg. Sophia, I had the privilege of meeting this past spring. I externed with the ACLU of Virginia and got to do a little bit of work with Sophia on immigrants' rights issues there, which was a really fantastic time. It is definitely, I think my biggest takeaway is that it is a real uphill battle in a lot of this litigation, and it can be exhausting and demoralizing. And I have a great deal of respect for you for being able to kind of push on and litigate these issues, even though you're up against really tough odds at times. So to tell you a little bit more about Sophia, as I mentioned, right now she is with the ACLU of Virginia, and she is their senior immigrants' rights attorney, where she litigates for systemic change to promote and defend civil rights and liberties of immigrants in Virginia. Prior to joining ACLU of Virginia, Sophia was a Virginia public defender, I think at the Lynchburg office. Okay, at the Lynchburg office. She taught at the Immigration Law Clinic at the University of Virginia School of Law. And Sophia was also a senior supervising attorney at Legal Aid Justice Center, Immigrants Justice Program. Sophia received her BA from the University of Texas at Austin in 2009 and her JD from Syracuse Law School in 2016. So in this presentation, Sophia will do a better job describing it than I possibly can, but we'll talk a little bit about immigration detention, both in terms of types of detention and sources of statutory or other authority for detention, but then, a kind of a roundup of recent or ongoing litigation, I believe all in federal court, where folks are challenging some of these detention practices and, seeking release. So I'll turn it over to Sophia, and thanks everyone.
Thank you, Nick. Can everyone hear me? Okay, there we go. Yeah, so like Nick said, I'm Sophia. Thank you all. Thank you, University of Richmond, for having us. And we're going to talk a lot about detention and detention litigation. And a lot of it is going to stem from what you've heard earlier in the day, a lot of acronyms that we're going to use. I'll try to clarify. But have to deal a lot with the issues in asylum, claims for relief, and then what happens to folks in detention. Start with, let's see if it works. Next slide, I'll just. So the ACLU of Virginia recently launched our Immigrant Rights Project, focusing on protecting the civil rights and liberties of immigrants here in Virginia. We do advocacy and impact litigation. And this is sort of a new area for us to really focus on. And at the current moment, we're focusing on the issues that people are facing in immigration detention and also in the criminal justice system because of their, immigration status or non-status. So next slide, please. So today's presentation, like Nick kind of went over, is broken down in a few parts, starting with a discussion of an overview of the detention, what the state of detention is, immigration detention across the country and also here in Virginia, and then going into the statutory authorities that are going to really be fully more illustrated on what those rights for people who fall into those detention authorizing statutes in the INA, what those rights entail and how they've kind of been challenged in the federal courts. And then we'll kind of briefly talk about, we'll talk a lot about writs of habeas corpus as like a main vehicle for getting people out of detention after they've been in detention for a prolonged period of time. And then also some of the other considerations for litigation surrounding immigration detention and other considerations that folks might it might be more pertinent to your practice if you're focused more on juvenile issues or juveniles in custody. So next slide, please. So this is the current numbers of the most recent data that's available through track. Syracuse University keeps track of a lot of statistics on immigration detention, immigration courts. They're a good source to understand, the rates of denial, rates of approvals of different types of immigration relief, and also the statistics on the population in detention across the country. A lot of this data is also on ICE's website, so if you're ever curious about, how many people are currently in detention and how many people we are currently detaining in this country, Syracuse Track keeps a report on all of that. But I think, what's obvious to understand is the United States maintains the world's largest immigration detention system, detaining tens of thousands of people in a vast, sprawling network of private prison corporations, county jails, through ICE itself, through U.S. Customs Border Protection, CBP, and also for unaccompanied minors and juveniles under the Office of Refugee Resettlement. It's also pertinent to note that Department of Homeland Security, DHS, spends more on immigration enforcement than all other federal law enforcement agencies combined. So the numbers are staggering in how much we spend to detain people in this country. ICE, for its part, as a sub-agency under DHS, has 200 jails and detention centers that make up its entire system. So it's clear ICE detains adults, and it also detains juveniles. And the only time it detains juveniles are juveniles that have been determined to be accompanied, so they came into the country with their parents, or they have come into the country as an unaccompanied child, meaning without their parents, without any parental support, but that they have then, if they then reunite with their parents in the country, the Immigration Customs Enforcement can redesignate them as accompanied children. And then if ICE wants to detain them, they can detain them in an ICE-controlled facility, which is generally, there's only one in this country, and that's here in Virginia, and we'll talk a little bit about that later, in Winchester. It's the Northwest Regional Juvenile Detention Center. So I guess the other thing to note is that, like on this slide, immigration detention, like the rest of the immigration system, is considered civil, and it is considered civil. I say that because there's not much civility to the system itself. The DHS and ICE detention system is that of a correctional model. So the detention centers are generally former prisons or jails that have been reconverted for the purposes of holding immigrants, or the ICE is contracting with local jails and prisons to hold people for the purposes of civil immigration detention. So the entire landscape of immigration detention is, if not exactly like the criminal justice system, jails, prisons, people who are being held on criminal charges, it is nearly identical. So a lot of issues come up. Next slide, please. So as you might know or might guess, a lot of issues come up in immigration detention. ICE routinely fails to provide adequate oversight of the facilities that they are responsible for. Like I said, a lot of the facilities are run by private prison companies. So 90% of the jails are, 90% of the dedicated detention facilities that ICE has are run and controlled by private prison companies in this country. And they lead to devastating consequences, exacerbated by the fact that in the last slide you showed that people in immigration proceedings and immigration detention are not guaranteed a government-appointed attorney, right? They're not given the right to access to counsel. And many times they do not have access, or they do not have an attorney. So in this year alone, there's been 12 deaths in detention in ICE custody. Reports have found that, you know, of the past, looking at the deaths over the past several years, 90 to 95% of those deaths were preventable. And what does that mean? That means that in a lot of instances that had they provided adequate medical access or adequate medical care for folks, those deaths could have been prevented. What we see when we investigate these types of death, the ACLU and the Physicians for Human Rights, when they investigated the outcome of ICE's investigations, is that they did not take corrective action in many of those cases, such that there would be reprimands or firings or changing of personnel or even do the investigation properly itself, or ensure that there's adherence to the standards that are required for adequate medical care in the facilities that encountered these issues. Similarly, some of you might have seen, there was a big report that ended up in a lot of the newspapers done by the Harvard Immigration or Law Clinic and Physicians for Human Rights that discussed solitary confinement. They did a report about the mass use of solitary confinement and ICE detention, where solitary confinement was used more than 14,000 times in the past 5 years. An average of 27 days was, most people experience an average of 27 days in solitary confinement, that which surpasses the UN standard for torture. Right, so that's very concerning. So when I say it's considered civil and non-punitive, you can understand why that really isn't the case in actuality, in practice with ICE detention. In ICE detention, there's just a lack of due process. Many folks are in detention without access to a bond hearing because they're detained mandatorily, and they are not given a bond hearing, and they just have to wait out the removal proceedings and appeals and all of that without ever having an opportunity to go before a judge and prove that they will not be a flight risk or a danger to the community and follow through with their immigration case on the non-detained docket. Even when they're given the opportunity to present bond hearings for folks who are eligible for them, the lack of uniformity that we discussed in many of the other presentations today is also evident in the bond hearings and what it means to be a flight risk and the factors therein of what it means to be dangerous to the community, right? There's a lack of uniformity at the trial level and also up at the BIA. So, like I already discussed, 90% of people in ICE detention are held in private prison companies. So all of these factors that we talked about, deaths in custody, failures of oversight of ICE, when those go unaddressed, it really allows for these private prison companies to reap a massive profit without impunity, continue their contracts without impunity, or with impunity, excuse me. And there's a real financial incentive here that we can all see in this massive immigration detention scheme. Next slide, please. So why, understanding that we talked a little bit about prosecutorial discretion in the previous presentations, you can see that this chart really demonstrates the difference between the two administrations and the population, characteristics of the population that are in immigration detention, on whom is there because or has criminal convictions. And while, Biden's doing better than Trump in that regard, in terms of the overall population of people who have criminal convictions and those who do not, but are nonetheless detained, nonetheless, 60% or so of people in ICE detention have no criminal record, right? And those who do have a criminal record, many of those are are minor offenses, such as traffic-related offenses, right? Which is a big concern, right? If we're talking about reasons for keeping people detained, and criminality is not an issue for many of those folks, it begs the question, why? Next slide, please. So this is sort of these are for the Caroline and Farmville are the two ICE dedicated facilities here in Virginia. Their maximum populations are, listed there. They're based on the reports from ICE and from practitioners in the field. It seems as though right now the current numbers are that we have just under 650 people, adults in Virginia currently detained. That's a large number just for this small state that only has, is not at the border, doesn't have a high population in itself. But nonetheless, we detain nearly 650 people at any given time. But that is subject to change. We could detain more. We could detain them up to the maximum population. And in many cases, and especially at Farmville, there's been lots of reports and finding that they were overpopulating the detention center itself, leading to very disastrous results, which led to many legal challenges. So the other detention center is not a dedicated facility. It is a contract that ICE has with the local, the Winchester Juvenile Jail. This is their high security facility for juveniles. They have a minimum contract. So that means that ICE pays for 2 beds, regardless of whether there are 2 children there or not. There's no maximum, as far as I'm aware, on how many children can be detained there at any given time. My reporting on this and understanding from other practitioners is that there's anywhere from like 3 to 4 children there right now that we know of. It's much harder to know how many children are being detained there, given privacy rights for children. But they come from all over the country. If this is the only facility that's contracting with ICE to hold juveniles in the interior, you can understand that these children who are there in Winchester are coming from across the country, far-flung from their parents, legal access, any of their general family ties or support systems. Next slide, please. So talking about the I just want to make sure that we're all on the same page. These are the detention authorities that we've talked about in a lot of the presentations, but they kind of go, through how people can be held, and then will, be discussed later in the challenges and how the Supreme Court has considered each and some of these detention authorities and the due process challenges as well. So starting with the first one, these are the folks that are pending a decision on whether they are to be removed or eligible for, or whether they're pending a decision on whether they are to be removed. They are eligible for a bond hearing. So this is the only one of these 4 detention authorities that is bond eligible. So when we talk about mandatory detention and CIMTs and whether someone is detained, generally we're talking about INA 236C. These folks are not eligible for bond hearing, and they will they are required to remain detained on the detained docket while they pursue immigration relief from deportation. Next one is about, oh, sorry, not next slide. INA 235B is the detention of arriving aliens. So folks who are coming into the country and applying, quote unquote, the legal way for asylum or for some sort of humanitarian status, they are not eligible for bond, they are parole eligible, and that is extremely discretionary, a grant to be released. And then the last is folks who are detained after receiving a final order of removal. So this comes into play for anyone who maybe they've lost their case, they've completely lost their case, they applied for asylum, withholding, and protection under the Convention Against Torture, they've lost, they have a final removal order, and they are waiting to be removed to their country of origin. This also comes into play for people who have are seeking, have been, we say, reinstatement cases, so folks who are returning after they've already been deported and they are seeking withholding of removal. They have a previous removal order from their previous deportation, but they are still pursuing the proceedings, making it extra complicated. So they have a removal order, they're also in proceedings, but they are detained under 241A. They are eligible only for what we call post-order custody reviews, or POCRs is the term. And that's just to determine whether or not they should be released, whether they're eligible for release based on dangerousness and flight risk. And that is done by ICE internally with no opportunity for review, other than to ICE headquarters. Next slide, please. So talking about habeas a little bit, and the habeas is a common law writ originally to challenge illegal imprisonment. It's now codified in the US Code. And it's this section here, 2241, is for civil detainees to challenge that individual's continued detention or restraint on individual liberty. Next slide, please. So some folks who practice in this area may be aware of these 4 cases. They're most seminal cases when it comes to immigration, detention, litigation for habeases, and they kind of determine what the court has said about challenges to either to facial challenges to or statutory challenges to the INA itself. So Zedvitas dealt with folks in post-order detention, so they are detained after they have an order for deportation or removal. And what Zedvitas said is essentially that the statute, the INA statute 241, only allow, indefinite detention would raise constitutional concerns. However, 241 basically says that you can only be authorized as detention for a period reasonably necessary to bring about removal. And this is where we get the significant likelihood of removability standard. And then the others they deal with, Denmore v. Kim is a facial challenge to mandatory detention statute for under 1236. That no bond is basically just left open the constitutional challenge to mandatory detention and if it's prolonged. And then Jennings v. Rodriguez, skip the other one, but Jennings v. Rodriguez is an important one to really understand because of how it plays in the Fourth Circuit and how it's understood and interpreted by the courts in the Fourth Circuit. And it said that there's no requirement that you get a bond at every 6 months, but it left open the as applied due process challenge against arbitrary and prolonged and indefinite detention. Next slide, please. So two other cases that I think are important that any law student studying this would, find in their syllabus. I'll go over the Nelson v. Priap. Is basically the Supreme Court discussed the 1226. So 1226C imposes mandatory detention on a non-citizen who's subject to for criminal grounds of removal. And it talks about when they're released from criminal custody. And the court really decided here that when released from criminal custody does not have to be immediate release from criminal custody. So the court said it can be whenever they're released from criminal custody. So if they were released 10 years ago and ICE decides they've been living their life free, they haven't reoffended, and they've been living in this country, but ICE decides they want to go pick them up, that they would be subject to mandatory detention under this statute. But I think, again, there is an argument here that the longer the time between when that person was released from criminal custody to the time that they are challenging their mandatory detention under the statute, it should be a consideration for a constitutional challenge to due process and those factors. Next slide. So looking at how the Fourth Circuit decides some of these Supreme Court cases and then applies them, these are just some of the cases that I thought were particularly pertinent. Portillo v. Hott, we see a lot because a lot of the district court judges in the Eastern District of Virginia is where you bring most of these cases because that's the jurisdiction of both the Farmville and Caroline Detention Center. The right venue there would be the Eastern District of Virginia, Alexandria. It's also the ICE headquarters in Chantilly, which has responsibility over those two detention centers. So we're generally seeing the same 6 judges in Alexandria, and Portillo v. Hott, I think, is a Brinkema case, and Judge Brinkema really set the standard for the 5 factors post-Jennings on what the court should look at when determining whether or not the non-citizen's current detention is reasonable without being afforded a bond hearing. So it's looking at the reasonable limitations on 1226C and also for balancing due process interests at stake in their habeas petition. The 5 factors, I'll just go over them quickly. 1 is a duration of detention, including the anticipated time to completion of the non-citizen's removal proceedings, whether the civil detention exceeds the criminal detention for the underlying offense. The 3rd is the dilatory tactics employed in bad faith by parties or adjudicators, which I think is an important one because, you gotta be on the lookout. And then 4th is a procedural or substantive legal errors that significantly extended the duration of detention. That could be anything, right? We've heard a lot about the issues that, NTAs being filed in the wrong place, a whole host of administrative problems that happen at the immigration court, on appeal for bond, et cetera, all exist in the immigration system. And so those is a very important factor that comes up a lot. And then ultimately, the 5th factor is the likelihood that the government will actually secure a final order of removal, right? Is the government going to win its case? Do you have a successful or likelihood of a successful defense to deportation? Leakey v. Holt is really just, I put it up here just as an illustrative case on detention under 1225B. So this is for folks who are recent arrivals, we call arriving non-citizens, who was held for 24 months without a bond hearing, pending a review of his asylum application. And this is actually very common. I'd like to say that this isn't, but we see this all the time. Less so in Virginia because we're not a border state, right? But this happens a lot in the detention centers at the border where folks who are requesting, you know, prior to circumvention of lawful authorities and all this stuff, but folks who are coming to seek lawful, coming to seek asylum through a legal port of entry are then then can be detained under 1225B, which is a mandatory detention statute, right? So they are mandatorily detained and at the mercy of ICE for parole. So if they don't want to give them parole, they don't get it. But Leakey v. Haught was a very good case, actually, where they said that, you know, where there's no end in sight, you know, like, and they haven't had a bond hearing, that, you know, that clear violation of due process. 4 months in detention without a bond hearing, you know, does not hold muster under due process. And then the last case, this is a case, a recent case, pretty unfortunate case, but a recent case where Mr. Vasquez Castaneda, he still is detained. He's been detained for 4 years. He was in withholding only proceedings. He had his deportation order reinstated. So like I was talking about, folks who have who are detained because they have final removal orders, but they're also in withholding only proceedings. He was one of those types of cases. He was held, you know, pursuant to that detention, the mandatory detention authority under the post order scheme, 1226. But ultimately, the Fourth Circuit found that, you know, Zedvitas couldn't help him because he was in proceedings, and those proceedings were finite, regardless of the fact that they are going on 4 years plus, right? And then, you know, also said that a due process challenge to the statute outside of the statutory challenge under Zedvitas would require exceptional circumstances for which he didn't prove. Whatever those are, whatever that means, yet to be seen. But unfortunately, that's where we are. 4 years in immigration detention, as long as you're in proceedings, even though those proceedings have lasted 4 years, doesn't rise to the level of indefinite or prolonged detention under this detention statute, at least. Deeply troubling, but that is the current state of the law. Next slide, please. So I know I've said a lot, and there's lots of different detention statutes. Well, there's 4, and they all have different case law associated with them. These 3 cases that I cited that are, you know, Fourth Circuit or in the Fourth Circuit and here in Virginia in the district courts, they are definitely not illustrative of all the cases. There's many, many cases out there. Folks like Amicus Center and, you know, now us starting this work in this area. There's a lot of cases that are illustrative of show how the courts are looking at each of these detention statutes and dealing with prolonged detention or excessive periods of time in detention for different folks. Here in Virginia especially. Next slide, please. What am I doing? Okay. So a few other considerations. I know that Dan was talking about, you know, challenges post Looper Bright. So we have been, along with Amica, have been considering what we do with class action litigation following Aleman Gonzalez. So Aleman Gonzalez is a Supreme Court case that came out, 2 years now? 2 years now, that held that a specific statute of the INA that's codified in the code as 1252 F1 precludes lower district courts from entering class-wide injunctive relief that would enjoin or restrain the operations of ICE's detention scheme. it impacts apprehension, detention, and removal authority by ICE. So basically, the Supreme Court prohibited lower courts from issuing class-wide injunctions. This is a major blow to folks who do this type of litigation and are seeing regular issues that come up, whether that be pertinent to just one ICE field office that refuses to, do the right thing, to do what is required under the law, or if we see pervasive, widespread ICE actions or operations that we consider unlawful and we'd like to challenge on a class-wide basis. Essentially, the Supreme Court said operation means also unlawful operation. So you cannot even enjoin unlawful operation. Even if what they're doing is wrong, you still can't issue a class-wide injunction on ICE's apprehension, detention, inspection, removal authority, and anything sort of related to those functions. However, only good news and the bright light at the end tunnel is that the court left open declaratory, class-wide declaratory relief. And there's a lot of debate and, about what this means. Does declaratory relief operate in the same manner as an injunction? Because if a court declares that you're not following the law, government, you would expect that the government then follow the law. But while there are many obstacles there that have yet to present themselves and to see what the logical next step follows, ultimately, it's still available for litigants. So we filed with AMICA and National Immigration Project, Rodriguez Guerra v. Perry. It's a class action here in the Eastern District in Alexandria on behalf of folks who had already won their immigration cases, but were nonetheless continually detained by ICE. So some of them were in withholding or CAT, so they had a final order of removal. Some of them had won asylum, and ICE still detained them for months on end. And it had been detaining almost 100% of all cases after, for folks who had already won their cases for months on end. And so we challenged that and challenged it on the grounds of the Accardi Doctrine under the APA, which basically says, the Accardi, basically says that a government agency is required to follow its own policies. ICE had a policy, a long-standing policy on the books that said they must release people after they win their cases, as you would assume they would, unless there are exceptional circumstances. So all we did is ask for a class-wide, challenge on a class-wide basis that they follow their own rules, right? That case is, we preliminarily settled that case, getting what we needed, including new custody reviews for everyone in this situation. So if ICE is going to keep them detained after their case is dismissed, they need to show exceptional circumstances. They need to give an extra layer of due process in reviewing those cases. And exceptional circumstancing means national security threat and or other considerations that we can, such as like high-level criminality, recent criminality, et cetera. And at the end of this, I've linked our resources for that. We have a big practice advisory for anybody who does detention cases and, is still wondering why their client is in detention, although they won their case. And so I talked about APA as a challenge and Accardi, and Accardi also comes into play when you're dealing with conditions-related cases, because the ICE has its performance-based detention standards, the PBNDS, that need to be followed, and they are regularly not. So if you come across a lot instances working with detained folks and they're not getting the services or the things that they need in detention, and you look at the PBNDS and it says they're supposed to be getting them, this is the vehicle, this may be a vehicle for, challenging those denials and those failures by ICE to do what they're already required to do by their own standards. lastly is Garcia Ramirez, which deals with juveniles in custody who are in ORR custody. They're in either detention or in some sort of custodial setting as unaccompanied minors, and they're kept there and they're at risk for aging out, turning 18, and then ultimately being transferred to the ICE detention. And there's several different factors or several different safeguards that are now in place given the preliminary injunction in that case that apply to ICE. And that injunction is, I believe, 5 years, and it's not even, final yet. The preliminary, or the settlement isn't even final in that case, and it will go on for the next 5 years. So I know that's a lot of information. Let me see. And next slide, please. There is one. So here's some of the resources that I was discussing. I know that Dan put similar resources coming from Amica on there too. Amica does a good job of following every single case out of the Fourth Circuit, out of the district courts that has to do with non-citizens and immigration detention, and also, general PFR, petitions for review, challenges to interpretations of immigration law. In their index of immigration habeas law, they have a lot of issues related to this. And then for folks who have questions about, like, is my client detained under which statutory INA authority is my client detained under? I don't think he should be mandated. He may be. The Virginia crimes chart that they have really lays out, is the Virginia Code crime section, how does it relate to the INA, or how does it relate to a CIMT or what have you? And so that's really good. Like I discussed, our practice advisory. So this has, everything that there is to know about our case, the benefits of it, how to reach us, how to reach class counsel if you have an issue, and all the hot tips there. For practitioners who work with children and are seeing children in custody or at risk of being in detention or in a custodial setting, I always recommend the Young Center for Immigrant Children's Rights. They are the ones who are in those facilities and handling those types of cases, monitoring what's going on, and are going to be the best resources for children in custodial settings by ORR or ICE. So they assign caseworkers here in Virginia to all of our facilities, or all of the facilities, including the ORR facilities here. And then, I was talking about the Ramirez case and age outs for juveniles who are going to turn 18 while in custody. That's the practice advisory for that, on what to know and what are all the safeguards in that case. And then with that, questions?
One question from the Zoom. Can you provide an update regarding efforts to reunite children and families?
Oh, the efforts to reunite children, I believe, so there is a settlement in Miss L v. ICE. If there are any more reunification efforts, I can't say off the top of my head what the timeline is on that settlement with Miss L v. ICE, but I believe that I don't want to speak out of turn, but I would assume that it might have closed by now for people to opt in. So all reunification efforts should have already started or been completed at this point. But that doesn't mean that all children and were reunited with their parents, as we know they were not. Many were never reunited. Many of them will never be reunited with their parents. But I would suggest that folks reach out to the class counsel of Miss L v. ICE, which is also ACLU. But that would be our national office. And if you need me to direct you, you can give me a shout out. Yeah, Nick.
Or, sorry, whoa, that was so loud. For folks with in-person questions, I have a microphone.
Thank you, Ashlyn. I was going to ask, I think it's come up a few times today, but kind of about the Fourth Circuit's attitude towards immigration cases, and I think it's come up in different contexts, like detention here versus defensive asylum. But what the calculus is with some of this litigation, where maybe the Fourth Circuit is somewhat more favorable than other circuits, but thinking about it going up to the Supreme Court and what that thought process looks like for some of this litigation.
Yeah, I think a lot of it depends. Like, I think there's some instances where there might not be such a risk if others bring the case up, because I think, I feel like in some instances, we might already be doing it in the most disadvantaged, the way that's not as advantageous to non-citizens already. So we would encourage a challenge on it if the worst that can happen is already happening. But I think that there's a lot of room for expanding access to due process in the immigration detention arena. And, I think that the case law that we have now, we're always trying to, improve on what there is. I would not be favorable. I don't think it's a good idea really to go to the Supreme Court on detention-related issues, because a lot of these instances, we can see a lot of success, practically speaking, for the individual themselves by just filing at the district court level and getting the process started. The government likewise doesn't have much appetite for fighting and bringing these cases up. So just being a practitioner who's willing to file a habeas case can, in many instances, can lead to your client being released within the first few months without even having to finish the case. Just knowing that there's somebody there challenging the government's detention, prolonged detention of a client, can lead to a success for the individual themselves. And I also think that it's hard to challenge the due process challenge all the way to the Supreme Court, because ultimately, those take a lot of time, many years, and we like to hope that, although we have seen that some folks are in detention for 4 or 5 years, that's not the norm, right? That instituting a habeas petition will moot it out. That's your goal as the practitioner doing these cases, is like filing equals mooting. Like, that's what we want to get to. That's our goal, not fighting every case, because ultimately it's, the best case scenario for the client.
So the Supreme Court said that district courts can't issue injunctions against ICE removal and detention practices. Is there a way, is there an avenue to get an injunction against ICE practices? Like, can the circuit court do that, or how does that happen?
So the Supreme Court can issue, which they did decline to do so in the case that it was before it, but only the Supreme Court, what they say, can issue class-wide injunctive relief. However, the availability of individual injunctive relief is still there. So you still can seek injunctive relief as to apply to the individual, but the reasoning, which convoluted as it is from the Supreme Court, was essentially like, on a class-wide basis, that would enjoin the entire operation of ICE on a particular issue for which F1 statute prohibits in their reasoning of it.
So for your cases against the prisons and against individuals maybe in the prisons, like prison guards, are you utilizing, how do you utilize the law to argue that they're state actors if they're private prisons?
So without going too deep into all the immunity issues with conditions claims, so a lot of, just like as a background, a lot of I'll start from an example here in Virginia. You have Farmville Detention Center. It's run by Avalon LLC. It's a private prison corporation. Formerly, it was ICA, Farmville of America, whatever. They are a private prison group. They have a contract with the county of Prince William, whatever the county is that Farmville sits in, Prince Edwards County. And then the county has a contract with ICE. So this is for the purposes of, you know, I mean, I'm not an expert on this, but I've heard that this is for the purposes of getting around more, well, I won't say that, but yes, so there is a connection there in regards to how they are tangentially related to state actors. And what availability there is in challenging that is really yet to be decided. Well, I don't know. I can't speak to it right at the top of my head, but you know, there is the contracts there. Then on the other side, you have Caroline, which is a contract with Caroline County directly. And so the people who work in the Caroline Detention Center are Caroline County employees. And so there's more of a direct connection there. And, you know, ICE oversees both of those, and they are obligated to the rules of ICE. And ICE is ultimately responsible for their actions as well. Yeah.
Well, everyone, thank you so much for coming today. I'll try to keep it quick here because sure folks have places to go. But first, I want to just thank all of our speakers today so much for being here. Obviously would not be possible without them. I think I was really impressed to see the diversity of different experiences and perspectives, both between the presentations and panels, but even within a single panel. Was really impressive to me today, and I think we were lucky to have such a wide-ranging group of speakers here today. So if we can give a round of applause to just everyone who came to speak today. I also want to thank all of you, our attendees, for coming today. Obviously, it wouldn't be possible without you. I guess it would, but they would be speaking to an empty room. So thank you all for being here. We appreciate your presence. I want to thank very much both of our symposium editors of the Public Interest Law Review, Katie Hall and Adriana Carpenter, as well as our Director of Programming, Emma Wilson. It takes a great deal of time and effort to put together an event like this, and it's something they've been working on over the past 5, 6, however many months now. So, you know, they put a lot of work in, and I'm proud of everything they've done for this event. I also want to thank our volunteers from our journal who were helping out checking people in and running around when they needed to help out with food or anything else. I want to thank Dean Perdue for speaking today. I want to give a very heartfelt thank you to Mary Ruth Keyes, who's the Associate Director of Communications and Events here at the University, or at the School of Law, rather. Mary Ruth has put an incredible amount of effort into helping us with this event. You know, everything from promotion to booking space to pretty much any logistical thing you can imagine, so we're deeply grateful for her. And lastly, I want to give a big shout out to, in the back right corner there, Carl Ham, our multimedia project manager here at the law school. Carl is a pillar for this law school, and likewise was, thank you so much for everything you did for this event, being here throughout the day. So thanks to all, both who were here, who spoke, and who helped out with the event, and I hope everyone has a wonderful evening. Last note, for folks who don't have to take off home from here, we are having an evening reception at Bar West on Grove Avenue. People are going to kind of migrate there right after. If you look at your programs, there is an address for Bar West in there, so hopefully we'll see a few of you there at the reception. Thank you.